like to call this work session of the Southampton Town Board to order on this 31st day, the last day of January 2019. Please rise and join us for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Why don't we remain standing? We'll do a brief moment of silence. As I said at our last meeting when Councilman Schiavone could not be present, that his mother-in-law, Jean Harum, had passed away last week. It was very sad news, and we are all with you, Tommy John, and for Andrea, Judge Schiavone. We deeply feel your loss and want to support you however we can. But let's take a moment in her memory and send our prayers to the family. Okay, thank you.
Thank you. And I want to thank the board and Southampton Town for their remembrance and all your kind words. It's really been truly heartwarming. So thank you. We appreciate it.
The services are this weekend, correct?
In Sag Harbor at St. Andrews at 10 o'clock. St. Andrews Roman Catholic Church on Division Street. And a reception to follow.
Okay, so we are going to start today with a continued conversation about amendments to Chapter 270, rental properties, the rental law. We're joined by Stephen Troyd, our Director of Public Safety and Ordinance Enforcement, and Rich Harris, Assistant Town Attorney, who specializes in this area. And who wants to start here?
I guess I'll start.
Okay, Rich.
Last time Steve put on a presentation and an update of everything going on in code enforcement for the past year and ended off going into some of the proposed changes to our Chapter 270, which is the rental permit law. There were two distinct separate parts of it. One were changes to update the code to more streamline it, make it easier for people to fill it out, to get the permits and to use the online system that we're developing currently. The other part was to implement what is tentatively being called the seasonal rental permit, which will essentially allow for transient rentals during the summer months. There was some discussion of that last week, and it seemed it would be easier at this point now to look at it as two separate entities. So the draft that I had last week and was circulated had both of them combined, the seasonal rental permit and all the parts that go along with it interspersed throughout the code, as well as the streamlining changes. What I've done now for you is cut out the seasonal rental permit portion or anything related to that and prepared a new copy with just the updates to the code.
Okay.
So you will now have two different things that you can look at. I'm going to pass these out. One, two.
So are you no longer proposing the seasonal rental, or we're just not doing it right now? Or we're doing it separately right now? Just doing it
I think they're
separately?
splitting the
I'll leave
two
that
up
to you.
so they can be
Okay, so we're
considered
doing them both
separately.
today?
So we could,
I-
so the streamlining could be voted for without
Yeah.
changes to
We
the
have
term
something
of
in our
rental.
package. These are
All right, so
the
this one.
same.
The one
We're
that you
doing the
have
work
that says
session on
draft
both
in
today.
very
On both,
dark
yeah.
letters there, that's the one that we worked on last week. That includes the seasonal rental permit.
Okay, so you just broke this part, the front part of
Yes.
this out.
So which one did you just give us?
And
The one
I've
that,
given you the one, that one that you have in black. I've given you another copy. It's red line, so it's much easier for you to read,
Okay.
because I know yours are printed out.
so this one is just a streamlining of the process? No, this is, the-
SRP on top of it.
oh, seasonal rental permit.
Seasonal rental permit.
Okay.
Now what I'm going to give you is a copy that excludes the seasonal rental permit. This is just the updates to the code. That's the one that does not.
So the SRP excludes the updates to the code and the, right? Or this
No,
has everything?
That's everything together, right.
Are we gonna have one that just has the SRP?
I was not planning on doing it like that, because the updates to the code, those are the more simple changes that are going to be needed, irrelevant of whether there is a seasonal rental permit put into place.
Shouldn't the seasonal rental permit be its own law, its own public hearing, not tied together with other code changes?
It could be cut out if we want to get to that. My thought was that there's going to be one hearing that comes first. It would be the ones for the updates to the code. Therefore, once those are adopted, assuming they are adopted, then it would be the seasonal rental permit that would incorporate those changes already being there.
But are those changes being promulgated as a result of the desire to do the
No.
seasonal rental permit?
No.
They're standalone changes
Standalone.
that you're putting
Correct.
forward?
And that's why I've prepared one with just those standalone changes.
Okay,
Okay.
and that's,
Did each of you get that one?
I got the SRP.
It hasn't,
This is without the seasonal rental.
I
Without the seasonal rental.
have it.
I didn't get without the seasonal rental. Okay.
So what I'd like to do to streamline our process here is talk about the one that excludes the seasonal rental permit first.
Okay.
That talks just about the actual changes that we are looking to make to the code itself.
Okay.
For that, I'm going to bring Steve in once again,
Okay.
which was part of the presentation that we had last week. I think we've got that up on the screen, too, the proposed rental code changes. This lays it out.
Yes.
Steve?
Okay, so the first proposed rental code change would be that the town code compliance and emergency preparedness administrator, me, or his designee, would be added to the enforcement authority for the law. I believe that because I work closest with the law, I should be the authority that enforces that law.
So then you could write a ticket
So
yourself?
we could write a ticket, or we could suspend the permit.
Okay.
This is also who can issue the permit itself.
Issue it as
All
well.
right, anybody have a question on that piece? Okay, that makes total sense.
That's-
Okay.
Okay, so the second change was definition of family. It's been brought into compliance with what's already in the zoning code. So it would be 1, 2, 3, or 4 persons occupying a dwelling unit, or 5 or more persons occupying a dwelling unit and living together as a traditional family, or the functional equivalent of a traditional family. The change was made to correspond with the zoning code definition.
Okay. Anybody have questions about that?
The zoning code or the building code?
Zoning.
Zoning.
What does building code say?
It's the same.
5 or 4?
1, 2, 3, or 4.
Does it say or 5? The building code?
No, I don't believe it does.
So the New York State Building Code goes up to 4? I'm not trying to
Yes.
trick you, I just don't, I'm not asking.
Yeah, that's a good
The
question.
change we made was to comply with the other codes that we have on the books, which
Right.
is, we have our building code, our zoning code, which comply with the New York State Building Code.
Okay, but the building code doesn't speak to this? Is that, would that
No,
be fair to
no,
say?
I don't believe so.
State Building Code is not, no.
So this basically says, because I know there's been some confusion as to it's 4 or 5 people. You're allowed only 4 unrelated people. You could have 5 unrelated people if they are living as a family.
Yes.
Correct. That's section B.
Which is in other aspects of our zoning code, you're saying?
So, because
Right, because
This is our zoning
so the
code.
confusion
Right.
before is people thought you could have 5 unrelated people not living as a family. Now it's only 4 not living as a family. Right?
It's, now it's going up to
Now you're
5.
bringing it
Five
up.
or more.
Right, that's what the building.
No, if you're not living as a
Zoning.
family, your max is 4.
right.
Correct.
Yes.
Right. I mean, before there was some confusion whether the max was 5 or 4.
But occupancy is
Depending on
still
where you read.
contingent on what the building code requires.
Now we're making it clear it's not 5.
That's
it's
State
4.
Building Code.
That's state
Right,
building code.
which we talked
Which
about
is
the
the
numbers.
superseding.
70
But they're
square
not
feet for the
talking
first
about,
person.
right, they're not talking
Right.
about,
We
But-
found the contradiction when we were enforcing the rental code, and attorneys were approaching us and telling their clients they had 5, and we were saying, no, in the rental code it says 4. And then when we investigated with Kyle downstairs, he said, no, in the zoning code it says 5. So he pointed it out to us, and then we said, well, then we need to conform it so that the rental code and the zoning code are the same.
so it's just a
But-
question of
Because really
conforming
just have
one way or
internal
the other.
consistency with the
Or
code.
changing the zoning code.
So we're
But the
getting,
5 or
you're,
more is the issue for me. I'm not understanding or more. What controls the or more?
It's the living together as a family, the functional equivalent of the family, so it would be
But the
5
size of the
individuals.
dwelling, the bedrooms, all
Well, that would be,
would still be
right.
the overriding.
The New York
yeah, you
State
still have,
Still can't overcrowd.
overcrowding would still be an issue that we would enforce. It's just a matter of, having a kitchen where they eat meals together, not having individually locked bedrooms so that no one has access, the way a family would live. That
so there were 2 conflicting definitions, and
Yes.
you're picking the stricter of the 2, the
No.
4 rather than.
No, we're
No,
going
they're
with the
picking
zoning
one
code,
lenient.
which
It's
has,
gonna go with with our building code, because that's more
More lenient.
overarching for the
Is
whole.
it more lenient or more strict?
More lenient.
I'm confused.
In one, you're
It's
only allowed
making
4,
it
and
clear
one, you're allowed
that
5.
4 is the max, 4 unrelated people,
Right,
not 5 unrelated people.
correct.
And that's what we're picking, 4 unrelated people.
No, you're picking 5.
No, we're not.
Yes, you are.
It's 5 or more
Taking out
persons
4 and
occupying
you're adding,
the
you're
Definition of
making it
family is
5.
five
You're
or
adding.
more.
5 or more persons occupying a
Before
dwelling.
it said 4 or more.
No, here, all right, 1, 2, or 3, or 4 persons occupying a dwelling. So that's sort of the same. Before, we allowed up to 4.
It could be 4, well, no, if it was 4, they had to be living as a traditional family unit, which now it's 5.
You added
or
4
more.
here, and you took
Okay.
away 4
Bring it into
there.
compliance with the zoning code. The
Yes.
zoning code said move it one up.
The zoning
You
code,
can have
It's our
up-
code.
yeah, the zoning code says up to 4 with no
I
issues,
don't have an
but
amendment.
if there's 5 or more, they have to be living as a
No, this is-
traditional
They're
family.
initiating these.
This is just.
We're just correcting
introduce it
a
after the work
inconsistency
session.
between the zoning code and the rental code, is what it
Yes.
is. Right.
Okay.
Yeah, that's it.
Making them
Just so that we don't have a
consistent, that's how
conflict.
I'm
so-
understanding.
They're going to be
Okay.
exactly the same now.
Okay.
Right.
Let's get-
Why wouldn't we do it the
Go.
other way, though?
Because the building code is more overarching, that affects a lot more issues within the town than just the rental code itself.
Okay.
So that comes up a lot more than just in this issue.
Counselor,
Right.
you mean the zoning
makes
code?
sense to go with that.
Right,
I-
and the zoning
I-
code came out of, there's a lot of this.
You said building
This
code.
issue.
Yeah, zoning code.
The zoning code came out of a creature of compliance with a lot of state litigation that's been on this issue for many, many years, so that's how we arrived
Thank you.
upon the zoning numbers.
I think the zoning code would be the overarching one over the rental code. Rental code
Didn't
being-
one say like no more than 4, and the other said up to 4 or something? It was a confusion in terms of the language. Maybe I'm wrong, but I always thought it was 4 unrelated people was okay, and sometimes people would say, no, you're allowed 5 unrelated people. So, under the code.
The zoning code.
No, for the.
Yeah, that's where the confusion came in, because we were telling people 4, and people who were reading the zoning code were saying it's 5. So now we're just going to make it the same, with the
Yeah,
zoning
when this
code being
rental code
the
was
rule.
first-
We're making it 4.
You're making it 5.
Making it 5 or more persons living as a traditional family, instead of 4 or more
When the rental
persons.
code was written back in 2008, a mistake was made. That's what it comes down to, and we're.
So you're correcting an error, making it consistent.
So now 4 people can be living together, but we don't have to show evidence of living as a family, as a traditional equivalent of a family.
Right, but isn't that the way it was, or, I thought it was up to 5, didn't have to show evidence. And now we're making it 4. I'm confused on,
We're making it 5.
You're making
Yeah,
it 5.
it's the opposite. It's about.
it was, I thought it was 5, and now we're making it 4.
The opposite.
No, it was 4, we're making it 5.
5.
That was the inconsistency in the
That's
rule.
subsection B.
You just,
Okay.
you just put in, you're just being
So
consistent.
before,
with the zoning.
before then, it really
Yes.
was up to 3, right? You were allowed 3
You were allowed
persons
3 without
occupying-
any question,
Right.
and then, under the rental code, the old rental code that exists now, you're allowed 3 without any proof of family.
Okay,
And
but
then-
other portions of the code said you were allowed 4.
Yeah.
Yeah.
Then why
4,
would
and then,
Section A
and
in
then
there?
5 or more, you have to show that they're living together
That's-
as a
Sorry.
traditional family.
Section A is how many people that are unrelated can live in occupying a dwelling. Section B is then you can have more people, but you have to have these certain.
As a
certain
family.
items. Right. Living as a family if they're not related.
As a rebuttable presumption.
Right.
Right, so you're basically fixing the conflict in the
Okay.
code. So you were sort of enforcing the 4-person limit.
We were, but then when they brought that zoning code to light, I think we were allowing the zoning code to be the rule
And you were allowing up to 5.
up to 5, as long as they
And
were.
now we're only gonna allow up to 4.
Right.
I wish we had known that like a while ago, but that's like a policy thing, how you're implementing this. If you went to 5, we should have had some
Well, that's what
input
the
on that.
proposal is, that's what you're.
No, I'm
proposing.
talking about the policy. They were implementing that policy before it got here for change.
It just still sounds like, to me, like we're tightening it from one section of code that's allowing 5 unrelated people down to only allowing 4 unrelated people.
Section A,
No, I think.
whereas Section
no, I
B
think-
refers to
Yeah.
families.
I know, but
We're allowing more people to live together unrelated
Than
than
previously.
before. All we
That's
need
the
is
zoning.
proof. Before, if 4 people were living together, we needed the proof that they were living together as a traditional family unit. Now, 4 people can live together. We don't need to prove that they're living as a traditional family unit. And 5 or more persons, we do have to show that there's some traditional or functional.
and that's
equivalent.
consistent with the building code.
Yeah,
No.
the zoning
Zoning
code.
code.
Zoning
Zoning
code.
code.
We can do whatever we want with the zoning
You're
code.
just bringing us in compliance with the zoning code, so the.
Yes.
so
Right.
The code itself, the town code itself is uniform.
It's uniform.
And where you look, where you had a family unit defined as 3 people, where you did not have to verify that, you're moving that to 4.
Four, right.
And then you're saying 5 or more, the definition of what you have to look at, then that's consistent with the zoning code.
Yes.
Okay.
That's,
All right, let's move on to the next thing.
Expands the definition of rental property to include apartments and commercial properties, condos, co-ops, and will not exclude accessory apartments.
So those weren't considered rental properties in the past?
They weren't required to have a rental permit.
They weren't required to have a rental permit, okay. That doesn't make sense. So now, yeah,
Correct, it didn't make sense.
so now basically all residential rental units will be subject to rental permit.
Yes.
Right,
So an apartment over a store didn't need a rental permit.
exactly right. But the
There would
fire
be a-
marshal's office would be inspecting the commercial portion of the building, but if there was an apartment on top of it, that would not require a rental permit, and since it's not a commercial portion of it, it wouldn't be inspected by the fire marshal, so there's a bit of a loophole.
regardless of the zoning, the underlying zoning. So if you're in highway business and you have a business there, but it's not actually operating as a business, but there's still an apartment in a building that sits in that code, that would still require a rental permit.
Yes,
Right.
All right.
under this revision.
Right, so-
Currently, no.
Currently not.
And the underlying idea behind the
We're talking, overriding for the public, we're talking about a proposal here, so.
Right.
Yes.
In the unincorporated areas, this does not include the villages, just to,
Well, there might be some areas we enforce the code, right?
As a, yeah, as
If we have
an
some
agreement.
And when we have an
IMAs.
IMA.
In the village of Sagaponic.
The overarching idea behind the rental permit law, as you all know, is for safety of people that are renting out apartments or houses within the town. The loophole we had was these, let's say these mixed-use properties, we weren't able to get in there. Sometimes these single apartments on top, they're the ones that really need to be inspected.
Sure. Make sure they have good fire escapes and things like
When
that.
you have a restaurant downstairs,
Right.
there can be other issues, so that's why we're able to include that now.
So the accessory apartments are interesting because as of 2019, they're all going to be income-eligible apartments.
All future ones.
Future ones.
So you have 400 that are out there, legal accessory apartments now that probably don't have rental
Which
permits.
we're going to absorb those for purposes of getting rental permits. But applying rental permits to the new ones that are built probably wouldn't make any sense because we won't be inspecting them for safety because they'll have a CFC as being issued new accessory apartment by the building department. So we won't be doing safety inspections, and we don't do safety inspections on renewals, and we don't charge fees for income-eligible apartments. So we would be issuing a rental permit just for the sake of issuing a rental permit. So I think what I'm going to propose when we get to that point is that we don't issue rental permits on the brand-new accessory apartments.
But that was part of the law we just adopted, and that was, I mean, I like the fact that you had that in there, and I assumed that you were doing safety inspections. Why aren't we doing safety inspections?
Because as they become new apartments, they'll be inspected by the building department, and they'll receive a CFC.
Right,
So they will already have their safety inspection, they'll comply with all of
for
it.
2
So
years.
they'll
and
be in
then what?
compliance
And
with-
then at the
2 years.
renewal, would they then get inspected?
We don't, as a matter of business,
That's
we
the
don't
problem.
inspect.
Well, you have the right to if you want to, and they have to submit an affidavit on the renewal that they haven't made any changes. and
Right.
it's still-
We do a paper inspection on the renewals, where they said, like you said, they have an affidavit, and then we make sure that it's, hasn't changed from the original application.
So how does that conflict, how does that
Conform with it.
conform, well, I don't know if that's the right word, conforms with the owner-occupied portion of our rental law, particularly on commercial buildings? Because we have an owner-occupied requirement, correct?
For an accessory apartment, correct?
The
So-
commercial buildings don't have an income requirement, an income eligibility requirement. That would be
Yeah,
one
I see what you're
difference.
saying. So if a commercial building has an apartment upstairs, obviously you don't have the owner living somewhere on the property,
Right.
right? So
But that's not an accessory
it's not
apartment.
accessory, that's.
it's not an
mixed use.
accessory.
It's just a rental permit according to the proposed code change.
Right.
That currently exists, but if someone wanted to add an accessory apartment to a commercial building under our new law, would they be eligible? And if so, would they be required to have that owner occupied? That's a question. I
You
have.
say it'd be a new accessory apartment going
Yeah,
on
with
to
our
a
new
mixed-use
law.
building, not owner-occupied. Or then looking at,
Well, I mean, I
And
personally think the
apartment.
owner occupied thing is a bit complex, and I have some thoughts about that, but I'm just curious as
Well,
to.
yeah, in a commercial
Would we
building, it
require
wouldn't be an
someone-
accessory apartment. It would just
Right.
be an apartment.
Yeah.
So our
Even though it's
rental,
accessory use,
our
it's not
accessory use law
accessory
would not
apartment.
apply to commercial buildings.
Right.
Is that correct?
Right.
Yeah, I
It
believe
really
so.
shouldn't.
No, it shouldn't.
Accessory apartments are
By
for
design, it shouldn't.
residential properties.
It's accessory to the use, but it's not an accessory apartment under our definition.
But if someone,
I get what you're saying.
allowable
See what I'm
I see
saying?
what you're saying, but
So there's
it's
no,
not.
there's no affordability requirement on those.
No.
The market rate hopefully will keep them
The
affordable.
proposed change to
Well,
the
some of them
definition of
are-
rental property includes dwelling units contained within properties used for commercial purposes.
There you go.
That's, that's an addition that I'm proposing. That's going to add in those apartments on top of a restaurant.
that is already used for commercial.
Right, but
In
you
other
won't,
words, not potentially, in other words, it could be an empty building that's zoned
If it's
for
zoned
commercial. You
And
know, that's,
getting back to the safety inspections, landlords are required to have fire alarms and carbon monoxide by New York state law.
State code,
And,
yes.
okay.
But we enforce it, so if someone just promises it's there, we're not,
Yeah, code,
have the
under the
right-
current condition, code is never going to see the inside of the building unless we get permission after the fact.
Right.
Because the building department will issue the CFC, which means that it's complete, the accessory apartment, so we don't need to inspect it then to give them a rental permit. And then, we're not charging a fee, we're not, so it's almost like there's this
it's like
entity.
a home when it gets a CO. We don't,
Yeah.
the building department doesn't go back 10 years later to see
but
if
we
you
don't
still have
ask for
smoke
another
detectors.
permit. If you ask for another permit, they're coming back.
Well, if they,
You ask for
Or
a
they
rental
supply
they
permit.
ask for a
hazards.
renewal, well, I think,
And-
when I was talking to Kyle, he didn't think that the safety inspection would be necessary based on the issuance of the CFC. So I was thinking if we didn't need to do the inspection and we're not charging a fee, do we necessarily need to issue a rental permit if the accessory apartment permit from the building department suffices?
Administratively, I get what you're saying, and that
Right.
makes sense in terms of a streamlined effort, but in terms of policy, I would think we would question the value in perhaps doing the safety on the renewals if you're not doing it on the CFC. It's just a
So it would
question
be
of
a
policy. I get what you're
it
saying.
would be a paper safety inspection, so to speak, because we don't do,
No,
It's
it's,
like,
Yeah.
no.
like check
Renewals?
boxes,
Just like we
and
don't inspect.
then they're
That's a
filing a,
discussion. I
then
don't
they're
know.
filing a
That's a
sworn
discussion.
statement.
That's a discussion.
Right.
That's, I know that's how East Hampton does it. You
Yeah.
File a sworn statement. There's a
I
little,
mean,
there's a
the number
checklist.
of renewals would
You
be
have a
tremendous.
pole alarm, smoke detector.
but how do you
carbon
validate
monoxide.
that over time?
Yeah.
You have to have some
How do
kind
you
of
validate
cycle
over time?
where
Well, you have the right to
verify
inspect.
the affidavit, right? So you wouldn't do that unless you had a complaint currently. But
Right.
If we
there's
get a
really no
complaint,
way
we'll
of knowing
respond to
whether
it.
that
If we have
somebody's
the
walking
affidavit,
through a
turns out it was
loophole there by
falsified,
giving
we'll-
Well,
you.
you're maintaining the right to inspect with, whatever, 24 hours notice.
Well, they would also have the right to give us a certification because we can't force them to allow us into the house.
Right, but in the rental permit, they're giving you the right to inspect with 24 hours notice or something like that, right? Is that in there?
I don't know if that's in there.
No, that's something that I've done in the course of prosecution work.
Okay.
But we would not have unfettered access to properties. If we need to get in there, we can't have an unreasonable search and seizure. In certain circumstances, I'll get a search warrant to go in there if we have probable cause that there is a violation within the property. But once you have your rental permit, you're following the rental permit unless we find out something else.
Okay.
So the
Now,
te-
the other option is to go the other way and inspect every renewal application.
It's
which
a
we
lot
can
of
do,
work.
And that's, will require a lot more manpower.
We also want to get these applications out to provide housing, and having an inspection on each piece of paper, each
Each-
application could be somewhat onerous and intrusive, I
On
think.
each renewal.
And
Especially
at some
since they
point, we have
doubled.
to trust the landlords that they will follow state law, and to provide these safety things. Well,
Maybe as a matter of policy, so.
yes, at some
I
point.
think after 2 years,
And we can.
every 2 years they're getting another permit, but, maybe after 10 years, it's time to re-inspect. Maybe
Or
there is
after
a
number of
schedule.
renewals, that
2
triggers
years
an
is a very
inspection.
short window, but maybe every 10 years, as a matter of policy, you say, okay, you know what? They're filing for a new rental permit, we'd like to see it. It's been 10 years since we were there.
Right.
No, I think 10 years is too long.
Yeah, I do too.
What do you think is the right window?
Realistically, if somebody's going to be a bad actor, they will do that. We've had people get a rental permit, and the next week, they cut the basement up into extra bedrooms.
Yeah.
Right.
And are we going to know that? No, not unless we have a complaint or we have some probable cause to get.
Well, you have the right, every time they renew, you have the right to say, I'd like to inspect this, right?
Yeah.
It's really up to you guys then to
So
say,
you
okay, we'll accept the affidavit, or we'd
schedule
like
that
to see
or
it.
rotate it through.
You know, the town investigator reviews every application, and based on his personal knowledge from investigations, he usually does detect when there's something amiss, and he'll then approach the owner, but we don't have the right to go into their property.
Well, you
It's a
do,
search.
though, when they're renewing their permit, it opens up a door for you, so to speak.
If it's a renewal,
think it's
they will
right.
always have the right, if they want to submit a certified application instead.
Right.
So he's saying no, that we don't have the right to just walk in.
We do in the renewal,
On a
but
renewal,
in the middle of a permit, you're saying it's tough to walk in without a warrant or
I
something.
think, yeah.
You have to have an
On a-
action.
Even on,
Right.
even on a new application, we
Yeah,
give them
yeah, I believe you
the
can
opportunity
on
to give
a-
us certifieds, so that they don't have to allow us into their property.
Okay.
So,
We need some clarification in the law, if you're allowed to require, are we allowed to go in if we want to,
Yeah.
both on the initial and the renewal? Because we're getting,
No, I think you can.
I think I heard.
No,
that
Certification as an
yes.
he's saying the
option,
opposite.
which is probably a good option
The
most
the
times.
reason that we have the certified option is because we cannot require a pre-permit granting inspection. We can't, that's considered a Fourth Amendment violation. We can't force someone to allow us in there. There's been many court cases on this. That's why you have the option of submitting a certified engineer or architect, a certification from either of them saying that you are in compliance with the state building code.
Okay.
Or you have the inspection.
So why couldn't we ask for that with the renewal?
Okay.
Now, we're talking about exposure here. With those documentation, is the town exposed if something, God forbid, bad happens in that premises? And I know, right, as an attorney.
Not something I can really discuss here.
Okay.
So I mean, I think, Christine, what you're saying is,
that's-
on a renewal, you'd have to go back and get another engineer to certify, rather than the homeowner certifying? I'm
Perhaps.
okay with a sworn statement, it's a, it's an enforceable document,
As long as that gives you the right to verify that if you feel
Right.
a need to do that.
we would conduct
Penalty of
investigation,
perjury.
but
Exactly.
you
You
got
have the right.
stonewalled
Got
at the
that
door.
option.
If somebody submits it and then, we are able to prove later on that they submitted a false statement, it's a violation of Penal Law 21045, or filing false instrument in the first degree. So if that is hanging over somebody if they want to do it.
And, you should have the right, every time they renew, every 2 years, to say, look, we'd like to inspect, rather
Or
than
not.
just taking your sworn statement.
But
Or
it
not.
would be the right to inspect or a certified.
Or certified.
Yeah.
That's how the
That's
law-
always
that's
going to
how
be the
the law is
same.
written.
Right.
You'd like to have that option for the certification, because it's from a bureaucratic.
From an administrative
Right.
standpoint, the overhead's really burdensome, I understand that.
But the way
If
we're
you have
doing
this,
now is a renewal, it's just a sworn statement, not necessarily from an architect or
Right.
an engineer, just saying, yes, everything is as it was.
Yes, right, that's what makes sense, to me, makes sense.
Yeah.
Are there laws?
Most people are going to comply with the laws. Most landlords, too, are going to want to have a smoke detector and a carbon monoxide detector, for their
well,
own
and
insurance
also
purposes.
egress, ingress, and all the, the things that happen when extra bedrooms are created, walls are put up, then you have those issues. So, and you wouldn't know about that unless you either received a complaint, and if you got an affidavit stating that it hasn't changed, but it may have, you have to rely on that, but you have the right at that time, at that renewal, to request an inspection of the property. And you can set up a rotating way of doing that within your own department. It doesn't trigger one, but
It could be set up, say, for your renewal, you're going to have two options. We do the inspection or we do
Or
the
do-
certified
or do the
application,
certified.
just like a brand-new application.
Right.
Right now, that's not where we're at. Right now, we're asking for just an affidavit from the owner.
Are
yeah,
there
and
criminal-
I think most owners would take that seriously. You're signing your name, you're exposing yourself to all sorts of litigation should you have
And John, I
falsified that
agree with you on
document.
that point, except for the people who aren't doing the right thing to start. They can sign their name, and do they really care?
Well, I guess it's a matter of percentage of how many people do that, and, this has always been the problem, right? How do we,
Well, we could also think that the people that are going to try to subvert the law, they're not applying for the rental permit anyway.
So we're talking about code
That's-
here. Are there criminal, is there New York State Penal Code for people who cut up their homes and change, essentially falsify documents?
Yes, for the falsification documents, there's filing false in the first degree. There's also the sworn statement of Penal Law 21045. And any violation of Chapter 270 is an unclassified misdemeanor.
Okay, good. Because, I mean, in addition to the people living there, it's our first responders, the people who are going to put air packs on and go into
Right.
a very, hazardous situation, and in a place that's cut up, it's extremely dangerous.
Basements have been cut up and there's walls where they don't know there's walls.
And
Yeah.
And when I apply for search warrants in these cases, that's one of the items that I put before the judge every single time, that first responders can't get in there. And if you have a basement where people are stuffed in there, they're in danger, so are first responders if, God forbid, something happens.
Get trapped.
Okay,
Okay.
let's keep moving.
So the next proposed rental code change would be eliminates the requirement to update tenants' identities.
Can you
Yeah.
just tell me what page you're on?
what
So,
section?
under the
Oh,
current
5,
code,
never mind.
every time you have a new tenant, you're supposed to let the town know? Is that the way it is?
Actually, no, there was a requirement in that, and that was taken out a number of years ago. But
Okay.
we somehow retained the requirement that you need to,
Update that list.
In the
Oh,
actual
okay.
permit, right?
Yeah.
Right.
Yeah,
So
they
you-
never
It's not-
took
it's
it
not
out.
required.
So you didn't have to, you weren't required to tell us who's in there, but you were required to update us?
So this is vestigial.
so there was a code amendment made at some point where only half of it was taken.
We leave that as an option for the owner to give us that information, because it will help us enforce the law if someone's there that's not supposed to be there.
When you have a tenant that becomes a
Okay,
landlord.
but it's not
Right.
required.
When a tenant sublets the apartment, or the house, that can be a problem.
Can you require, here says not to name the people, but the actual number of people who will be living in the house or on the lease?
I don't think that would be a privacy violation in any sense. I think that's
Well, it
something.
would coincide, it
One
would
month it may
coordinate
be
with the
6
bedrooms.
people, and the next month it might be 5 people.
I mean, there could be less people, or, you know, if they believe that their lease says 5 people.
We
and
actually
there's
have that
6
in the
people
code
there.
already.
Oh, you do?
If you're looking at the
Where are you now?
right copy,
What page?
page 7, very top.
We're going to go back, though, right?
A number of
Number-
tenants
number
intended?
5.
Okay.
Oh, you struck,
All right.
where you
That's there
struck.
already.
Great.
Okay. Yep.
Next, wait, did you have that?
Okay, and they have to comply with the maximum occupancy anyway.
Right.
Right.
So even if it changes month to month, it still has to be within the limits of,
And if it's
The square
a
footage.
2-week rental, we probably wouldn't have the information before the people left.
right?
You know. The next one is eliminates requirement for Carter contract. The problem we have with this is we don't know if the owner has canceled the contract after he provides it to us. They do have to comply with the zoning codes.
Can't they self-haul?
Excuse me?
Can't they come to our transfer station?
Well, they can certify that they're self-hauling. I mean, but saying that we don't know if they canceled the contract, I don't know if they cut up the house into 10 more rooms after we left either. So, I mean, we can't.
So there's a law that says you can't have garbage piling up at your property.
Right, we have our property maintenance code, both state and local garbage codes, that's going to apply no matter what anyway. If we have a violation, we're going to cite
Right.
the owner, the tenant, or both, as the case may be.
And then, you know, one of the things is that these changes are to facilitate a web-based application to make the process streamlined so that we can do that online and be more customer-friendly and reduce the number of people that have to come to town hall. And I think it's the future, and we need to be involved in that.
How does this help that? I don't understand.
Well, all these additional documents that have to be submitted makes it difficult to do online applications. You know, it's more attachments, it's more room for error.
I can appreciate
you
that,
know,
but at the
and
same
I think-
time, we're dealing with life, health, and safety and quality of life for surrounding residents also, and for the tenants themselves. I mean, these are
Right.
important issues. I don't.
Well,
for
the
sake of
property,
expediency, I don't
like,
think that's something
I
that should
think
go to the
the
wayside.
property maintenance covers it, so we're not concerned that there's going to be a problem that we can't address.
I think it's a mistake.
Well, people, I mean, there's an affordability issue here too, so that somebody, a renter may choose to be a self-hauler.
Right.
Say, you know what, I'm not gonna hire a company, I'm gonna bring it myself to the town recycling center.
And they can certify that, or the owner can certify that they've gotten a certification or an application.
Well, that's something
I
that we
mean,
can
what we're
make,
trying to
you know,
regulate
in the
here
application
is-
process, just as,
We wanna make sure garbage isn't
Yeah.
piling up, right? That's our goal.
Right,
is to
that's
make
our
sure
goal.
Well,
it's
we
all-
also want to make sure it's not being dumped, too.
True.
Right.
Well, your problem, Steve, is more with the copy of the contract from an application point of view. So
Yes.
maybe we could have a question in there that says that you do have you have an agreement with a Carter,
Or you certify that
Just
you will.
check box, at
Yeah.
least there's something there that
Self-certification.
you can go back, and if you see stuff piling on their property, that you can say, look, you say you had a Carter.
Steve, how many Carter contracts
And if
do we
there's an issue,
receive
then
under
we
this
can.
law?
So not actually ask for a copy of the
I haven't
contract, but
seen
just
any.
make them check a box that they have one.
Yeah.
What did you say?
And then if
I was
it's a
asking,
problem, then
how
we can
many
ask-
Carter contracts have we actually received with applications? I've actually never seen one.
Well, that would explain all the
Usually-
high property maintenance issues that we're having.
No, usually they're signing the affidavit instead. Then
Well-
that's part of the application now.
Well, then maybe we should stick with the requirement for a contract for a Carter.
Are we having a
But
problem
the
with,
requirement is one or the other right now.
Yeah.
are we having a problem with this?
We're not
issues
eliminating
with
the
garbage piling
requirement.
up?
Just for the last work session, they did a presentation, and one of the higher categories was property maintenance issues.
Right, but property maintenance
Property
can be a
maintenance
lot
is
of different
different
things.
than garbage.
It's a very
Okay.
broad spectrum.
Is that a major problem, garbage piling up
I
at
I
Reynolds?
bet it would.
Where?
I'm
And
glad.
if we do,
Not
it's,
that I'm aware of.
it's a property maintenance charge that we hit people with.
But is there a lot of that with the people not, getting their garbage taken?
I mean,
I mean, you
we-
could have a contract that
Not
picks up
with-
once a week, and you could still have,
Not
Right.
with legitimate
Garbage
rentals that
piling.
have permits in
I think
place. It's
it's
very
re-
rare that I have someone out front of them in court where they have a rental permit in place, but they violated this particular regulation. That doesn't happen at all, in fact.
To Councilman Lofstad's point, I mean, I think one of the issues that, like parks, we get a lot of clear household garbage that's being dumped into Parks Department refuse bins and
the
dump
beaches.
sites. I would be a little concerned about that, but in your experience, you're not seeing that as an issue, and it's covered under your property maintenance rules and regulations,
I mean, we
right?
can make
But
it so
if
that
it's
they
hauled
certify
off,
that
you
they have
wouldn't know
either
that.
a contract or.
If it's taken to the
they will
woods, you
Resolve it
wouldn't know that.
themselves.
And we're
How
getting
would
them
you
at the
know?
beaches, at our pavilions.
Yeah, but I
and all
don't know that would change.
If there
the
is garbage
behavior.
that's dumped off-site in a public place, we have a rebuttable presumption within our code that if the garbage has an indication of where it came from or who it is, they're rebuttably guilty of it unless they can prove that somebody else dumped it.
And
We've had a few.
the people who are dumping are not necessarily renters. They're people who own homes who leave on the weekends.
That's
In my
true.
experience, and they're just, they'll go someplace.
They're
Well,
not really
perhaps in
aware of
I've
certain
seen
parts
them
of
do it.
town, Tommy John, but in other parts of town, it's renters. I think it depends on where you live.
I don't know if we can legislate this kind of behavior
Yeah, I'm
in
not
the
sure we
code
can.
this way.
We
Maybe
have-
we can put out some
But as is,
information
too,
to
We have-
people.
Requirements of
But
it.
Or
has it been
police.
I think
successful?
we should
That's my
well,
question.
maybe the fine should be steeper. I don't think we should lessen something because it's not working if it's an issue, if we
I
have
think-
to.
Well, I think they're trying to eliminate redundancy here, so you have some redundancy in how you control this.
This was really to streamline the application itself.
Online, so that we can.
I mean, we can have them
You're not eliminating
certify
the requirement
themselves.
to have a Carter, you just
Right,
trying
you
to.
still need to get your garbage out of the house.
Yeah.
But they are eliminating having a requirement to have a Carter or an affidavit of self-owned.
No,
Provide the
the
contract.
requirement is you can't let your garbage build up. That's the requirement.
That's
How
everyone's
you-
requirement.
Everybody's required to do that, and that's enforceable if their garbage is piling up.
And right
All the
now it's
garbage has to be
enforceable.
contained,
Well,
right?
instead of, yeah. I mean,
and that's
instead of-
enforceable,
I
so
mean, there's almost a presumption that renters are more likely to abuse
you are
this,
not.
and I don't think that's actually
You're
the
not
case.
required to
You know,
have a
somebody's-
Carter. You
No,
are
but as a
required to
renter,
not let garbage pile up.
As a homeowner who's renting out a property, you're making money off of something. I think that you should be held to a higher standard, and you should have,
The landlord, yeah, I thought
make
we
sure
were,
that your
yeah.
garbage is
All right.
getting taken away.
I don't know, the problem is the enforcing of that. That's what I'm,
Well, could we have a checkbox as do you have a
Yeah.
private Carter?
That's what the affidavit is right now, and it's just
Okay.
like what the code says.
Or
I
your
have a
cell
Carter,
phone, so
or-
at least
or
we
it
know-
says, the affidavit that's required now from the owner acknowledges responsibility for refuse removal in a timely and efficient manner. That's either by a Carter or by yourself.
Yeah,
Means
I
you're
mean, I
you're
like
going to
that, because you
comply.
could
So we don't need a copy of the
You could have a
contract,
Carter
we just
that's
need a
scheduled to pick up
certification.
every 2 weeks, and, or
just
even
the
once a week,
statement alone.
and
The
that may
statement
be
alone
not
to allow
enough.
you
Right.
to enforce.
Because that's just accumulating more paper
So you could
documents.
literally have garbage piling up even though you have a carting contract.
Are we, would a compromise here to be a certification from the owner on the application itself that he will comply with the property maintenance code and that all garbage will be picked up in a timely and efficient
I
manner?
think that's
He
okay.
should, so,
Or,
yeah.
mean, they
or
have
at
to.
minimum on a weekly basis?
Well,
I
it
don't know
depends
what
on the
the
rental
what the local
contract, so
carters
if
do.
you have, if you've rented it out yearly to somebody who's only gonna be there in the summer, you have to get the garbage picked up every week. You know, just, you have to make sure that the garbage isn't piling up. I think that's the main thing. There's no garbage all winter, it's only in the summer. And then maybe the frequency isn't once a week, maybe it's twice a week.
I think typically it is with most Carter contracts. I mean, that's what I see for somebody here where I live that does this, and it's the landlord who controls everything. So he sets up the contract, he passes that on to the tenant, and they are responsible, and I agree with anything that puts the responsibility on the landlord more than
I
on the
think what we've
tenant.
come to then is leaving this as is, whereas you have the contract from the Carter or the affidavit from the owner saying you're going to take care of the garbage.
Yeah, but
Leave it as is, that should,
I'm good with that.
one or the other.
that's
And
what
to
everyone-
provide that on the online application, they have
So
to
that
provide
stays.
some kind of attachment, so that would stay.
Thank you.
I'm good with a checkbox saying that those things are being covered. Is this,
I'm okay with that,
I mean,
checkbox.
I,
That's what I would appreciate,
So
because
rather
we're
than-
trying to
Yeah.
streamline.
rather than, you know, the
Rather
owners.
than having to provide
But
the
I
contract.
think that the
is
owner, when they say, I agree to the terms,
Are you
they
thinking
are
we take it
agreeing
back?
to those terms.
They're changing it
At the end of it, they're
Should we
saying,
vote on this or
Just
something?
a
I mean,
suggestion, I'm just.
because we're split on this.
Wordsmithing here.
and
I don't know, let's maybe.
I see the value in having the online applications for landlords. And, you know, this is going to streamline it. Or this, what we are doing, the code changes are going to streamline it. And if we get someone to, you know, check a box and sign that this is happening, garbage removal is happening, that essentially does the same thing.
So let's get back to the intent of this, was to streamline it so that they're not burdened with the overhead of having to produce the contract
Right.
to make that proof. So they have an affidavit, or they check on the box, just what you're saying, that they will take garbage. That's it. It's a pretty simple, straightforward thing in my view.
Does that?
And then you can add, should a copy be requested by code enforcement or whomever, it must be provided. How's that?
Well, but I also would like people to use our recycling centers. I would love it if they sorted their cardboard and their, you know, their paper and plastic and, you know, brought it there themselves. That is better for our waste stream, and, you know, they don't have to hire a carting contract.
Yeah, I don't think
Contractor.
this mandates that. I think,
Okay.
yeah.
Right.
It's in the alternative. It's
But
not-
from a landlord standpoint, I can see where he would like to manage that, and most likely he would, you know, he wouldn't be the self-hauler. He would make sure that his tenants put their refuse in the right place. Carter can haul it. Carter makes requirements on tenants to have garbage at a certain place for pickup. You know, they don't go to door. If you have, you know, 5 apartments or whatever it might be, you gotta have that all in one place.
So
That's their
just, and we can go through the board, but just, so basically the online application would say, how are you dealing with garbage, private card or self-hauler, right?
We could
And-
make
and
that an
then,
option, or
you
we
know,
could have a certification statement.
The town reserves the right to request, if necessary, the contract with the private card, you know?
Okay.
Yeah,
But you're,
do that.
Tommy John, you're
I
okay
think
with that?
certification's
And then
gonna
a
happen
certification at the
either
end
way.
that you're gonna comply with,
And when you're filling it out, by checking this box, I hereby certify that.
you're right.
I would like it to be so simple that someone with an iPhone could file an application for a rental permit and not have, you know, I still see in some people they can't scan and attach documents and becomes difficult, and they would probably bring a paper document to the town hall,
Sure.
which we'd like to eliminate that.
So Tommy, you're okay with that?
Yeah.
John, you're okay? I'm
Yeah.
okay with that.
I understand what we're
Christine, you
talking
want
about
the
and agree, but
contract,
I'm so confused by the back and forth here, that just given the issues that we have currently, have had historically, and I anticipate, you know, go on for some time, anything that relaxes a requirement that has been an issue for us in terms of enforcement and everything is not something I would be looking to do. And I can appreciate that you want to streamline stuff, and I get that, because you don't want it to be a hindrance to people who are doing the right thing. But, you know, in terms of economies of scale or just, you know, balancing it out, the harm that it can cause is so heavily weighted on the one end when it goes wrong, and that very often is what we're legislating from. So anything, however you work out the language, whatever you're doing, if it could be deemed to be less than what we're doing now, I don't think that that's a good idea as a policy for purposes of administration. If it's the same, then that's fine. If it's more, that's fine too. But a lot of wording went back and forth, so however.
We've got your direction. I think what we've gotten to, it's going to remain essentially the same. It'll be set up so it can be filled out online, but it's going to be the same requirement. Certification by the owner that you are going to be responsible for timely and efficient removal of waste whether it's by yourself or by a carter. But it falls
And we
ultimately
reserve
to
the right to see the
landlord.
You have the
contract. if
right
we're-
to demand that, should you want to.
You know,
That's-
Yeah, proof thereof.
I think that this statement can just take out a copy of the contract, can be taken out and just put in exactly how a carter must provide for weekly pickup and all that same stuff. And then should a copy of the contract be requested, it must be supplied and just have them check off the box. So they still know that they have to do what they have to do, and if we want to see a copy of the contract, then it's on them to provide it to us.
Yeah, checkboxes
They're on
are much
notice.
easier than attachments, I think.
Nice.
Yeah, I mean,
I don't know who
Councilwoman
agrees.
Scalera, your point is good, but I also know that this is a really difficult thing to enforce. So trying to separate the enforcement part of it from the rental permit process, you want to streamline that so that it can be done online and it doesn't mean that any requirements are being waived. They still have to have the property in compliance, they still have to meet all the local codes, they still have to do all those things. You just want the process to be able to have that, organize that, and have a better handle on what the statistics are, rental properties, where they are, who they're there, which I think we've suffered probably from that. We don't quite have that all the time, particularly when you want to enforce.
Well,
Am I correct in that?
yes.
Okay.
Clearly, the end game is to make sure garbage isn't piling up. That's what we're trying to do. So you could have a carter, coming once a week, and you still could have garbage piling up, depending upon the intensity of the use of that house. So if they're picking up on Saturday and it's Wednesday and there's bags everywhere, they have to deal with that. And the more I can free up your staff members to be out in the field enforcing
Doing
the code,
code enforcement.
rather than reviewing garbage contracts, carting contracts, to me, that's more enforcement of the code. So I don't want to tie you up with the mundane stuff that isn't actually going to lead to the results. I'd rather free you up to, be even more vigilant in the field to catch these problems. If somebody puts into SOS that there's garbage piling up, they might have a contract with a carter at that address. I want you guys to be able to go over there and write a ticket and get it corrected.
I agree.
Okay. So it's not a question of more or less lenient, it's
That was
really more code
lenient.
enforcement.
No, that was more lenient, it was taken out.
No, they're still required to deal with the
Now
garbage.
they are.
What they're not required to do is, every time they submit for a rental application, they're not required to send in with it their contract with the carter.
As I said, in what we're doing, anything that seeks to relax things that we are already having issues with is not something that I would support. If it just ostensibly stays the same and you just massage the wording.
They're still required to
Well,
have the
that's what I was
contract.
gonna
the purpose of the work session is for us to weigh in on these, to develop a code that works and recommended by both our council and by our director of code enforcement. There are some things that clearly haven't been working, and I agree with the supervisor's point that, to free up code enforcement officers to do code enforcement rather than going through this burdensome process, I think that's what you're saying, that's what I'm hearing from you.
Yes.
Is important to support. So,
And I think a checkbox with that statement takes care of both.
Okay.
In lieu of actually sending in the documents or attaching a contract document.
That option was always there, and so we'll keep it like that.
Right, you have the right, you reserve the right to ask for the contract.
Right.
If they're saying they have a contract, they're acknowledging that we have the right to ask for it. We
Now-
might not ask for it, but we can ask for it.
Yeah, I wrote it down, contract upon demand is a note that I put down for my.
Okay.
Right.
And if there is a property maintenance issue, we will enforce the code on it.
Absolutely.
Is garbage piling up at people's homes or rentals' homes a pervasive problem in the town? I had asked that question earlier. and
It depends what part of the town you're in.
Some areas are.
Some areas
vendors and
tend to
some
have more
areas are
property
not.
maintenance issues that are,
So, buried in there, I'm concerned that, we're talking about rental permits, right? So somebody who owns a home
Right,
could
they
also
can-
have a problem with garbage piling up, and
Right.
they're not required to get a permit, right?
Right.
Right.
Right, so we have to be careful. I don't think there's necessarily that a renter is gonna produce more garbage than a homeowner. They may in some cases, may not.
No, and I'm not saying that. I'm
agree.
saying
Yeah.
that a homeowner is making money off renting this property, and so that they should step
Right.
up.
So when the code enforcement folks say that we had property maintenance issues, a certain number of them, we don't know whether were from properties with rental permits or properties that were owner occupied.
Or we're
It's
for
just a
Steve.
number.
The real utility
I
of
just
having
don't think we can make the
within
assumption.
rental permit law is
No,
that
but
you have
right now-
absentee landlords
Right.
that may not even be aware that they have the property maintenance issue, they could be living in New Jersey. But they filled out the application and say, oh, I have this garbage thing to deal with.
But whether it's a problem, it's a problem in different areas in the town, regardless of who it is. But if we know it's already an existing problem and they're coming to us and asking for permission, a permit from us, we should try and tackle the problem wherever we can. And if this is one way to try and ensure that it's not a problem with these at least, then we should be seeking to do that.
So at
It
least-
sounds like you're going to do that with the words that you're going
The
to change.
wording, so at least they're
do we
making them
have-
sign a certification,
Right.
right? Agreeing to that, whereas a homeowner is never signing that. So when you enforce against somebody with a rental permit, you can go to court and say, look, they signed that they would do this, and now they haven't. That may be, you
The less
you bring the
utility
same
of this
violation
is-
without that.
It's a
Stronger,
it's a
right?
regulation of the rental permit. If you have a continued violation for 14 days or more, that's grounds for revocation of a permit.
Okay.
And do we
So
have a
that
definition?
is the hammer that's included within this.
Do we have a definition of garbage in our code?
Litter, there is a
Property
definition of
maintenance.
litter.
Yeah.
Okay.
And it's a pretty
I
stiff
don't care what it is,
penalty.
I just, we
Yeah.
have it, and it's,
You can summons them every day for the litter that's
Some-
on the
I do
property.
one an hour.
people may not consider some
There's a
things
section
garbage.
within
It's a
261
very
that
good
says
description.
Okay.
Household refuse shall be
Good.
kept in
I'm-
All right,
containers.
let's move on to the next one. So-
Thank you.
Okay.
Number 3.
So we're going to eliminate the
I'm glad we
period of,
didn't try to do this last week.
I keep taking up your time, eliminates the period of proposed occupancy. This is, just one of these things where it really has, they can't be there less than 2 weeks. Sometimes people are applying for rental permits, they don't even know who they've rented to yet.
Right.
So they don't know that information.
It was the
Seven.
number 7 being eliminated on
Seven.
page 7 on page 7.
Maybe there could be some attestation that they understand the minimum rental period under this permit is 2 weeks. I understand that the minimum.
That's an easy fix.
Well, it's within the definition of what a transient rental is, and then it says a transient rental is prohibited under the regulations.
Okay. Either way.
So having that in there just seems,
What about, we're taking out a certification, though, from somebody who's licensed engineer or architect, right?
we are.
I don't know. Looks like you're taking it out.
Oh, no, that's
Number
later
10?
on. That's later.
What page are you on? Seven?
Seven.
Okay.
You're taking, and I know that was, back when that was put in, that was a big deal of being able to have that complied with, and it helped the fire marshal and everybody else certify what was there.
Right now, we're allowing the owner to certify.
That should not have been,
No, it says from a licensed architect, licensed engineer.
that should not be crossed out.
Number 10?
That's
That
pretty
should not be
big.
crossed out.
Okay.
That was a big mistake.
All right. So, disregard?
Disregard.
Thank you.
That-
Good, because I have a check next to that, and,
Thank you.
all right. There, that's an easy one.
Are we okay with
So
the,
then
So that's
where are
on
we
the
now?
initial rental permit, but not on the,
We're on
So
ten-
wait,
on the
7,
extension.
number 10.
We're ahead of that, we're
right?
So then
We're crossed out
eliminates
number
the
three.
period of
Proposed
Right,
occupancy.
right, not on the renewal.
Not on the renewal, but on the initial rental permit, they have to have a certification from a licensed architect or licensed engineer.
That's the certification or the inspection that you need for the initial permit.
Timeout. You
Okay.
said we were on eliminates the period of proposed occupancy, number 3, and then we were directed to 7.7. So are we still in 7.7? Just which part of it? What code amendment here correlates to the proposed occupancy one up on the screen?
7-7.
To be crossed off number 7 on page 7. You look at the same one as me?
I don't know.
Yep.
yeah,
The
that
period of the
single line.
proposed occupancy.
There you go.
Okay. So that's it. So the rest of the changes are coming.
Yes.
Okay,
Right.
Okay.
Okay, so the next, should I move on?
yeah.
Yep.
Eliminates the 4-car limit for rentals between 1 and 6 a.m.
Sorry, back up. What about number 6?
I think the presentation here is not going in order of the code itself, so maybe it would be
okay.
easier just to go with code sections.
Okay, yeah. I
Yeah,
mean-
following the red
So
might be easier.
formerly number 8, listed as number 6, a statement of floor plan depicting the location and size of each conventional bedroom. It's eliminating the need to put in a drawn-out floor plan, but simply stating the location and size of the bedrooms. That's for overcrowding purposes. Steve could attest to it. It's been onerous upon applicants to have to draw out the diagram of the house.
So
Okay, so
basically-
not a certified type floor plan.
So you have to say, like, first
architect.
floor,
Thanks.
there are 3 bedrooms, and these are the sizes,
this is the
second floor,
dimensions.
there's, okay.
So it can be included on the
Doesn't
online
have to be
application as
exactly the
opposed to an
location of
attachment.
each
How
bedroom.
does that impact, or if at all, your ability to enforce?
I think during the inspections, they'll be able to refer to that in the application, so I don't think it'll be a problem with the
Now,
enforcement.
the building plans often will have these things, right? Well, the. if
Well,
you-
they submit a drawing now,
If they have them,
and,
it could be an
you know,
open house though, so they can submit the drawing. And you'd mentioned something that was imperative to keep is the number of tenants and tenants to occupy. When they say, yeah, we have one bedroom, we have 7 tenants, we say, all right, well, there's a problem here, we can catch that just from looking at the application.
But what about because you're saying you would catch it on inspection. We were talking before, you were saying that we're not doing inspections, so,
well, for new rental permits, we would do inspections, and then we would compare the renewal information with the original application.
so this
and
is
see if
only
there
for
are any
renewals?
changes.
This section pertains to renewals?
Well, for anything now, for new applications as well, we would have them just put in writing what the dimensions and the number of bedrooms were.
So it's your first filter to see if the statement of
Right.
occupancy matches the floor plan that
Right.
they're certifying.
And
then you check
it's
that.
removing
It's
this
another point.
extraneous material from the rental application, because the rental applications become this 12-page.
They don't have a.
But if it has a CO, it's
Everybody does
still-
it differently. Some
It's
people-
still in the building department, the plan for this
Sometimes.
property.
An example of how this came to fruition, we had a rental permit in place for a house, got a renewal that came
floor
in,
plans.
and then it suddenly says there's 3 more bedrooms on it than there were 2 years ago. So well, what happened? Turns out they went and built out the basement without any permits.
So, yeah, for you to do your job, you just need to know how many bedrooms and what floors they're on and the sizes of the bedrooms.
Right.
Okay.
And I'm sorry, before we go on to the next one, number 7, which I know it's not crossed out, but you're putting the onus on the homeowner to have a copy of the certificate of occupancy. Isn't that on our GIS and because for me as a homeowner, when I've done stuff at my house, trying to go through all my old files, that's hard, but if we, the town, have access to it, through our GIS, wouldn't that be
Yeah,
easier?
so instead of saying
Well,
a
we
copy
do-
of the
we do in
certificate,
this-
then
as
just
far as a
require,
CO.
you could just require a CO, right?
We do that quite often. If someone needs a CFO, we can pull it up in the GIS system. But if someone's going to be submitting this online, and they just want to put everything in, they need to have a copy of it to put it there. They could request it.
Well, how would they submit it online, the copy of the CO? Why don't you just have a checkbox, do you have a CO? If they don't have a CO, they have to come and get one.
But then you're putting it on them, which you didn't want to do before, to have to go through and look at GIS to make sure that
Oh.
everybody has it.
Okay.
and it's a CO, and then we're making a
Understood.
decision
Yeah, I
if
think
it's
that's
valid or
burdensome.
not.
Got
I have the
it.
one town investigator who renews these things and reviews them.
Is it hard to check if somebody has a CO on the property?
But then he has to
They have
confirm
more
it's
time.
valid.
Each property you'd have to go through individually and,
Sometimes you have to dig through GIS.
So
and
how do
there
they
could
do
be-
that online?
Read.
Okay, so me as the homeowner, the onus would be on me then to, yes, get it, so it's not on our code enforcement to do it.
Is this something they
Yes.
have to physically bring in, or
You're
can they
also, when you're
submit
doing
that online?
Which
it's
it should
valid.
be.
Yeah.
yeah, I think
You're making
they
a
could
judgment
submit it
it's valid.
online.
How can
So
you
they'd have
do
to
that?
scan it? Is it?
Well, how
But I was
are we
trying to-
setting up for the online? Are you going to be able to upload images?
Well, yeah, but I really would like to avoid uploading as much as possible. I'd like to streamline it, whatever we could put in the body of the application, similar to the description of the rooms, the dimensions, number of bedrooms, get away from having attachments, because that's what's gonna make people shy away from doing it that way.
How hard would it be to get a list of every property that has a CO and every property that doesn't have a CO? Can IT just produce a master
But
list
they
and
can
then?
change, when someone's giving you a
See,
CO, they're
COs can be complicated. You could have-
verifying
You
that
could
it's
have one
real.
property with 3 buildings on it, you have 3 COs and pre-existing
Yeah,
COs
it can
before
be-
that, and they change. It's complex, so it
And then
is.
some are pre-1957.
So you get a
It's
pre-existing
grandfathered.
CO.
It's
We may
not
be
as-
disputing the
And what's written on the COs,
So
the
it could be a
use.
complicated issue. That's why to have it here, say, give us the CO, and even the applicant might say, well, either I have it or I don't know what I have. Can you help me?
Well, I know, so in East Hampton, for example, they require you have a CO. If you want a rental permit, you must have a CO. If you don't have a CO, you have to go get a CO. If you have a CO and you've added to it, you have to go get all the structures you've added legalized before you get a rental permit.
Well, that's essentially what this is saying.
Yeah, that's what
If you're going to have a
doing.
complete application, you need to have a CO.
Which assumes that everything on your property right now is as it is in this CO. If we did it, we
That's a
can't
bad assumption
verify.
because it could be old CO and.
But that would be a worse assumption if we were making it,
I think it's
not
the
the
CO that
applicant. That's the
pertains
point,
to that
it's
dwelling.
verifying it.
Yeah.
It's
They
the
give it
CO
to
that
us.
pertains to that dwelling.
Yes.
That's a
right.
different
What's
thing
going
than,
to be used by the renter.
because there may
is
be
the CO for
multiple
that area of
structures
the
on that property.
Now, there are some situations where you'll have a house and it's got the CO, but let's say maybe find a shed way out in the back that doesn't have a CO. I'm not gonna hold up a rental permit for that.
Right, but let's say they added an addition on, and they never closed out the CO. They had a permit for the addition.
That would hold up, you're not gonna get a rental permit.
Then they have to go and get it surveyed and get it in, get
Or
an
get your final
updated
inspection.
CO before.
Right.
I mean, they still have to go through the process, even if it's a pre-1957 home, they still have to go get the CO in order to be in compliance.
I
with the
have a
rental law.
number of cases in court where someone, they rented out without the permit, say, okay, fine, I'll get the permit now, and we see there's no CO, they have to go through the pre-existing CO process before they can get their permit in place.
But on the initial permit, we're inspecting anyway, right? There's just a lot more work on the first time,
Inspecting or getting a certificate.
or
Yeah,
getting a
you're taking away the
certification.
inspection.
Right. Well, we could, right, either a certification or an inspection,
You
one
have to
or
have
the other.
those two options.
How hard it is for us to check if they have a CO? You know, again, in East Hampton, it goes, we go to the
It's an
building
inquiry
department.
on the GIS system, and you have to
You can find it,
hope that.
but not all of
it's
them
been
have it.
uploaded, you know, if, you know.
I think
They don't have
if
access
you
to
would
our
just-
GIS system.
If you would just either weigh in on this or think about it, is there any difference then between me as a homeowner coming to you and asking and submitting to you a CO that I'm saying is the CO to my house and it exists as it did there, and you, on your own, pulling off something from GIS that God knows how old it could be, and what could have transpired in the interim that you don't even know that that CO is current or not, because you're not the homeowner who's submitting that this is current with what's on the ground right now. That's, I think, from a legal standpoint, to me, that's a little bit of an issue.
I think it's better if we look up the CO. It's a little more work, but our records are gonna be the most up to date.
If you have records, if I've changed my house and I didn't get my building permit and I don't have my CO, you're gonna have the old CO, and I'm submitting to you.
Well, there is no new CO.
Right,
that case.
In
that's
order
the
to
point.
clue a homeowner in more efficiently for an application, we say you need to have a CO. If you don't have a CO, you're not going to make that application to begin with.
Right.
Yeah, and you're not
Rather
gonna
than
get
walk
it.
in, the application say, code enforcement, can you pull a CO for me? And then we're spinning our wheels, and it may not even be ready for prime time. I'd rather have the owners on them to bring it forward. And then if they come in and they think it's fine, but if we realize you don't have a CO, you know, then we can help you out. Maybe we can pull one up for you. But to have the initial submission be by the homeowner, it's going to make it easier on both parties, I think.
Right, but how do you do that if you're trying to streamline this process online?
Well, there's-
They can
there's-
email it as, they can click a box, say, yes, I have it, and, you know, please email within 5 days, or whatever.
Wouldn't that be part of the initial inspection process? The inspector has the CO that we have, and it says whatever it says, so that evaluation is going to happen on premises, looking at the document.
Well, that application has a unique identifier, correct? So when the
What?
person, the application, when they're first filed for a rental permit, has a unique identifier on it. It's a unique number. It's not done by the address or name. It's done, you have
A rental permit
numerical
number.
service, right? So at that point, when you ask them for a CO, if you did it by email, it would go into a hopper someplace in your office, and then your guy would have to dig through that, but it's not necessarily linked to that particular, see what I'm saying? I think there's a little bit of streamlining that's required in your office to handle that issue, to bring in an attachment. I'm not sure I understand how you handle those attachments and how they get literally filed with that, for your purposes, not for the rental permit purpose, but for your enforcement purpose. Because I think it is critical to have this floor plan in front of you, and part of what you look up, if that was linked to our GIS system, if there, I don't know if,
It'll have a tax map number.
it will, but how do you, can we put that on
The
GIS?
applications
I
are
don't know.
scanned into GIS currently, so there'll be a copy of.
So you'll have a copy of
Copy of
that.
the application and any attachments.
So on the application, if you had the floor plan attached to that,
Well, we're looking to eliminate the floor.
or the CO,
CO.
yeah, I'm sorry, the CO, I'm just still back at floor plans. Yeah,
Currently, when someone submits a rental permit application, they send a copy of the CO along with it, or they'll.
Okay.
it
Now,
might-
this
what
is
I
not
thought.
something, though, you're proposing to change.
No, we're.
So
Oh,
we could
sorry.
this
We
isn't
have-
even on the
we-
list of
We haven't run
changes.
into
Sorry.
issues with this, and what it's done,
My
it's
fault.
been a good gatekeeper, saying this is the first thing you need. You gotta have a CO for the house before you rent the house out.
Right.
yeah, right.
Pretty
That's what I'd always understood, okay.
Well, and my point was, sometimes I didn't have a copy, so it wasn't that I didn't have a CO, I just couldn't find the copy, so never mind.
You need to get here.
So let's go,
Just go down to your
I get
friendly
point.
building department.
It's buried in
so
the,
let's go back to the list. So eliminates the 4-car limit, is that where we are?
Yeah, let's start there. That's a good.
Eliminates the 4-car limit for rentals between 1 and 6 a.m., which was,
Where's that?
Well, are we going in order now?
Yeah.
According to
Where are we
red?
I think we were going
I
to
thought we were going by
back
red.
on that
Right,
side,
red.
which is actually a law that we passed
No, we're
fairly
doing red.
recently.
We're doing
We're doing,
red.
we're following
going with
this
the red.
now.
So we're on.
Page 7, number 10, we're keeping.
Right.
Right.
And then page, thank you, page 7C, no, sorry, 270-6A, what's going on there?
Oh, remember what I said, that eliminating subsection 10 above was a mistake?
What's a mistake?
It
I
was,
have
not, it was
that.
not a mistake, it was simply recodified in 270-6A.
But we're gonna leave 10, and we're gonna include this also.
Or no, I mean, you
No, I
don't
didn't
need
need 10. I
10.
put it
in
You
the-
have
Yeah,
it-
but you're taking out.
It's
a
rewritten above
certification. Yeah,
in
but
the
it's
clear
not.
paragraph.
No, are they
But it's
taking out a
not.
certification?
That was my
You're taking out
question.
a certification from a licensed architect or licensed engineer
No,
that
it's,
states that the rental
It
property is
is-
fully compliant.
it is there. It says
Where?
provide a certification from a
That
licensed
number 10
architect
is
or licensed
rewritten
engineer.
in,
Certification shall include, but it doesn't say who has to certify it.
No,
It
keep
sells
going.
it.
Licensed architect or
Or
licensed engineer.
Where?
The owner is elected to provide a
Under A.
certification from a licensed architect or a licensed engineer.
Fully compliant.
So it was
Okay.
just stated twice, that was the problem.
Yeah, and that's why I have it checked, because I didn't understand why
I
it was
was,
written
this was
twice.
simply streamlining, there was some surplusage there.
Okay, so we're taking out 10 then?
Take out 10.
Because 270-6A covers it.
Right, hooray, I was right.
So you were right before.
You almost
you
All
got
right,
it.
Rich.
I knew you were wrong about being wrong.
You were wrong that you were wrong.
Once I thought it-
So now you just make it right.
Once I thought it was wrong, but I was mistaken.
But you were right about being right.
All right, so so it's in A.
Yeah, it's there.
Oh,
That has not changed.
70-6. All right.
Moving on.
Because that A was actually referencing back to 270-5B10, you see right in the
Yeah.
So
back.
are we,
Got it.
so do you
Okay.
guys want
I
to
got
go through
rid
it
of references.
off of this with
Okay.
each change? Is
Yeah.
that?
Yeah, that seems to be easier for everybody.
Okay. So the next one,
Let's see, we don't have to-
okay,
Is B.
This is bookkeeping, and then you're removing, no rental permits shall be issued if there are any violations of New York State Uniform Fire Inspection and Building Code and premise
It was unnecessary language because it's already written down that you're going
There's
to
a
comply with
redundancy
the code.
Okay.
Right, but it says here if there's any existing violations.
And
So that means that you're
Well,
not complying with the
What
code,
that
right?
is talking about, what we said before, we will issue a rental permit for the house, even if there may be a violation that's unrelated to that house that's being rented, like, let's say, a shed in the back. That might be a violation of the building code, but it doesn't affect the premises that is being rented out. So we're not gonna hold up a rental permit for that.
You're going to allow a rental permit, well, how are you going to distinguish then between a building code violation like a pool?
What this is doing, the way it's written now, it hamstrings the town from not being able to issue the permit. When we go and inspect, we say, okay, the house is fine, the pool is fine, but you've got that shed over there that, let's say maybe it's 1 foot over the property line. Well, that's not zoning, but let's say the shed should have had a permit, let's say it was built without a permit. Is that going to stop the rental permit from going forward?
Like if they overcleared a little bit somewhere.
Or if you
Well-
have, say, three buildings, 3 houses on a property, you
Right, I
want to
see what
rent
you're
out one of them, but the other one may have an
see
issue
what
with
you're
it.
saying.
So we don't want to hold up the rental of that house, which is going to provide income that could.
So you're
allow you
making,
to fix the other one.
you're basically saying the rental, the property being rented must
Right.
comply with the,
It
New York
gives the enforcement
State
authority more
uniform.
leniency on a
I
case-by-case
thought you're
basis.
not allowed, though, to not, I didn't think you were allowed to look over, if you had a building code issue, New York State building code issue. You had to,
It could be a 3-acre piece of property, and you have another building on the other side of the property.
It doesn't mean you're going to allow it to sit in non-compliance. It just means it's not
Correct.
going to hold up the building permit process, but he still is going to be notified that he's in violation of.
doesn't
the
prevent
code.
them from
Absolutely.
issuing a rental permit.
I think you need to be very specific about the things you're going to, this is very open-ended, and that could be a problem even in its reading, so I would, you do, I'm not the sponsor.
Well, you
It's
could-
whoever's
Will they get a
sponsoring
notice
it.
of
Another-
violation?
Include stuff that said, I think you need to be specific about the kinds of things.
Well, you could say here, instead of crossing it out, say, no rental permit shall be issued if there are any violations of New York State Uniform, rather than at the premises,
We'll say upon,
on the unit,
or you say the unit or the area
The-
that is to
the-
be rented out.
right, the
It's-
unit requesting the rental permit, or whatever, rather than at the premises, just change premises.
It's tough to say, and what this, I saw that this was a restriction upon code enforcement to say, well, look, we'd love to give you the rental permit for the house, but you've got that, that light that's out of compliance on the other end of the property.
Right.
We don't want to hold up a rental permit for that where,
Then put in the specific things that you want to forgive.
That's
or
pretty hard
hold
to
in abeyance.
anticipate.
But I just
Well,
think the easiest way is to
it's
put it
also
back, but
dangerous
take
to
out
have
at
it like
the, in
this.
the, in existence at the premises, just say, in existence at the premises being rented, or.
the
at
particular
the-
building or
at
the
The premises in question, or the structure in
the
question.
rental unit. you could
The
say.
rental unit, yeah.
Is it our policy to write
Well,
notice of violations when we see them?
Is
If
it-
if we're on a premises inspecting for a rental property and we see a light that's not in compliance on the other side of the property, they still need to bring it to compliance.
You're gonna issue notice
Not
of
hold up
violation
the
just like
rental
any other
permit.
property. Yeah.
Well, here's what happens. If they don't bring it up to compliance and then they go into the zoning board of appeals and they will say, well, we had it all inspected with our rental permit, which they really didn't, but they may say that and think it in their head, that it's somehow okay. So it's important to issue the violations or the summonses or whatever when we're inspecting it for the rental permit, and they have to take care of, not to hold up the rental permit, but that they need to bring things in compliance in other parts of the property if we see them.
Yes.
Right.
And that's
try to
a
be
kind of
as
a
clear as
policy
possible,
decision.
clearly.
And
within your
you
department.
may rephrase that to say that if other violations that are not subject to the rental permit are noted on inspection, that you'll be issued a notice of violation, and you need to bring those into compliance. But it's not a quid pro quo. It's the rental permit still is going
Yeah, that
on,
would-
but you still are
So
in
these guys,
violation.
right, currently, under the current code, can't issue the rental permit, even though the violation has nothing to do with
Yeah,
the accessory
but
apartment.
it doesn't let you off
whatever
the
it might be.
hook for.
Doesn't let you
No,
off.
it doesn't let you off the hook,
As
but
long as
it
it's not
allows
a
them
life,
to
health, safety
process the
issue.
rental permit and still go after the other violations that are unrelated.
Like,
So I think you just have to add, instead of in existence at the premises, in existence at the dwelling unit seeking the permit, or something, for which the rental permit pertains.
Is the defined term, we could go with that.
Well, what if it's an accessory apartment? Would that apply to both, where the owner is living? If there was a violation there?
Well, it seems to me that the distinction you're trying to make here is between those things that are public safety, there's safety issues, as opposed to non-compliance issues like shed sizes, lighting, that kind of thing. So
I
you
see.
may in fact be able to develop a list, not a specific list as to the violation, but what's contained in that. These are non-life-threatening, these are not public safety issues, but these are issues that the code says you're non-compliance if you have a shed that's
We can
in the wrong
accomplish
place.
your purposes by going dwelling unit.
Dwelling unit for which the permit is sought. So it's very clear that that's the dwelling unit we're talking about.
See?
This is not.
How does that affect the pool violation?
Well, your opinion is important here, so,
I appreciate
you know,
that, but I mean,
if you're not the sponsor,
But they're- you're
I'm not the
looking for me to
sponsor
agree with
either,
it.
but I want to be,
Who is
I don't know, I want
I've
to,
said-
I'm trying to
Thanks.
find a way
The way you would do
to be
it,
respectful of our code enforcement officer and his needs, and try to balance that with doing
Well, you could say for
something
the
right
dwelling
here.
unit and
No, what you would do is-
appurtenant or accessory structures related to, I don't know.
what you would do pursuant to what John is saying, is that you would say it would have to be compliant with the New York State Building Code, and you wouldn't hold up town code zoning violations. You would hold those in abeyance, because that's what you're going to be talking about when you talk about setbacks and things that are not life and safety. But the building code, you have to make them comply with. That's how you would do it.
Okay.
Yeah, and, things like dark skies compliance and things like that, it is a violation, but you need to get that fixed.
Right.
You might wanna
This
include
is
that.
not a free ride.
Perhaps a time frame to address
Yeah.
other issues.
Is dark skies in the zoning code, Jim, or is that separate statute?
That's zoning.
So then the zoning takes care of it, because that'll be your house, the quality of life issues, the setback issues, the things that you're going to want them to come into compliance with. But for immediate purposes, the New York State Building Code really deals with the health, life, and safety issues, and those are the things where you're not going to be able to overlook those. So that's how you would distinguish that if you
So you
wanted to
maybe
have it.
split it into two?
An example of where this came into play is you have a property with 3 different houses on it. He gets one house finished, ready to go, then he's still doing some work on the other 2. He wants to get the permit for the first house. With this in place the way it is, we can't give him that first rental permit to have an income stream to work on the other houses.
What about if he had to be New York State building compliant, because he's still going to run into an issue, and we can't do that. I mean, because then you're talking about life, health, and safeties, and that's a difficult situation. I can appreciate it,
Unless-
but, you know, unless those houses are kind of like in their almost ready position and there's no building code violations there.
If they're not occupied, and it's not going to be used by the person in the rental permit itself, then I would be fine with that. That's a situation that I'm trying to avoid,
Yeah, I think it's
to
just-
give,
Just to illustrate the point, I don't think that probably happens.
I understand, so,
I've had a few.
I mean, and again, if it's a homeowner, if it's not a rental at all, you know, they could have a CO, they could be occupying it, there still could be violations of the state building code present. We have really nothing, I guess we can write them up for those things, but, so now it's a rental permit for that property. We're holding it, to me, I could see denying it or holding up the permit if that dwelling unit itself doesn't meet the, you know, minimum fire protection standards of the building code.
What I'm saying is, if you have one of these situations like I described, the way this code is written now, the code enforcement is prevented from issuing the rental permit. Even if we see it as completely safe, which is the reason for the rental permit law, we simply can't do it. We have no leniency at all.
Right.
By eliminating that, it gives.
It's a little bit too much discretion. I mean, you can appreciate, I appreciate your point, but you got to appreciate our point, because we get the back end of these things going wrong. And, you know, what do we do in that situation? I get
I
it, but
do
if there's too much
understand.
discretion from our standpoint, it's a very uneasy position for us to be in then, to know that whoever's going to be out there is going to be making a judgment call. Well, we may not agree with that judgment call, so I don't, you know, maybe we need to just think
You
about this
could
a little
make it,
bit
it
more.
may not be issued if there are violations, to give you some discretion.
That gives them full discretion.
Yeah, it gives them discretion.
Is that something you're comfortable with? I'm not, when it comes to the New York State building code?
Well, I
I'm
understand
not.
there, if there's no fire, there's no issues of the building code or the town code on a rental property, why deny the permit? You know,
But that's not what we're talking about. We're talking about there are issues.
but unrelated to the rental property,
Like the town zoning code violation.
elsewhere on a larger property, you're
Right,
saying?
that's what we're saying.
And it might have to be
It doesn't
a,
have to be a larger property, it could be a smaller
I
property.
It might be a
know
clearing
one
thing.
area where, one particular property where there is a house, it's a beautiful house in perfect shape. Over on the other side of it is a shed, it used to be a farm stand, and they're looking to rebuild it, but they don't want to demolish it yet because they want to keep the setbacks in place. So it was appropriate to let them have the rental permit for that house while they're going through the planning process
Yeah,
for that.
that's it, but that's,
For that
that
farm
was
stand.
covered.
And
But
so
we
long as it's
prevented from doing that The
documented.
way this is written.
So long as it's documented, and we know it, and it's in the GIS system, and when the planning board or the zoning board, when they get this information, they know that we've been there, we inspected it, we saw the other structure, and we, you know, indicated that it needs to be brought up to code. And I think
we
we're
would do
good.
that every time.
you could leave it in place and just say, unless it is unrelated to the rental permit.
It is giving code enforcement the discretion that I don't know if you're comfortable with.
I'm just one
You know, or maybe that case could require a sign-off by the head of the department saying, okay.
I think the distinction between building code and zoning
I
code
think that
doesn't
covers it,
work
yeah.
well, because like, there's no life, health, safety in the zoning code, so to
Yeah.
speak. There's no parking on the streets between
Okay.
1 and 6 a.m.
So you wanna-
know, setbacks.
And ultimately, it's, you know, it's not giving you additional discretion. It's, I'm personally trying to be responsive to your needs here in a way that makes sense across the board. If this is a solution that you're happy with, that carries a lot of weight with me. But, you know, from Christine's standpoint, and I agree also, is that on the other side of it is we get these calls from people who feel that they're being treated in a punitive way because there's a small violation of, you know, ground fault detect, well, that's not really a good one, but it's, you know, a dark skies compliant light, you know, that things get held up because of that. I think that somewhat does lie within your discretion. You don't ignore the violation, but you don't hold up the larger,
The lack of shielding on a
You have
light
a
should
solution.
hold up
I think
a
that was
rental
a
permit.
You look like you have a
See what
solution.
I'm at?
yeah, it shouldn't. I agree.
Let's hear,
Say
let's
no
hear
rental
Rich's.
permit, no rental permit shall be issued if there are any violations of the New York State Uniform Fire Prevention and Building Code in existence at the dwelling unit for which the rental permit is sought.
Yeah, definitely.
I'm okay with that.
And that takes out the town of Southampton, which should have been town of Southampton. code.
I like the black and white nature of it, because when, things
You
get,
don't want that discretion.
right, because then people making decisions and
No, and you shouldn't.
there's no
Yeah.
uniformity.
And when there
in
is,
enforcement.
when there is that lack of definition, it's usually a call to us in that regard, you know.
Okay, that
and-
sounds, so you got that? You
Got it.
that down? I'm okay with that. Everybody okay with that? Let's move on. What's the next one? We're going through it in order, so we're
Fees.
fees. So you want us to take out, have the code not say $200 fee, but
Right now, there is a, if you look at subsection B,
set the
it
resident.
is a very complex fee structure, different types of fees. Some are higher than 200, some are lower than 200. It's an administrative burden on the part of code enforcement to try to figure out who has these certain exemptions, and it doesn't make that much of a difference as far as the fees people are paying. Simply just to make a straight-up rental permit fee, and rather than having it $200, it'll be set by town board in the annual resolution of fee setting.
Okay.
This
Makes
I
sense.
like, because this is a large amount of the complaints that I hear, at least, in that regard. I do, yeah, because they get confused, and I think it's a turn-off, they walk away, and then it goes underground. That's what I
Some of the people interpret that to mean they have several fees to pay, and then you'll have a veteran sending an additional $150 on top of a $200 fee, and then it creates an administrative burden where you have to return money.
Can I ask a question? And I don't want to bring back the prior conversation because we ended it pretty good. But do we have anything in here coming up that if somebody is found to have violated even town of Southampton zoning codes, that you have the ability to revoke depending on the nature of it, the rental permit, and you have the ability to deny a permit the next time around, because some of these houses, as we know in court, repeat offenders, we know the names, we know the addresses, everything. But even if they, go into compliance one time, you want to make sure that sticks, and you don't want it to come back.
Maybe
So do we have that ability?
Constitutional problems with that. If you're
No.
imposing a sentence
No, but
basically
we're giving
beyond
them
what the court has imposed.
No, it's not
You're
a,
basically saying that you are
It's not a
now
crime.
denied
There's
a
no right to
right
rent.
that other people
there's no
have.
right to rent.
If a rental permit is
I
revoked,
think there is a right to rent.
it
They
can,
wouldn't be coming to us then.
then it can be appealed to the licensing review board. After that, the appeal from that is to the town board. After that, it's an Article 78 in the Supreme Court.
The denial or the
The
revocation?
revocation
What
of
about a
a permit.
denial if someone is found to have violated this, 3 or 4 times, and we're just done? It's not a right to rent. We're giving you that ability.
Is that a
and
home rule issue?
It is, in a
Do we have that
sense, you are
discretion?
basically taking away somebody's right to rent.
They don't have a right to rent.
They might constitutionally have on real property a right to rent.
Do they have a right to rent?
That's a question, yeah. I
Yeah.
don't know if we have a clear answer to that.
Can a municipality deny a resident or property the ability to earn income through rental?
Where the code permits it.
If the code permits
If
it,
the
If the
code-
I think that's a
permits it,
home
then-
rule issue, and I don't think we have the answer to that, but it's a good
you
question.
might get in a situation where if somebody has paid their fines and whatnot, I mean, it's a real reasonableness of the restriction, I think, that Christine.
Right.
Because the issue,
If you violated
the
it,
issue
you're
that I
fine.
see is that if you have
I don't know.
landlords
It's a
that
good question.
continuously take advantage of this, that you want to have some ability
Sure,
to have a
right, right.
stop, a way to stop that from happening.
Right, if you
It's
have
not like
something
just
that's a
pay myself
reasonable
forward,
time
I'll just pay the fines and just keep
You know, you
doing
might,
it.
if you have
There's also
if you have a
injunctions that
due
could be brought
process
against somebody
provision,
that's
you may be able to do that,
Right.
where they can go in front of a board and argue their case
License.
as to why they shouldn't have been denied that.
Right, like what
think
Rich
we
said
should
about the
put that in
license
there.
review board.
I think we should put it in there.
That we can
That they should have notice.
suspend their ability to have a rental permit.
Yeah, if
period.
you're
Subject
found
to,
guilty
let's
For a
review the
period.
legality under
Sure, but
home
how
rule.
is it-
Is it indefinite?
A revocation or a suspension?
No, you
Right.
deny you deny a permit on the next time if they apply based on that.
Yes.
I mean, that's the one suggestion that I've heard. The other is you could revoke it at any time if the violations are severe and long-term, you'd have to
We have that
separate.
already for the revocation.
Most people do
Well,
the
that
right
was my-
thing,
that
but
was-
we do have
On
ones
particular
that don't.
pieces of property, not on other properties.
Just do some
See,
homework
this is
on
the,
this
this
one,
is the
because
question here. If one
Maybe trampling on,
landowner owns several pieces of property, one was problematic or two. I mean, it's going to be very hard to codify that, what we would be doing. I do believe it's a Fifth Amendment violation. We cannot take property without due process of law, and that would be essentially what we would be doing if they had different properties. So,
Wait, say that again, I'm sorry.
If the landlord had different properties, we might be able to do this on one offending property, but the other properties that they own, I believe it would be problematic
So you would tie it, if you were going to do it, you could tie it to a property.
to a property
They have
rather
to,
than
they
an
have to look
owner.
at, look at the legality.
You gotta look
Either
at-
way.
I'm concerned about the
Under home rule, I think
constitutionality
you-
of that as well.
Me too,
Give
and
her-
if they want to straighten up and fly right, and they promise
You
never
know,
to
we
do
can
it
look
again,
into
they
it. We should look into
actually.
it.
There may be some case law about the reasonableness, the
I
length
think
of the
there's a
restriction.
there's a repeat offender
Yeah.
part of home rule, I thought, but I may be totally wrong, that there's this repeat offender concept where, you know, if somebody who flagrantly disregards the law by just simply paying fines, but continuing to be in noncompliance. And, you know, it's a difficult it's a difficult thing to overcome because of the multiple properties, and I think some of the issues that Tommy John was talking about. But I thought there was that.
You may be-
that towns had that right at some
To
point.
deny the ability to rent the property.
To revoke a permit
talked about
based
doing
on
this.
flagrant and
Yeah.
repetitive
It probably
violations.
depends on the type of permit. So, as a legal question here, you may be able to do it for, you know, a certain period, like a 1-year revocation, and with a due process provision where somebody can come and make their case to a body as to why it was unfairly denied. You might be able to do it, but it's a legal question.
I'll
Yeah,
research
definitely
and
a
see what
legal
options
question.
we have for
I
this.
don't have the answer.
Thank you.
You know, if somebody's a flagrant violator, we do
We
still have
don't
the
want that.
ability to cite them and bring them to court.
But we are not always,
But do we have the ability to
Successful in that.
deny them a renewal of a rental permit? That's a good question, but I think we need to
We've
do
also had a
something.
situation where a permit has been revoked,
I know.
they continue to rent.
But
Yeah.
in practice, I think that most areas know that there are flagrant violators, and some people will email me with a name, and, you know, this is a problem. It's part of this idea of paying your way through an issue. If the fines are too low, you know, what is a fine that is large enough to dissuade someone from continuously violating the rental permit law?
And there's different types of violations, right? So somebody could be violating the public health and safety provisions, somebody could be violating quality of life provisions. And if we're going to take away their right to rent, it probably should be more on the public safety side.
I don't know, if someone's making enough noise that they've been like keeping their neighbor, like it's
Yeah.
brutal if you happen to be, you know, and I'm not talking predominantly about that most of the people are in compliance and they're doing the right things, but
Sure.
it just takes that one bad actor on a block and it's disruptive to the entire area.
I understand what you're saying. I wonder who would be making that call. And to me, that call is not to be made by the legislative branch. That call to deny somebody a right to use their property where the code permits that use, that should go in front of a judge. It's,
Ultimately, it may, I think the original call would be from the chief administrator who issues the permits, and then it would be like the regular process, a denial may go to the zoning board of appeals, and then from there, it might go to the court.
yeah, you see, that, I believe, is completely problematic on our level of government. I mean, if we're going to tell a person that you cannot rent your property for something that you did in other properties, it's a problem. And you understand this. I mean,
No, I
understand-
think
I
it's
don't know
got to
the-
be
I don't know the
anchored to the
question.
property.
Yeah, I don't
It
know the
can't be-
answer.
It's got to be anchored to the property.
I understand what you're
But
saying, I
even
just don't know the
there are
answer.
some serious
That's
constitutional
what they're
questions.
gonna
yeah,
look.
this is,
Look at,
Let's
research it
And,
if you
you
could.
know,
Also work on this.
we
Yeah.
do have issues, and, well, not issues, sometimes we have code enforcement violations, and they go before the court, and the court makes their decision, how
You
they
better be
make their
careful.
decision. Well, I know, well, and each judge is different, and, you know, they're going to interpret the law and the facts as they see them.
I think we need an
I don't-
opinion
Yeah, we
on
need
this.
You know, and we
that-
have to be careful here.
Yes,
Yeah, I
we
agree,
do.
totally agree.
We have a lot of rental properties, some of them, you know,
It could be
People
considered.
rent
part
homes.
of
Most of
the
them are great.
process.
There's no
people will
problem.
rent for the summer, they'll
I
pay,
only know the ones.
No
that-
problem.
people will pay
Yeah.
hundreds of thousands of dollars per month in some
We only know the
cases for
bad
rental
ones.
properties within the town.
No,
And
but
then
let's
and
be-
suddenly, we revoke a permit, they have the loss of that income. Just have to be careful. that
But
we
we're
have
not
to-
talking about those properties.
Yeah,
It could be, though, that could be one of the
No, it's
problems.
You need
not.
to, you
Could
need to
be.
frame this in a very narrow sense.
Exactly.
This is the repeat offender
Right.
who constantly does
That's what we're
this,
talking about.
knows that they're doing it, but takes advantage of a loophole. I
Exactly.
think that's a very narrow set of people, it's a very narrow set of things to look at. It may be legally that we can't do that at all, and the constitutional elements are absolutely, you know, you're absolutely right to consider
I'll
those.
get back to you on this one.
Yeah, if you could,
Time
it's
to-
interesting.
Probably not a
Very
permanent.
complex
Thank you.
issue.
You
Yeah.
might have some
yeah.
type of reasonable ban that could be put in place for.
Because the whole goal here is to allow for affordable rental and accessory apartment use and all these other things. It's important, but to do that in a way that doesn't impact your neighbors, does not violate public health and safety, and you can get your streamline, your application in there, not to drive it underground, because I think the violators that we're talking about are the ones who have been driven underground.
Let's keep going. What are we up to?
Number 2.
A, we did. Number, we haven't even gotten there.
So we were doing,
We did A.
So
We
you-
were at 270-9.
We did P, we did P.
70 dash,
Okay.
oh, and you did have in A, you added an additional $50 upon the third inspection and thereafter, right? You have to keep going back. That's B, 278,
Yes,
B,
catch that.
so,
That's adding in an additional fee of $50, because sometimes we can waste a lot of time and manpower. Someone says, yeah, we're ready for the inspection. They may
Right.
be scheduling just to make me happy, to try to get them, say, I'm trying real hard, I don't know why I failed again. We want people to actually be prepared, rather than having someone come out 3, 4, 5 times.
now do you want to say 50 or do you want to say 25% of the rental permit cost? Because that's gonna, 10 years from now, $50 might not be enough.
Well,
Make
and
that
then
by
we,
resolution.
then-
Yeah, that's a good
Put it
point.
by
yeah,
town board
then we
resolution,
can
that's
change
what
the
Right,
fee
we'll just
structure.
keep it, right now it's
Remember.
$200.50, so it'd be.
The amount to be set by resolution.
Okay,
Yeah.
Just add it in
Thanks.
That-
the reorg meeting.
okay. All right, so now keep going then, so we're at, what, 270-9, D is coming out?
Yeah, well, let's talk about that,
Right.
why?
The reason is that is because you could have a house where you actually have 3 legal bedrooms in the house.
Sure.
That could be used.
In the basement?
Yeah, if you have the proper egress.
Right, if you have the proper egress and
Right.
egress, but we're
So-
not
so
requiring.
The building code is going to.
So it's sort of arbitrary to say no more than 2, if they're legal.
Yeah, because you have to be compliant with the building code to do that in the first
We
place.
have to know that.
Window wells.
And
Yeah.
that would be done with the rental
Egress, they have
permit,
to be
and
right
inspection or
size.
certification. But 2 is a random number that was put in there. I know some houses that have spectacular basements where you could have 3 bedrooms in there.
Well, then I would be more
Ceilings.
comfortable if you put down that you cannot have any more bedroom, you cannot have any more than the allowable bedroom numbers in the basement that are permitted under the New York State Building Code, with proper egress and ingress.
I think that's implied.
Yeah, I think that's implied, yeah.
Now, the bedrooms are
The
predicated
loopholes
on
in our
parking.
code,
Yeah.
nothing's
Rich.
Well,
implied.
you have to
But
comply.
it's under the New York State.
Well, it's the opposite. The parking is predicated on bedrooms.
Yeah, but
You could have 4.
You could say all
Okay.
bedroom basements must meet, the egress requirements. and
Which is-
public-
no, you don't want
That's
to weigh
implied
in
too,
on,
Right.
that's, it's already there, it's already in the
No,
code.
And I don't know, maybe we should have a conversation about how many we should allow in the basement. I don't know. It just seems like a
We're
lot of.
seeing more, particularly as, well, not so much down in Southampton, but other areas have passed pretty strict restrictions on home size and lot size. And you're seeing now more and more basement dwellings to comply with the massing of the house.
People are digging deeper.
People are digging deeper, so,
Unfortunately, though, that's also an area where an overcrowding is an issue. That's largely where it's, not largely, but it is done there a lot. And they put a number of bedrooms in the basement, and it becomes, because it's the least seen, and it can be sealed off the quickest, and it's absolutely the most dangerous. So I don't know. I don't
You
know.
make a good point. We do have those basements that get cut up.
That's what they usually do.
so how can we
It's
address
usually the
this?
So the
first
reason
place.
this is in there right now is have it as a regulation and a reason where you could get a rental permit revoked for having more than 1 bedroom in there. A very simple way to do it. If we go and inspect, we see 3 bedrooms, you're done.
So a house that's on a
I think
hill,
this-
which part of the basement has sliding glass doors, and it's got a large footprint, they could only have 2 bedrooms in there, under our
If you want
current
to rent
code.
it out, yes.
Yeah, see, we're trying to,
But you could have a like a giant house with a full basement, 12-foot ceilings,
That
good
was the reason
fire.
for the elimination of this, because they'd have to comply with the building code anyway. If you have the
It's
if you,
usable space. If they have a CO that allows that use and they meet all the standards.
I just think on
It's sort of
balance with our
arbitrary.
problem areas where this happens, where you don't have these massive houses perhaps, but you have smaller ones, and you do have to apply things town-wide, it just seems that concern about what's going on.
We've never cited anybody for a violation of this regulation. It's always been a building code violation that you put in the bedroom.
That's what I'm saying, I assume that's the overriding.
I mean, all bedrooms
Law.
must meet the fire safety codes, right? We've already said
Of
that.
course, you're right.
Yeah, I mean, everything has to, meet the electrical code, meet the plumbing code, meet there has to. Those
that's
are the
what we're
superseding
expecting for.
things. That's what you're looking for, so.
But they don't in the problem ones, so why make it easier?
Well, I'm not sure what you mean, they don't.
A lot of the problem houses don't necessarily comply with all of that, and we don't catch it, or there's whatever, so
Well-
why make it easier?
I don't know if it does. It doesn't sound like it does, because it doesn't sound like anyone, you've never prosecuted on that basis, correct?
Not.
Yeah.
Yeah,
So
but
maybe-
people
maybe I'm
think
thinking,
that, oh, now
maybe
I can
what's
put
wrong
in
is
5
maybe
bedrooms.
It
what's
does
wrong
seem
is our-
arbitrary.
Maybe our
It's not
code
based
is
on
wrong, the
anything.
superseding code is.
The number's not based
I
on
don't know, I don't know
anything.
what the number,
I don't either.
I mean, you could have said no more than one bedroom. Or
Right.
we could say no basement bedrooms.
and
It
some
it should be
places
the more difficult fix is to fix
Some
it
places
where
say
it should
no
be,
bed-
as a
some places
code.
say no basement.
Yes.
The old superseding code. This is like
It is?
The
this
code
is
will
somebody tried to
dictate
correct a
what's allowed
problem
at.
that was perceived maybe a long time ago within our code, our building code, that they thought, okay, this is the easier way to put this in. It should be put where it belongs. I think this belongs in the superseding
I mean,
code.
if you left it there and, and gave you the ability to go beyond the two if it was appropriate. I don't know.
We can be more restrictive than the New York State Building Code, correct? I know Codes Council has to
I mean, this
sign
It has
off
to
on
be
it.
approved by
There
codes.
can't be
Right.
that
Once they
many
sign off on
houses
it,
that have
okay.
more than 2 basement bedrooms.
Can't you just put no
Compliant?
more bedrooms shall be permitted as based on whatever code applies
The
to
building code.
the number of basements that are allowed? So it's still in there saying that,
You can always expand your number of bedrooms to as much as the house can fit, so long as you have
We
a
also have
septic for
septic
it.
issues too, I
Yeah,
don't I
right.
don't know if you'd want to do any of that.
Well, they have to have a
Yeah.
Not
CO.
getting into that with the rental code. That usually
Well, I
comes up
just-
when somebody tries to legalize a house at our behest, and they'll be in court for a year as they're going through the Department of Health regulations.
And that, to me, is the superseding code of all of that, because those flow rates are established by the number of bedrooms, which is problematic sometimes, because
All right, so what do
it's
we,
not as cut and dry as it
what do we want to
sounds.
do with this
I don't know.
provision? Do we want to leave it in there that you can't have more than 2 basement bedrooms, or?
I don't want to lessen it. I'm more comfortable, since I don't know, I'd rather have it there than not.
Has it been an issue? Has it been?
Basement.
Do we
apart-
have
rooms?
basements
You kidding?
with extra bedrooms in there?
No, I don't mean,
Absolutely.
it's not
Do
an
we have,
issue. I
do we
mean,
have
has it been
properties
an
with
issue
more than 2
impacting the ability to get
bedrooms
a
in the
permit?
basement? That have sought rental
Absolutely,
permits?
but that's never the only issue. It's usually
But
that's.
it's another charge you could be having for leverage, I mean.
And usually there's probably not a rental permit place to begin with.
Yeah, I understand that.
What, Tommy John, do you?
I'd like to take
As
it
far
out.
as-
I don't see the
As far
use,
as enforcement goes.
I don't see the usefulness of it.
So it's a tool
I
for
think
enforcement.
people are cutting up their basements. They are in violation of code, other laws that they can be processed under. So I'd like to strike it
Joan, do you have a?
as it's.
I don't really see where it serves a purpose, to be honest with you, because it's captured in the superseding code. That's my feeling, but I'm not entirely sure. If you could just check with that. If this is captured in the code that overrides their ability to get a CO,
Okay.
then I would.
Christine, you said you'd like to leave it in, and Julie?
I'd like it to have it say, no more bedrooms shall be permitted in the basement of a rental property as stated in whatever code. So at least people say, oh, there is a restriction on basements, and I got to know what I'm doing. I can't just put,
Yeah, and I think we're saying the same thing.
All basement, how about?
I don't know if there
I don't
is.
know what
All
code we're
basement
talking about.
bedrooms must,
The R code.
Oh, sorry.
I think it's a state New York code.
yeah, based on all the things that allow you to have
Something like that.
bedrooms in your basement.
Any
then
bedrooms in the basement must comply with New York State Building Code.
Something like, yes.
I mean, as an example, Rich,
We're
like,
going to anyway, we get somebody for either not having
Yeah,
a.
but
private-
Well, you could
I-
restate that.
Didn't have
I'd
the
like the
building
reference
permits.
in there just because there's a sensitivity to basements.
and the reason I'm a little concerned by that is that in our CPF code, for septics, the 25% expansion, we took out the basement expansion as part of that because it wasn't a change in the footprint. And that's a little concerning to me. So I would really, make sure that it's not abused. It's really based on the flow rates of the septic that's on there. I think that's where it would be found. But it doesn't quite work. And I don't know where that code, if it doesn't exist above this, then I would keep it in. If it does exist, I think we should reference it.
And we don't
Flow is
have any ties
determined
to
by the number of
the
bedrooms,
to the
right?
septic code.
Yeah.
in our
So
rental
But
if
it's
we
not-
increase the bedrooms, we're increasing the flow, which would trigger requirements.
Trigger health
Well,
department.
they already have to comply with the sanitary code,
Right.
mean, if they
That's the
have-
Department of Health, I think is the overriding thing
you
in
know,
that.
and if they have basement bedrooms, they better have a CO for those basement
Right.
bedrooms, so they have been inspected.
Right, and they would
Are
be
safe.
cited for occupying
Accessible.
the basement without a C of O or a CUC for the build-out.
So I could go either way. I understand that, you know, there are some very large homes that could easily have very safe basement bedrooms beyond 2.
I just didn't want to be in a position where if you do have a house that say has 3 bedrooms, everything's perfectly legal too, and they want to rent it out. This is now saying, you know, you can't rent it out now because you have too many bedrooms in your basement. When the house could be
Well,
a
and
light
that
level
may-
code.
You just want to stamp that they're in compliance, that they have a.
It seems a little arbitrary, the 2.
If they meet the
bedroom.
sanitary requirements, they meet the Department of Health rules on that basis, then that's probably okay. But I'm not entirely sure that just because you have a big house, that entitles you to add more bedrooms, because the septic flow may not match that at this point.
Which will trigger.
And I
And
would
it will-
feel better
hopefully
if
it
there
would.
is
You're
a,
gonna
if
get-
there is
you're
a
only gonna get your building
basement
permit signed
bedroom that
off
you
on
guys
if you
actually
get
go and
that.
inspect.
Green
Because
stamp.
that's where you could have
Yeah.
But
problems.
they're not inspecting.
But that could trigger an inspection, say, oh, you know, there's 2 basement bedrooms. We want to make sure it has, you know, the windows are opening, you know,
Proper egress.
what are the ladders, whatever, you know, they have to do to comply. Do you want to take a shot at writing something for that, rather than eliminating completely, but a reference to basement bedrooms, all shall, you know,
Yeah,
you know,
That was supposed to be the easy one.
shall require a
Well, but, you know, you
Inspection.
can understand as far as increasing rentals and increasing nitrogen contribution and violation flow, septic law and flow rates, that's an important issue. So they
Sure.
can't get that. They have a pre-existing permit because it's a pre-existing house. So that septic system is there. But if you add bedrooms, it's what triggers the Department of Health coming back to look at that flow rate to be sure that they're still in compliance. I
try to
don't,
come up with something that,
In order to get your CC from the building department, you're not going to get that until you have the green stamp from the.
right, but if they already have it because it's a rental and they're just adding a bedroom in a basement, is that triggered through the building department? I think so. I think I agree with you on that.
Yes.
I'd just like to
They
see
would.
that. At least reference
It would
that. That's to put people on notice.
it has
a
to
little
be in the
bit.
CO that they have a,
Right,
bedroom
otherwise
in
we're
the
going to cite
basement.
you for occupying buildings.
Yeah, except that I don't know if that then goes back to the Department of Health and says, hey, we've added a bedroom. Is this septic system currently in compliance?
is it over 5?
Yeah, but yeah, and that's where the problem, it's 5. It's
If
5
you have
is the
3 in your
max.
basement, you probably have more than 5 total.
Is it you're allowed 5 or you're allowed 4?
You're allowed 5,
After that, you have a larger sanitary system?
yes.
At 6 or more?
Yeah, I have to
I
go
think
back
it's
and
over
look at the code, I
5,
can't,
yeah.
I'm not
We
gonna,
can check that up, I believe that.
that's a Kyle
General
question.
catch-all with the sub-county health is
That's a Kyle question.
5. If you go more than 5, then there's an extra review and permits.
All right, so Rich, you
Yeah,
wanna try
particularly
to-
if, with our
Try
IA
to work
systems
on
and
that.
capacities, this is a different
So
issue.
rather than completely delete the thing about basement bedrooms, have some language about basement bedrooms.
Because, Jim, the argument for not including the 25% expansion was exactly that reason, whether or not you're gonna.
They must meet
They have
all.
to add it's punitive.
It's
okay,
redundant.
but
They have to meet
add
those
an
things
IA
anyway.
system to meet that flow rate because of
Okay.
added bath, you know. That was it. That was part of the,
Right.
okay.
But it does seem arbitrary to say you can't have more than 2 if they're perfectly safe.
Big houses.
And
as long as they,
and they have sanitary and everything, and have a CO for them.
They're not allowed unless they comply with the state and town codes, and then that
Right,
implies.
if the owner were occupying the
got
building,
that.
they'd be able to use all 3 basement bedrooms, right? But the renter could only use 2 of them. It seems a little arbitrary.
Yeah.
All right, let's continue on.
Next is,
279F.
well, subsection E, that was just to clean up the code so it complies with the definition section. Rather than rental property, it's dwelling unit.
Okay, and then you took out in,
F is
What's
taking
those?
out the 4-car limit on a rental property.
yeah, let's talk about that, so, because that was a recent law that I sponsored, 'Cause I thought it would make it easier for us to identify overcrowding. You know, if you had more than 4 cars at night at the dwelling. So what is the issue with that? And I made it apply only to rental property. So a homeowner, if it's homeowner, there wasn't this limitation, but if you're gonna rent it, no more than 4 cars visible, at least that's the way I saw it, you know? If you had a car in the garage or, you know, if it was screened, but you shouldn't see more than 4 cars on the street at, you know, 4
On the
in the morning.
property at 4.
No, you guys want to eliminate that and go back to just the same rule as the home ownership.
I know the code
One car per
officers like the
bedroom,
idea of seeing the, you know, the actual number of cars there so that they can use that as an indicator that there is overcrowding. Because if you limit it to 4 cars and you have an overcrowded house, we're not going to be able to tell. But we will use the number of cars to determine that there is overcrowding. And then some of the houses that they do inspect with this have 8 to 10 bedrooms. And then, you know, having 4 cars is unrealistic in terms of transporting people to and from the houses. So that, you know, we thought that it would be better if we just stuck with the +1 rule, it's bedrooms +1, and that would give us a more accurate accounting of what goes on at the house. The limitation of 4 cars is actually hiding, or possibly hiding, the overcrowding in the house, in a sense. So if they comply with that rule, but yet they're overcrowded, we wouldn't be able to tell. We use the number of cars to see what's actually going on inside the house.
Okay. I'm okay if you want, if you, yeah, you guys are enforcing the code. If you feel like it would make it easier for you to do your job without that provision. You know, the idea behind that provision was to make it easier to identify overcrowding and cite them without having to get inside the house to determine if it's overcrowded.
Yeah, the idea actually did make a lot of sense, but in practice, it turned out to be better off.
I don't understand that. If you have to get in anyway, why would this hinder your investigation? That's ridiculous.
It's not hindering, it's just if there's going to be, if we see more cars there, it's
Right.
just a very easy indicator that it may be overcrowded.
Right, so isn't that a good thing?
I mean, you'd be able to write just on the more cars, a ticket, versus
Right.
having to wait now to get a warrant to get inside to then write.
Well, if
Like
people are
saying it's not-
concealing the number of cars, or the number of people by having limited number of cars there,
So are you gonna think that there's 4 more cars? I mean, it's an indicator, so I don't understand what you're saying.
well, if there's 4 cars there, if they
Yeah.
comply with that aspect of the law, but they're actually overcrowding the house, we wouldn't be able to tell by the number of cars.
I
Right,
think it
but
would
it
discourage the overcrowding if they,
discourage the over, this
know what I mean?
logic, I'm just not following it at all, I'm sorry.
Yeah, the officers didn't feel that they were able to enforce that. It wasn't helping them to identify the overcrowding. And their reasoning is that the 4 cars conceals the fact of what's actually inside the house.
So if you're getting complaints of overcrowding, but you only see 4 cars, you're not enforcing the code? Is that what you're telling me?
No, we wouldn't have a complaint about overcrowding, yet we see 4 cars. It looks like they're in compliance, but
So if we
they're
don't
not.
see it, it's not there, I'm not.
Well, as part of the investigation, they would use, you know, the overage in cars to determine how many people were there.
Right?
So if there's
so you're saying they
Oh,
have more than 4 cars. they just
over
don't
4
park on the
cars doesn't
property.
necessarily mean it's overcrowded.
It's not an
Correct.
indicator.
Because there's 8 bedrooms,
said
you
it
could
was
have
an
16
indicator.
people.
I'm trying to understand.
I just still think it's unsightly, so, I
don't
mean, maybe it's not
understand it.
overcrowded, maybe it's a big house.
Sometimes
and
looking at big
You could have
houses,
8
ways
cars.
impact
I
property,
don't
too.
want 8 cars at my neighbor's house.
Right, but sometimes they're parking in the back or on other people's properties. I've seen them, people parking.
Yeah, well, if
But that-
if they're
I mean,
parked
if you
and
had a
screened,
party-
Sometimes they're not.
it's,
You're saying that your guys don't see that as an indicator that there's overcrowding? It doesn't really help them in that?
The actual number of cars would promote the idea of that it's overcrowded.
Yeah.
What you said was that you thought it was an indicator of overcrowding. What I heard was that you didn't think it was a helpful thing for enforcement necessarily, but it was an indicia of overcrowding, as it is in every other municipality on the island.
The
extra cars.
extra cars, yes, extra cars is definitely,
So I
But
think-
setting the
I think
limit
what
at
they're saying, they're
4 is-
hiding the overcrowding
Oh,
by
I
complying with this law.
misunderstood. I
They've
thought
only
you
got 3
wanted-
cars, but it's still overcrowded.
But this, just because that is missing wouldn't negate your pursuing something if you got complaints. So it's not hurting to have.
well, if we got complaints, that would be the case. But
Right,
not every overcrowding situation generates complaints.
right, but you wouldn't know it was there then, if you got no complaints and there were no more cars, you wouldn't know it was there anyway, unless there was more garbage. So the point is that having it could only help. Having it doesn't hurt you, so I'm just trying to figure out why you would,
They felt that it didn't help them to actually investigate overcrowding by having the limit on 4, because you could have a house that is overcrowded, there's 4 cars there, or that are visible, and they don't have that indication that there's
So
actually.
when I
But
put the
removing
law
it would have
forward,
no
it wasn't
consequence,
just
right?
about overcrowding.
Under
So
that
I
law.
understand that you could have a 10-bedroom house, right? And if the homeowner's there, they could technically have 11 cars,
Correct.
right? But the rental ought to be, a family, hopefully, and not a share house or grouper house, and you should basically be a requirement. You better carpool to get there, because we don't allow more than 4 cars visible. Now, I realize the law could have been written cleaner in terms of visible. It just says no more than 4 cars. It should be no more than 4 cars visible from the street, something like that. But it was kind of like a.
I would be concerned that
paving over
you're
their backyards.
allowing the law to be broken as long as you're
I
hiding it.
could have unlimited number of cars on my, right, I
No,
don't
it's-
live on.
it's-
there's
We were
any
really-
It's a
street.
community
Makes no sense
character.
to me.
Like, if they
Community
were saying, oh, we only had
character
4,
element.
so we're in compliance, were they trying to use that as a defense? That they
I
only
think
had
that they're just not feeling they're picking up the
I've had
overcrowding.
some attorneys speak to me, saying, my client has a 4-bedroom house. You should
But if
put
the
5
intent
cars
was,
there.
if the
But
intent was
they're-
aesthetic,
but they can't
that's
because
different
it's
than.
renting.
No, it
his-
has
his
2
concern.
intentions. One is community character thing. You don't want to drive around. Maybe they could legally, if you take this out, have 8 cars at a small property. It just looks terrible.
So what do we do for houses that have more than 4 bedrooms or 5 bedrooms?
Well,
And they want to rent
They're
them?
not in
If they're
this.
currently, if they're rented, they're still not allowed to have more than 4 cars. If
Well,
you
then
take this out,
that's an
they won't
unfair
be
res-
able to have,
Then that's an unfair restriction, I believe, on their property if you have 6 bedrooms, but you're only allowing them 4 cars.
Well, they're allowed a
I mean,
bedroom plus 1.
I bought, it's East
That's what
Hampton
we
has
would like
this
to
law in
do.
place.
Well,
Right.
they're
Remember,
allowed-
if The homeowner has the house, he might still use his garage for his cars. or
I'm
keep
sorry,
his car
if
there.
it's rented. If it's
Only
rented.
for rental. It's a restriction that goes.
So
with the
tenants
rental.
have different, under the existing law, would have different rights than owners.
Yes.
That's problematic, I think. If they rent and they pay, I don't know, whatever, $1,000 for
Well,
7
we're
bedrooms.
discussing this law, but I want
You
to
know,
understand the
it is,
reason.
it is,
We're kind of,
Yeah, well, this is part of it, and, the tenants then only get 4 cars. So what do? Park at the train station and carpool?
yeah. I mean, that's the law that's on the books. East Hampton has the same law on the books. I understand your point completely, that you have a different set of standards for renters than you do homeowners. Whether that, you can do that or not, I don't know. It's the first time somebody
do.
brought it up. So, I just felt if you want the ability to rent and, live by this restriction, no more than 4. But you could have different thresholds. If there's a 7-bedroom house, maybe 4 is too restricted. 8-bedroom house,
well, what I'm hearing is from code enforcement is that the restriction on cars is not.
It's not helping
useful.
them identify overcrowding issues.
So then that would make the law only in this way, an aesthetic law, rather than actually helping with code enforcement.
Well, they
Am
said
I
it's
correct
an
in that?
indicia, it's just not enforced an issue. They
Yeah,
said it's
I-
an
I'm
indicia
just
of
trying
what
to-
is- Yeah, I am too. They said it was an indicia. I know that it is. I prosecuted these cases.
Right.
So, I mean, let's not,
could you say no more than 4 cars visible from the street?
I mean, could we say no more than 1 car per bedroom?
No
And take
more than 1 car
take
per
away the
bedroom.
plus 1?
Visible from the street.
I think we got to that point of the conversation, it just seemed easier to have it just comply with the rest of the
All
code.
right, I don't have a strong objection to taking it
Just one.
out, as long as you guys are enforcing the, overcrowding. But
Well, I kind of like the
think-
1 car per bedroom, that part makes it, I feel like I'm not understanding something here. I'm missing something.
A question. Homes are required to have ample parking based on the amount of bedrooms, right, per code?
Right, you're not allowed to park on the
Well,
lawn.
hopefully
Right, you can't park on the
Well, but if
lawn,
you pave
and
over
we
the
really want them
lawn-
off the street. We want the cars to be,
Well,
look
you're
nice and
supposed to
appropriate.
provide adequate parking.
Because this is a quality of life issue, and
Right.
I understand what is, sometimes, I remember the days at the share houses where the cars are all over the place, and, we certainly don't want to go back there. But I would support a 1 car per bedroom rule. I mean, is that
Would you want that to apply to everyone or just the rental properties?
the rental properties?
Okay, one car per bedroom, rather than plus one for the homeowner. The renters would be one car per bedroom, period. So it's one less car,
Then homeowners.
right? Oh, I'm okay with that too.
That actually, you can compare the number of bedrooms with the number of cars you see, and that'll give you an indication.
That would be useful to your
I think so.
enforcement.
Because you can verify in GIS that there's a 5-bedroom house and you see 7 cars, and you know there's possible overcrowding issue, and
But the landlord is required to provide adequate parking for those tenants. And
I would believe so, but if you have a house that's had additional bedrooms put in the basement, for instance, and
Then we
the
would know.
original parking plan is different,
Then you would see it
you know?
in this case, because the adequate parking should have been provided if they'd added extra bedrooms, and that's where people start parking on lawns or on verges or,
And that would all be included in the site plan when they have their original permit.
If there
Apply
was
to
such
their
a thing, you
original.
got some houses that are, it might be a pre-57, they get a pre-existing CO. And in fact, a lot of the COs just simply say house.
yeah, they're not
I
very
still think aesthetically,
That's
there
trying.
ought to be a limit. If you had a 7-bedroom house, do you really want 7 cars visible? You look like a used car lot. I don't know. Put some in the garage or
I know,
something.
and they could tactfully, they have the driveways with the little
throw
areas where people
camouflage
can
netting
park.
over them.
Put some,
I don't
put some landscaping
understand the
up,
why.
you
Yes.
know? Do
Yeah.
something.
And they generally do.
Maybe 4 is too restrictive.
Well, what
Maybe
about
no
those-
more than 6 visible from the street.
Those properties who can't afford to put landscaping, they're just parking on the front yard on dirt or laying down some cement, and
Well, but if
I
they're
don't know.
renting, they're in business.
And we'll cite the
Right.
property owners or the tenants in that situation where they park their cars on the front lawn. I've got 3 of those in court right now.
Right, you can't park on the lawn, but you can park as many cars in the driveway as you have bedrooms plus 1.
what's a driveway?
You also can't park on the street overnight either.
Right. So what are we doing with this one?
I'm going to rewrite it to put wording that'll be 1 car per bedroom.
Okay.
Agreed?
And the bedrooms are restricted based on the size of the property.
Based on New York State Building
And
Code,
New
based
York State
Yes.
Building Code,
and the health
Health
department.
Department.
Okay.
That's parked. If it's in the garage, we're not counting.
Well, because they turn the
outdoors,
garage into an accessory
Yeah.
apartment.
Parked outside at the
Now
top.
you get.
Okay, let's keep going. Because we don't, if you're garage, we don't have that rule, 1 car per bedroom now plus 1. You have 5-bedroom house, but you got a 10-bay garage because you're a car collector. We don't say you can't do that. As long as we don't see it, it's not an
Right,
issue.
right. Next, go in order 270-12, revocation of permit. Right now, the code requires a continuing
I'm sorry, what page
violation.
are you
I'm
on?
not seeing a
10.
change in this.
Page 10, 270-12. In order to revoke a permit, there needs to be continuing violation of any section of Code of Southampton for a period of 14 days. I propose to reduce that to 7 days, 1 week.
Good.
Some of the issues that caused me to look into that is because right now there's a transient rental restriction, which is 14 days. It could be hard to prove that somebody transiently rented it out for 7 days and revoke a permit based upon that, because you'd have to do it for 14 days, and then it wouldn't be a violation anymore.
Oh, wait, okay.
So it's internally consistent.
That's fine for me.
Okay.
Moving on.
Thank you. Moving on to 270-19, penalties for offenses. I have shortened the language in there to make it clear that the penalties are pertinent to any violations will attach to anybody that violates the code, not just the owner or the tenant. That would include agents, middlemen, even real estate agents, anybody that causes the property to be rented in violation of the code. This is done
Where is that
based
language?
upon our experiences.
13.
Oh, you're just taking out by the
Page
owner or the
Page
tenant.
13 on the bottom.
At the bottom, the strikeout.
Property managers. Right.
Yes, many names are used. Finally, last page 15, very last addition to it, states that nothing shall prevent a tenant from maintaining a private cause of action to recover rental payments made if a rental permit was not in place for a dwelling unit during the term of his or her tenancy. This is codifying the ruling that's come from the case of Schwartz versus Torrenzano and his progeny, which stated in part that if there is a violation where you can't rent a house out without a rental permit, that there is an implied private cause of action for a tenant to recover his or her rental payments paid while there was no rental permit in place. And that's spread throughout the land based upon this case that happened right here.
Can I ask you one thing I didn't see in the law, which I know East Hampton does require, you get, every rental permit is assigned a number, and anytime you advertise that property, for rent, you have to include that number. It just helps, so if you see an advertisement online, or wherever it is, that doesn't include a rental permit number, that's a violation too, advertising it without a rental.
How do they,
Without including it.
but how does that work
It helps
if it's a new
identify those that
rental?
don't have,
They can't get a rental
I don't know
permit
so
until
much
they
about
have,
an advertisement, because that would actually be a free speech issue. I tell them what you can or cannot advertise.
well, it just says you can advertise, but you must include your
it has
rental
the
permit
rental
number.
permit number.
Just look at East Hampton's law on it. 'Cause I think it helps code enforcement identify which properties may not have rental permits, because they're not listed in the ad.
I'll take a
But
look.
I don't understand how that would work if it's a new rental. What, don't they have to, Rich, if it's a new rental and they're advertising for an unoccupied space for rental, do they apply for a rental permit prior
You
to
need to have a
that?
rental permit in place before you rent.
Before you rent the property?
Yes.
If you list out.
And that's
All right,
stated straight out of the code.
so
You should
once
not-
that identifier number's there, so what he's saying is that if it's then published with that number, would that help you?
Well, we could cross-reference the number to
Yeah,
make sure that
that
it's.
kind of makes sense, but I don't know if it's.
Take a look at East
Private
Hampton's law,
property.
because they do require
We-
that.
we can
And
go-
Anytime you list a property, you have to have the rental
We
permit
can go
number.
very far as a registration. We can require.
It's certainly
stickers on
for a
houses, too.
prospective tenant.
Let's do that.
Right.
It's
New
important
Orleans
for
went
the
very far
prospective
with their
tenant.
regulations recently.
Right? If I was a tenant, I'd feel safer knowing that, that everything would be complied with before I move in, only to discover I have an unscrupulous landlord.
They do in East Hampton require that the house number be visible from the street as well. But I
That's-
think that's
protects the
really so
tenant's
that the
rights
fire
as well.
department
Sure.
ambulance can get
There's
easily
these sequential
identified.
numbers every year? Like when we have a
I'd have
renewal?
to check. I don't know if they change based on the annual.
That's what I was talking about
East Hampton,
before,
you get
having
a
an
new number.
identifier, because I think that's useful for all your data, for collection.
And I think they can
Unique
tell
identifier.
by the number whether it's,
Because the numbers,
It might be like 18
Generated.
19
yeah.
or it might be consecutive.
Saves you a big headache
So
trying
if
to
it
find.
says 16 dash, you know it's an old one. and
Right,
you haven't
it's
updated it.
expired. It's not doing any good.
You don't think so?
All right, so I don't know that we have time to move on to the next one yet. I mean, unless we want to come back after, we had for 11 a different item.
It's 12.
I know. So, and I don't even know if Len Marchese is here.
He was,
He
he
was.
popped in and out.
So why don't we see if we can get those guys in? Do you want to come back?
I have to-
Take a break for lunch?
I have
and-
to get to court.
All right, so why don't we
So what I'll
reschedule
do, I'll work on the changes of the research projects that we've come up with from this one here. I'll schedule another time to come back. At that time, we'll discuss the short-term, the seasonal rental permit as well.
Right, and do you have something that pulls out the seasonal rental permit stuff in
Yeah, there's,
I can,
a sheet that these
oh,
are?
no, I don't think you said.
Well,
you
they're
said
in red.
no
They'd be in
before.
red,
Take a
right?
look at them.
Yeah,
yeah, in fact, the majority of it is, there really was only one main section that talked about the short-term, the seasonal rental permit, and a few interspersed things just for administrative purposes, but the majority of it is
I mean, it's fairly simple, right? It's a secondary permit.
270-7. That's really the crux of it. This is in the one that I marked SRP on page 8, section 270-7.
Right, and we talked a lot about this
That's-
already.
that's-
Not really, no. So basically,
Really it.
the seasonal
Are we gonna
rental
go through
thing
it
is a
now?
separate permit. You pay a separate fee, and during May through September, you can, instead of renting 2-week minimum, it becomes 1-week minimum, but you have to adhere to some strict quality
That's it.
of life,
Joe.
neighbor protection guidelines, or you lose that right.
And I believe Steve put together a very good synopsis that's in.
All right, so, I mean, I'm willing to keep going. Let me just get, can we recess for 5 minutes? Let me check with Len, and maybe I can schedule Len for 1. All right? All right, that's a 5-minute recess. All right, so let's resume. So we're sort of switching gears now, and we're gonna talk about seasonal rental permits. And the basic concept, as I understand it, is under the regular rental law, the minimum period you can rent is 2 weeks.
That's correct.
And there were a lot of properties that seem to be renting for shorter periods.
Yes, transient
And it
rental.
seems like that the market has sort of shifted. There are less longer renters and more shorter renters. So this would allow for, rather than 2 weeks, a 1-week rental during the summer months,
Yes.
provided they adhere to some strict quality of life, neighbor protection provisions.
Yes.
Okay, so you want to take us through what's being proposed?
Okay.
You'd have to get a new, you'd have to get the rental permit
This
plus
is a
it.
second permit on top of your rental permit?
But first, you need to have a rental permit and go through the inspection or certification process that we've been discussing already. Once you have that in place, you have the opportunity to apply for a seasonal rental permit, which would be a permit that runs, it's a 2-year permit, but it's really valid between the dates of May 1st through September 30th, which is the summer rental season, that would allow a person to rent out their permitted house for a shorter time, which is 7 days, or, I think, 7 days is how we wrote it. In order to do that, there are a number of life, safety, health, and neighborhood requirements that
I'm
are
sorry,
in place.
may I just interrupt?
Sure.
For that May through September period, is that an unlimited amount of times they can do 7-day rentals? Like every week?
Yeah,
Yes.
yeah, you couldn't have more than one transition per week in a 7-day period. So you couldn't rent it for the weekend and then have somebody come in on Monday. Right.
So I can't do a 2-day.
We can switch to the next tab.
Oh,
Do that.
Sure. All right.
So there are a number of requirements in order to have a seasonal rental permit. The idea being is, yes, it could potentially cause an imposition upon the neighborhood where there are short-term tenancies happening. These are put in place in order to protect the quality of life for the neighbors surrounding those houses where it may happen. These are laid out. Go through them one by one. Steve, you want to jump in now?
Sure. So, the seasonal rental permit requires the name and contact information of a person who will respond within 1 hour to correct any code violation upon the property.
That's needed, obviously, so a neighbor anticipates a problem. Granted, they can call code enforcement, we always welcome the calls, they can send in an SOS complaint too, but the fact is, somebody might want to contact the owner and say, hey, your tenant's doing this. So there needs to be someone that's going to be able to respond immediately. We, of course, will have the info as well.
I'm sorry, Steve, you read the first?
The first line,
First
the
sentence,
second
yeah.
line, the second part of that is the dissemination of the information to the neighbors by certified mail and to provide proof of service to the Division of Code Enforcement.
And what's the purpose of that?
So that the people who live next door to them are confident that they can contact someone who can respond to the property if there's an issue.
All right.
Including, code enforcement can respond, but sometimes we can't get to the property.
So this is an additional provision. So right now, if you rent for 2 weeks, you could be in New Jersey.
Right.
But here, if you're going to rent it for less than 2 weeks, you have to have somebody who's around to immediately address neighbor complaints.
The problem that you have is that, the code is done the way it is so that we don't have neighbor, I said this last time, pitted against neighbor, and that we are the people that bring the violations. We are the people that's our job, to give it to the neighbors. I don't.
I see this more as a caretaker position where a person can allow us access to the property, because we've had issues where there's noise complaints, but there's a gate and no one's answering the gate and you can't get in to see what's going on, and you would need somebody that'll allow access and someone we can deal with that'll go in there and maybe negotiate to resolve the problem in advance.
Well, can we require that they give us, if there's gated, that they have to give us the code to the gate? If it's a lockbox, they're gonna have to give us, if you're gonna send notices out to the neighborhood, that would
To the
invite.
immediate neighbors.
To the immediate neighbors, that would invite them and give them the idea that they now they can do something about that. Because I can tell you that anybody who's living next door to anybody else that's going to be renting their house week to week in a neighborhood, perhaps will have something to say about that. And so what are they going to do with that information?
Right, so you're concerned that it'll create conflict amongst the neighbors,
Yeah, I am.
and,
Well, these
That's
things
just
do
the first
create
one.
conflict.
But
And I
having-
understand that you're trying to address it preemptively.
Look, some people do operate the old-fashioned way. They'll go knock on the door and say, hey, can you turn the music down? This way, don't even have to do it. You call the person that's going to handle it, someone who's in charge of making sure the property is in compliance with the seasonal rental permit code, and say, Mr. Smith, you have renters here, you're responsible for it, the noise is too loud, they're jumping off the balcony. Can you do something about this? If you don't, I can call code enforcement.
This is a typical provision in places that do allow shorter-term rentals.
Where?
It's in other codes when doing some research.
Where?
I'd have to get back to you on where exactly that is, but that's where this was taken from.
I anticipate that the person who's gonna get the call would understand that it's their job to respond.
Then require they have a property manager if you're going to, I would say.
Well,
if
that's
you're gonna
basically
do
what
this.
it is.
I'm not saying I support it.
It's
one way or the
someone who
other, I'm
can
just saying.
respond within an hour.
Right.
They have to
But why would you
provide the
say it then?
neighbors with that, because this is a
Why do they provide the
a
neighbors?
little
that
more
work-
transient than the 2-week rental.
That's right.
So to create some additional protections, this is one extra protection, is the neighbors will have a number of somebody they can call who can get there within an hour to address any kind of
But I
issues.
kind of feel like we're delegating our responsibility, and we now will have put it onto the neighbors, and I don't think that's a fair, I understand what your intent is,
Right.
but I don't think it's a fair,
It's a quality of life
I think
provision.
the way they do
I
it,
don't- I
they
don't
disseminate
think
it
it's
to
coming out
neighbors
that
to say, the house next door to you is going to be rented on a short-term basis. The property manager is Joe Smith. If you have any issues, you may contact code enforcement at this number. This is also Joe Smith's number.
Right.
To give them that opportunity, because you're not going to be able to, it's not like you have your neighbor that you know that you can call up, or the short-term person there that's causing a
is there a
problem.
requirement that they have a property maintenance person or a property manager?
No,
Well,
but this essentially is that. it's
An
the person that's
individual,
going
they have to
respond
identify an
within 1
individual who
hour.
can respond within an hour to any complaint.
I think
Certainly,
it's problematic, but go ahead.
okay.
So the next is, a seasonal rental permit may not be issued for an accessory apartment. So an accessory apartment is something where the owner of the house would be living there in the building. It's really designed to assist with income eligibility, shouldn't be a transient 1-week rental. A dwelling unit with a seasonal rental permit may be rented for a period of no less than 7 days.
Says
I
night.
I had nights there, but that's
What's-
We went through that
Stays
last
in-
I
week.
don't understand the difference. You rent by the night, you're sleeping there.
Well.
'Cause then you get 8 days.
8 days.
It's usually 7 days, 6 nights, so if you stay for the 7th night, you wake up on the 8th day.
That's good math, you're right.
Well, it's,
That's what I was thinking.
right, I mean, you're usually going to check in
Right.
late in the afternoon.
when you do
and
like a long
leave
weekend,
early
4 day, 3
in the
night
morning,
stay.
so that it
Yeah.
could be cleaned for the next group coming in, whatever, but, I think 7 nights is, I don't think it really matters.
Right, well, then somebody in the next week is forfeiting a night, so to speak, because if you're gonna do it every week,
There are 7 nights in a week, there are also 7 days in a week.
I know, but you wake up on the
Well,
8th day.
We'll hire the professionals to do the math on this.
Apparently, we need
But
them.
doesn't it also imply that it says no less than 7 days I'll use? But it doesn't, does that mean that you can repeat the same tenant for that next 7 days over and over and over again in the course of the summer rental?
You wouldn't need the
Then you
seasonal
wouldn't
permit
need
for
this
that.
permit, then you're
You have
renting
somebody,
for
they're
more
going to
than
stay
2
for a
weeks.
month,
Yeah.
and that's working under your regular.
Oh, I
rental
see
But
what John
there's,
is,
you see, yeah, you get it, right?
well, no.
Because it's more,
He's
more
like,
money.
"No."
You're saying that it prohibits somebody from renting for 3 weeks? No, it doesn't.
No, it allows somebody to rebook the same person week after week after week after week at a probably, okay, never mind.
We're going
Just
down the
looking
rabbit
for-
hole with
Yeah,
you.
we are. Don't go, let's not go
Let's
there.
not-
We can discuss whether it should be 7 days or 7 nights. We'll have to analyze what the difference is. But I like
You're
7.
on that, right?
I think
I need a
7,
number, a statistician.
7
to
nights is
analyze that.
clear.
Well, since I can't-
How do you
Yeah,
define
because
a
that's what
day?
a day is when you clean it up for the first night.
What exactly is the definition of a day?
Exactly.
Yeah.
We'll get to that.
Okay.
Yeah.
Pulling in the dictionary.
I think
calculator.
nights make sense. You rent by the night. You're renting bedroom.
You're not renting by the night.
Well,
No,
it's- you're not renting single nights, what I'm just saying is, that's how many nights you're sleeping there. So rather than days, saying nights, I think is clearer.
That's how hotels
So if you
do it.
stay there 7 nights,
That's
you
how
will
a
have
hotel
stayed there 8 days.
Right.
Otherwise, we get
You got to
confusing.
leave on the 8th day, so
That's
then they
right.
clean on the
But
8th
you're
day
there
for the
on the
next
8th day.
person. Well, but you have a
I-
checkout time
I
of
think
10
leave it
a.m.
7 nights. No more than 7
You wanted to
nights.
come back.
I'd leave it nights, but keep going.
Okay, so no guests of the tenants occupying a dwelling unit with a seasonal rental permit may be present during the hours of 1 a.m. through 6 a.m.
How are you going to enforce that?
If we get a complaint of noise, then we can go there and we can request the,
Well, you haven't,
lease.
you're asking for a contract, a rental contract of some kind?
Yeah, there'll be a contract
So if
that'll
it's
tell us
rented to
who's
6
there.
people and there's 8 people there, it's a problem.
Right.
Keep in mind, each of these regulations, one of the reasons that they're in there, the penalty for violating one of the regulations of the seasonal rental permit is revocation of that seasonal rental permit. That's why each one of these do actually mean something, even if it seems like maybe unenforceable. If we are there and have any of these violations, that's it for the whole permit. So it's going to make people want
So
to.
the concern is you rent the
keep it very
house to
strict.
a nice family, whatever, 2 adults and 4 kids, and then they invite some friends over, and then suddenly it's really a multi-family, you know, it's a
Right.
different rental.
And the
So
violations then
you
fall
can
upon
have
the
people
owner.
visit you during the day, but this is a lodging issue, right? These are not, it's not supposed to be a party. It's supposed to be overnight lodging, right, to supplement the lack of hotel capacity.
Which is what we did for the open.
Right.
For
Okay.
2 weeks?
So the next is strictly conform to the noise limits in Chapter 235, or the seasonal rental permit will be revoked.
Okay.
Which they have to comply with anyway, but you're saying that if you don't, the penalty is just not just the financial penalty, but the loss of the
You
rental.
have your noise ordinance, but now you violate, it's going to be worse.
Have you made it any more stringent in terms of what will be considered a violation of noise ordinance?
No, we're not making this separate. We didn't change the noise ordinance restrictions for a seasonal rental permit. I mean, it's something we could do, if we think necessary, but the plan was to have it
I
as.
mean, you could make it easier to enforce, like, by having a
But that's not like an
provision.
additional provision. I mean, they're supposed to already do that.
Right.
They
but-
are,
but there's
it's
a
just the
penalty
loss of the
provision. You
permit.
lose your seasonal rental permit if you violate the
That
noise,
provision.
the noise code. You're not just paying your fine like you would in a regular noise violation. You would lose your rental permit, your seasonal rental permit.
Okay, I mean, that's, right.
In addition
not
to
kind of-
That's the
whatever.
motivation for the owner to keep the tenants
Right.
from violating that code.
So it's like a privilege. You know, you comply by the quality of life rules and you can do
Right.
it.
I mean, if you're going to be having these short-term rentals, you need to make it very strict and very clean.
Right.
So
I mean, you could add a provision in, like no amplified outdoor music after 10 PM or something, you know, regardless of the decibel level. You know, you could put in things like that.
From an enforcement perspective, I would think just the regular noise code, the code officers know it very, very well. They
Okay.
know how to operate the machinery, they're all certified in it.
It's on my phone, it works very well.
Yeah, but you say we can't get there in time. So if they knew a shut-off time, regardless of what, because they don't know what their decibel readings are, if they know they gotta shut it off at 10 o'clock, it's done. If we can't get there, it's,
Yeah,
Doesn't
you know,
matter.
you could say regardless of the, you know, chapter
decibel readings
235.
change during the different times of the day as well.
yeah, so they're happy you should have it
It'd
on
be 7 to
time.
7.
You could add in a provision.
Work
An enhanced noise
business
ordinance for the
noise.
seasonal rental permit.
You could say in addition to chapter 235, you know, there shall be no amplified music outdoors after 10 PM on a property with a seasonal rental permit. It's easy enough to add that in. Something to think about. So let's keep going through your list.
Okay,
I
so
would say, yeah, the amplified music doesn't always work, it's not always the application that's the problem.
That's true,
I could look into options to enhance it.
right. It's usually a boom box or a
It's a
radio, or
low-frequency
Bluetooth
problem.
speaker, that's, but, you know, it could be live music,
Could be people too.
could be people just talking really loudly. All right,
So a rental agreement is required and must be provided to Town of Southampton code enforcement personnel upon request. This would be where we would identify if there are additional guests.
Are you on the next, sorry?
no, he's on
I'm
that,
sorry.
it's number 2.
Okay, number 2.
I don't have it here. I'm having
So-
trouble.
They file that with you in advance. You're not waiting for it when you
No,
get
upon
there.
request.
Well, we would ask them to provide it. I don't think they need to give it to us in advance, the rental
What if they
agreement.
doctor it up?
The rental agreement?
Yeah, and
It's
say there's
false
10
document.
people. They're tenants. What, I mean, who are you asking for it from? I mean, for goodness
That's a
sake,
good
if
point.
they're,
So the rent agreement is probably, in most cases, going to be some online thing, right? So somebody has booked it through Airbnb
Right.
or VRBO.
Yeah,
But
originally,
it-
we'd written this as it'll be the lease agreement or the contract, but we realized people don't have that anymore.
Right, but they can produce something, I think, showing that I booked it to so-and-so for the week, and here it says there are 2 adults and 3 kids,
Right.
and, you know, that's who I rented it to, but, you know, 10 people, 10 single people showed up.
Right.
so you do have that in advance, what you're saying?
No, if we.
We haven't required it in advance yet, but I mean, that's something that we can consider. That
I don't know
goes in
how
with
you
the
think
season.
Administratively, that might be quite a burden, to try to keep track of everyone.
Because it's a 7-day
But if it's a
span.
problem, you want the right to get it.
Yeah.
Okay.
So the next one is any swimming pool and/or hot tub must be maintained by a professional pool service technician at all times during the seasonal rental period. This is to prevent, you know, chemical burns to children and pools not being
Do
maintained.
we have a
because
lot of chemical burns?
We had one last year.
We had one.
They were turning over the house to somebody else, and it was a short-term rental, it turned out, and then the owner went out and full of chlorine. Next family came in, the little girl jumped in, she was in the hospital.
So I don't know that we're licensing yet the pool maintenance people. I think we should. It's been something we've talked about here, but to me, this is a really important provision, that if you're renting a house with a pool or a hot tub, you know, the homeowner may think they know what they're doing, but, you know, that's where you end up with, you know, bacteria, that's where you end up with, you know, in the hotel business, you know, I have to check the chemistry 3 times a day in a log to make sure that the hotel guests are safe, you know. As you start to cross into what is getting more transient, I think we need to protect the renters a little bit and say, okay, look, if you have a pool or hot tub, it has to be professionally maintained. Like, it's the least, you know, we're not saying you have to record the chemistry every day or 3 times a day, but at least have a professional maintain it. I think that's
I think
reasonable.
it's,
Yeah, listen, it may be reasonable. I mean, in light of the fact that we're requiring a pool professional and a hot tub person, but for garbage, we're getting away with that. Like, it just seems
Well,
to me kind
remember
of
that this
silly.
is a provision that would apply to a shorter-term rental. If you rent it for 2
doesn't
weeks,
matter.
you don't have to do
The garbage
this.
provision, we're keeping that one, that's where we got to.
And can I just go back on that? In this handout you gave us, it does mention everything that we talked about previously, and one of those was the garbage pickup. Whatever we discussed during that will apply to this one as well?
Yes, because you're going to have the regular rental permit in place to get the season.
Okay,
Right.
thank you.
These are all
So again,
in-house
if you don't get the
requirements.
seasonal permit and you rent every 2 weeks, you don't have to have a professional maintain your pool. But if you're gonna rent it less than 2 weeks, you do. It's one added thing that goes with the shorter-term rental. Okay.
The enforcement authority shall revoke a seasonal rental permit when a violation of the code continues for 24 hours or more after written notice is provided. So that's the extra enforcement that we want to put in there to keep things manageable for people and
And how do you sort that out if somebody has bookings all summer and the first tenant has a problem, they lose the permit?
they're
I guess it's their problem.
they're gonna be summoned every week that they rent.
And how long would that be revoked for? Could they then rent next season, next summer? Is it forever, or is it
That
just?
goes to the question
That's
we
what
had
we're going to be
before.
looking
We can
into,
stop.
about revocation
Yeah.
or suspension.
Yeah, that's kind of interesting, because now you're not saying they can't rent their property, you're just saying they can't rent it short-term. So you're not
Oh,
taking
you
away,
wouldn't be taking the rental permit? You'd
not the
be
rent,
taking
just the seasonal
Because
permit.
we're
So
saying.
can you take away both?
If it's a regular, you're talking about a regular rental permit, you're going to need to, as proposed, have a violation continue for 7 days without correction.
Right.
To have this enhanced seasonal rental permit, we find a violation, you need to fix that instantly, because you have those people that are living there, for 1 week, you have neighbors that are being affected by the short-term rental, you have 24 hours to fix it.
But then, but we're still gonna have the same problem potentially. Shouldn't it be like if you lose this permit, you're subject to losing your rental permit also?
It's a different criteria, though.
It shouldn't be, though. You have more to lose. If you're
Well,
gonna
you
go this
may-
route and you lose this, you're gonna lose that
So
too.
if you get your
And I
seasonal
assume that
rental, you
24
double
hours, that 24 hours, I'm assuming doesn't mean noise.
No, right, that's definitely
Because
not
we'd
the
have
case.
far.
It's a violation of regulations.
Problems
too.
with
It's-
that.
It's rental permit regulations that are laid out here. I mean, you could do that. That's reasonable. I mean, it's really just taking out the word seasonal in this
I
section.
mean, I would say you lose your seasonal, that the privilege to rent short-term. If you violate the quality of life provisions contained in it, right, you're losing that. You may not have violated the underlying rental permit.
Then put may.
Well, it is the regular,
You may be subject to revocation of your underlying rental permit.
So if they continue to rent without the rental permit that's been revoked, then the money they collect could potentially be reclaimed by the tenants. That,
say it again?
so
Yeah.
someone renting then could reclaim the money that they paid if that person still rents to them after we revoke their permit.
That's a private issue, but yeah.
Yeah.
Yeah,
I
we
think
went
you're
there, told them
mixing
they
two
had to
separate
leave. They
issues.
would have to.
So if we're
Yeah.
looking at if you're talking about making it may rather than shall, right now it's a directive, even just for the regular revocation. It says the enforcement authority shall
Shall.
revoke a rental permit.
Right.
This one says shall revoke a seasonal rental permit.
And may also revoke,
We can make,
may in their discretion revoke your,
if we're going that route, maybe they should all just say may.
no.
Okay, good.
Just, what it's saying, the enforcement authority,
So shall revoke a seasonal rental permit, and we would have to lay out
Unless you wanna do-
criteria.
I would
and may revoke the
I
underlying.
would go with both. I would
If we
revoke
go with
both.
may, then we need to lay out the criteria for
Then
why
you're
you would
making
do
them
a
both
versus.
may? You're making them both may?
No,
Or making
I
the
would
first
make
one
them
shall and the second
shall,
one
yeah.
may?
I would make them both shall, or in the alternative, make one shall and the other one may.
Well, you still have to that's why I'm suggesting you come back next week, because you still have to determine legality of
Yeah,
this.
but-
Right.
So we can go around in circles, but
Yeah, let's move on to the next one, but the point is that the seasonal rental permit is a privilege, and if you violate it, you lose it, right?
Right.
Is there any others on the?
Hey, Michael again, I tell you,
The
he gets
last one.
around.
Is there another one?
Is that it?
It's Mickey Chi.
Yep.
Right.
That's it, so it's
That's it.
fairly simple. Now, I know this is something that you've been working with the Long Island Board of Realtors on. Part of the problem that we have a lot of people in our community who make a living renting properties. They get commissions on rentals, and what's happening with the online business, most of the real estate agents are complying with our laws, and they're not gonna take a rental less than 2 weeks, and so they can't get any commission from those rentals. It doesn't allow them to enter this business, yet the business is going online through Airbnb and VRBO and HomeAway and various sites, depriving a lot of people who live in our community of an income from this growing part of the economy, which, short-term rentals, it's an interesting thing to look at, because you can have a long-term rental, somebody rents for the entire summer, and they could be a real problem. Could be a share house, they've rented it for the summer, they could be a problem every day, every weekend, yet they're not a short-term rental. And you can have a short-term rental, a family for a week, that isn't a problem for anyone. So, the term is, I do think if you go less than a week, you're starting to look more like a hotel. And I think you're starting to compete with the hotels. But I know different towns have different rules. I'll just give you some examples. Shelter Island does allow short-term rentals on the main corridor, on 114. And I think everywhere else it's 2 weeks. East Hampton allows 2 rentals less than 2 weeks in a 6-month period. So you can actually rent by a night twice in a 6-month period, but that's it. They don't have the 1 week minimum. So, some areas like Riverhead, 4 weeks is the minimum rental in Riverhead. It's controversial. Southold, I think they're looking, at something like this. 2 weeks, there are 2 weeks now. We used to be at a month, and it shifted to 2 weeks because there's a provision in the code, not in our code, but in the tax code, that allows you to rent a residence for 2 weeks without declaring that as income. Right? That's not subject to income tax, a 2-week rental. So to allow people to take advantage of that provision, we went from 4 weeks to 2 weeks. But the rental market, as I said, is changing, and the real estate agents, are concerned that the old market of summer rentals and one-month rentals is dried up, and there's a movement toward these shorter rentals, people who want to experience an area.
Or people who can't afford more than a
Yeah,
week.
families that can't afford it, and we have very little hotel capacity, and it could be a positive thing if done right. So that's where this conversation really originated. And I would like to invite the Long Island Board of Realtors here to have, conversation with the town board a little bit about this as we
Set them up for the
progress
work
it.
session.
Yeah.
We had spoken with, I think it was Marlo Paventi, who was the director of intergovernmental relations for the Long Island Board of Realtors. The director of government affairs who we've spoken with, and I provided her with a draft of this.
Real
She's gonna get
estate
back
is a
to me.
major industry in our community, there's no question. This is something, it seems the industry is looking for.
And there's other considerations here with this, and I am concerned with this legislation. I appreciate the work that you have done on this, and you clearly have been thinking about, many of the contingencies, particularly with the neighborhood. Two areas that I'm concerned about with this, and you may want to address this, or bring in the realtors and have them address this as well, is the character of the neighborhoods where these short-term rentals would be. These are residential areas. People do live there year-round. I see the contingencies that were put into the code, but that's something that I definitely want to give more thought on. The other aspect.
John, I'm just on that point.
Well,
So-
I want to finish
Okay.
with the 2 points, and I want to
So I
put
have a
this
thought
out
of how you
there.
can address that by basically not allowing this across the town, but only in certain areas where you're trying to promote tourism.
Well, good.
Okay.
The other aspect is our housing stock for rentals. If people who own homes decide to rent their house out on a short-term basis, well, that effectively takes that home off of the market for year-round rentals. And I think it further puts stress on people who cannot necessarily afford homes to be in this community. Somebody's renting a house, they have 2 kids, they've got a good rental year-round. Well, if we put this on and somebody decides to, do a short-term rental for the summertime, that house is no longer going to be available to that family, and they've moved. So these are the things that I'm thinking about. I hear what you're saying,
That's
Jay, and it's a
consideration.
good point. Real estate is a major part of who and what we are out here, but we also have a housing stock that we need to be concerned about and
You
mindful
may,
of.
conversely, you may have somebody who is a year-round person, owns a home, who could use just a couple weeks of rental income, they'll go live with mom and rent the house out for them, just so they can stay here and not, lose the house or be able to afford to live in the community. So
Well,
it could
I
be a
mean-
supplemental
Right.
income for them.
And these are, this is going to be part of the discussion, and I wanted to put it out there now,
Right.
while we're having the work session. So we can
But
air these things.
typically, the rental market for summer rental is that you make more money with a summer rental than you do with a year-round rental. There's more of an incentive for summer rental, so your point's well taken in that regard. I don't know how you affect that. If you have the opportunity to rent in the summer, you're in an area where people want to rent, and, that's what you were talking about as well. You were talking about areas where tourism, that's where people want to rent because they want to be close to the beach, or they want to do those kinds of things, or it has a tennis court, or it's a swimming pool, or whatever that might be. That's a much greater income. And there's a reason why so many homes are LLCs, because this is a business that's been established here, whether we want to admit it or not, or recognize it, it's true. It's here, and that's what's happening. So, and I was a little curious with your comment about the taxes, because the 2-week rental thing with taxes, I don't know if that's limited to 2 weeks or not. I think it's income-based. So you have sections of 2 weeks rental like that. You are subject to tax, and you are subject to all those other things as well. So I'm not quite sure how that works out. But I think there's a little bit more to work on here with this. Because in practice, I see ways that could, the calls that I get are about short-term rentals, Airbnb typically. So it's not always just companies, it's not always just real estate. They don't even list they list through Airbnb. So the shorter-term rental drives it more towards Airbnb. And I have people that, they want it to be shorter. We want it 3 days because typically they do Airbnb over the weekends, Under this rule, I could see a way around it. I could see if I'm going, I'm being facetious about the 8 days and the 7 nights, but if you have 1 week rental or 2 week rentals, you can't take advantage of that weekend rental. If you had 1 week rental or the 7 days, you could set it up in a way that you can rent every weekend. And you would charge according to the week, you would do a discount cost on that. The person would only be there for 3 days over the weekend, and then you're required to rent it again the next weekend. So I think there's a lot of ways, that people can take advantage of this. And I'm not going to comment on whether it's good or bad, it's just, I just see that in practice.
Well, if they did that, you'd have only one movement, right? One transition in that 7 days.
Right, yeah.
Right, so somebody came in on, let's say, a Friday night, and they're scheduled to leave the following Friday night, but they left midweek. You couldn't put somebody else in there, you're locked out.
You'd have to wait till the following
You're like that.
7 days, or
You're locked out.
8 nights, or whatever it is.
Now, do you have a restriction built in here that, somebody, let's say somebody owned 10 homes, they couldn't get this on all 10 homes, just one home?
They don't have any restriction written in like that.
You shouldn't allow an LLC to do it. You should have somebody on the hook.
And we could cap the number of these things that
Some
we
houses
issue.
are owned by LLC.
Yeah,
And
a
they're
lot
not
are.
eligible.
Or in trusts.
And it's a problem.
Quite a number
for
are.
And it's a problem for prosecution a lot of the times, because you can't, they're not afraid of going to jail. Corporation is not afraid of that, and finding for service is always an issue. If they can, that's done for just that reason. It's an arm's length transaction from the person. Make it a person that's actually on the hook. If they want to do the seasonal.
I think that it should be, per owner, per entity, you should not be able to get more than one of these things. Because I don't want it to be a business where somebody is managing 10 homes, that then they're, basically running a hotel spread out. I think if it's helping a local person stay in the community, it makes sense. But I don't think it should be a business.
That's not covered in 277A, Rich? If you talk about the line, no more than one dwelling unit owned by the person.
Where are you?
277A.
270-7A.
What page?
8. Seasonal rental permits may be issued to any person
Oh.
no more than one dwelling unit owned by that person.
How about that?
Yeah, because I thought we talked about that.
So it is. So
You're a
you-
genius.
So an entity can only have one.
Or any
So no
entity
entity.
within which that person has
Take out
any
an
financial
entity.
involvement.
You should take out an entity.
Where is it now? 270?
Page-
270, page 8.
Left hand is
At the very beginning.
Well, the concern, the way that I wrote this, was my concern you'd have the AAA corporation, the BBB corporation, but Joe Smith is a member of both those corporations, so he finds his way to rent out different properties. So we said, if you're involved with more than one company, you're only going to be able to rent one house.
No, that's good, but I
I
wouldn't.
mean, a lot of houses are in LLCs, corporations,
I know, it's a problem.
family trusts.
I know.
Would we be able to see that? If an LLC applies for a permit of,
There's going to be, the regular rental permit application will be the LLC, they have to be owner of the property.
and if the person has separate LLCs on different, or the entity has separate LLCs on different properties,
We're not going to be able to get
Effectively
that from a
making a
corporation
trust.
search unless we're subscribed to KPMG or some
It's
sort
hard
of
to-
search site like
Very
that.
hard
We're
to
not
find.
going to get
Really
the
hard
underlying
to
numbers.
So, two other things.
that took me about 30 seconds.
Yeah.
There's also the liability
Watching
issues,
you.
the liability
Well,
burden.
no, I don't do that.
We-
Do it.
The liability burden on a
That's how you do it.
homeowner,
Right.
on a private citizen versus an LLC or an S corporation or something like that are very different too, which affects costs, what they're going to pass on to the renter. So, those are, I don't know if that's captured or whether it's appropriate to be captured here, but that is an issue.
The points you bring up is a good way to stop that type of fraud, if you will. I don't know if it helps to advance the purpose of replacing hotel stock that is not available by saying you have a house, you need to have it in the name of a person in order to do the short-term rental. So sometimes LLCs are in place not for nefarious reasons. Sure.
Unfortunately, though,
For the
we
good reason.
are always having to look at the unintended consequence of something, which usually winds up, a lot more of a problem.
I'm very much
in
plugged
Can
into that
you,
for it.
can you go over what the rules are for bed and breakfast? Because we have a different provision that allows you to rent by the night, a bedroom, up to 5 bedrooms in a house.
I'm not too well versed in that,
It's a
in that
special
code.
permit,
It's-
isn't
It is
I'm not
another
sure on
permit,
that.
I believe, or it's through the building department. I actually don't know that well. I've actually had no dealings with
Because that truly is
I
a
haven't had
transient use. I
encounter
think
with that.
you're,
But I think it's burdensome cost-wise. I think that's why it's probably not used that much.
I think
maybe not taking advantage of that much. I know there are a number of bed and breakfasts.
there are a few,
Well, the
yeah.
person has to live there, though, don't they?
Right, there's a lot of, there's a
They
lot
have
of
to live there.
conditions on
Yeah,
it.
They
so, I
have
mean,
to live
that's-
there, but
we
it's
don't have a lot of people that want to
Yeah,
invite.
and then there's
strangers
the liability,
into
the overhead for that particular is high.
The owner, I think, has to live there.
Yeah, and then they have to assume the renter's insurance and all the rest of it.
But it's a much more transient type of use than what's being proposed here. There you
Bed and
have different
breakfast,
people
like
every night.
weekend. Well,
But,
But it's not.
yeah, most people,
It's
one
permit
day
for
is
bed and
not
breakfast.
good,
It's not just a
7
restaurant.
days is too much, 3 days is.
Probably should also serve food,
You know.
too.
You know, the other thing the board could consider, if it wants to consider a shorter-term rental thing, is, one, do we cap the number of permits that we issue? You know, how many seasonal rental permits? We could set a limit in a given year, or a total amount. You can also, and Tommy John, you were sort of getting in this direction of some sort of locational standard. Is it right for every neighborhood? Or maybe, you know, if you're within a certain distance of a main highway artery, or something like that. So, just things to think about, whether this makes sense for all properties or just some properties. So this is really the beginning of the conversation.
Some more research to
And
do.
what I'd like to do is invite the Long Island Board of Realtors into the conversation. So maybe take some of the suggestions, and we'll schedule another work session, maybe in 2
I'll
weeks.
tinker with this a little bit. I'll come up with a list of suggestions. Everyone's come up with, so we'll have discussion points, and discuss that with,
I'd like to also, not just the Long Island Board of Realtors, but also there are people in town right now that do rent to Airbnb and feel restricted in some cases. They're local residents, year-round residents, they're trying to make it some extra money and, you know, talk about the time distance. I think we should have some representative of that community, part of this conversation to understand the implications beyond just the real estate
who is the,
market.
Sure.
who is the representative of that community?
I don't,
Well,
there are
maybe
a couple
if-
people that have contacted my office that have the questions about it. Maybe just bring someone in who does it for a living to see, you know, what the pitfall, what their perception.
They're not going to want to come and say that, though, because you're not allowed to do
Certainly not
it.
to me, they won't.
I don't know.
Not to us either. I mean,
I don't know
I would
how
think
how we
they're
get it
not gonna wanna admit
represented.
that they did
you know, I
that
don't
against
know.
the law.
It's not, I'm
I
saying
had-
Airbnb type, but it's not just Airbnb.
There was a memo from Airbnb that I had seen where they had listed, I think they have like at least 800 listings in the town of Southampton. You saw that.
Maybe we should-
We're prosecuting them, aren't we?
Airbnb itself,
Are we prosecuting them?
which.
Airbnb?
Sure, if it's a violation of our code and short-term rentals, yes.
Right, so-
Wouldn't have, not even having a rental permit on a lot of them.
Right, so I think these shorter-term rentals are happening, I think for the most part, probably without a problem. And they're happening in all tourism communities. If you want to go out to Aspen or go visit, I don't know, pretty much anywhere. My daughter and I went to Mexico City, we used, I think Airbnb. So it's pretty typical.
My daughter was just in Mexico City, exact same. That's really interesting, because that's what,
And it was-
I
it
said, where are
was-
you staying? Airbnb. I just,
Terrific. So I think, you know, people are, it's an industry that more and more people are taking advantage of. We don't have to do this. We can leave things just the way they are. But, or we can try to figure out if it's something that makes sense for our community, if managed right. Maybe there's a way to do this that will help some, you know, year-round people stay in the community and may help our stores and restaurants, help our tourism industry. You know, I think it's important if we do go this route that we're not interfering with the hotel businesses, you know, where we're not, these people aren't providing like a daily maid service or hotel type of amenities. That's probably not written into your law, but I think, you know, the 1 week minimum, they really should not be getting into the nightly rentals. I think that's really not fair to the hotels that are heavily regulated by the health department and by the
Christine
town.
came up with, makes sense then, if they do go and rent it out for one night, you're gonna lose your whole rental permit for that.
Yeah,
That's a good motivation to comply with the rules.
yep. Yes, well, you did say the minimum rental period is 7 nights,
Or days, that's true.
but,
Yeah, there's constitutionality
All right,
issues
so-
here.
okay.
How much you're gonna restrict someone's right to, I wanna find out.
You don't have a right to rent, though. You got to remember that. You can do the research. I don't believe you have a right to rent.
yeah, I
It's a
don't know.
privilege.
I've got some research I'll put together,
Otherwise
the
we wouldn't
talking
permit
points
it.
we've got, set up another work session about the Board of Realtors. I'm gonna try to reach out to Airbnb, see if there's maybe a representative from them that might be representative of the renting community. I don't know how I'm gonna get people that might actually be doing short-term rentals right now.
I'll pose the question to a couple emails that I got and see, and I'll pass it along if anybody has any.
But they might not
This
want to
is-
come to a town board meeting
Probably
discussing
not.
it, because they'd be admitting basically they're renting short-term. So it may be complicated.
Yeah, it is,
They can discuss why they support it, they don't have to.
Why don't we
So they
circulate it with our
did.
CACs?
That's
And
true.
they're going to speak to people in the community, both who have taken advantage of Airbnb, and maybe some of the CACs can come and discuss it.
Yeah, it's a very broad conversation, it's very necessary, I think.
good idea.
Certainly part of a larger conversation for people who live here.
It affects everyone, whether you're part of the market or not.
Right, the year-round population is
Right.
And I
I
don't
thought your
think they
point
have any
about affecting
organization
affordable housing could
to
be
come
an
here and talk.
important point.
It's a good point, it's a very good point.
It's a good concern. Is it's going to contradict our efforts to create affordable housing by creating a, more economically viable home use? So I think it's important to look at all those things. Okay,
Thank you, everybody.
Thank
Thank you.
Can you send,
Thank you.
For you guys, but appreciated.
You want a copy of the presentation? We can forward.
Yeah, actually, I would, if you don't mind. Thank you. You can just email, right? Just-
Yep.
Yeah. Thank you.
PowerPoint.
so maybe while we bring Frank and Len in,
What is it now?
the Hampton Bays Water District, putting on our Water District Commissioner hats.
We're not doing, we're doing it in the context of a work session, not a water district.
Right.
meeting.
While we wait, maybe just a couple announcements or reminders. There is a press conference tomorrow, 10 a.m. at the Hampton Bays train station. This relates to the morning and afternoon trains that are starting on March 4th. This is that East End commuter connection that Assemblyman Thiel's been leading the efforts for, and Councilman Tommy John Scavone has been working on, and myself and others. So everybody obviously is invited to attend the press conference to help publicize it. And we do have the head of the Long Island Railroad is going to be there, as well as Assemblyman Thiel, and possibly the county executive may be there as well. So encourage everybody to try to come. It may be cold, but 10 a.m. tomorrow at the Hampton Bays train station. All right, another announcement tonight is the Police Award, 7 p.m. at the Avram Theater at Stony Brook, Southampton. So encourage all town board members to be there if you're able to as well. And some of us attended a press conference last week. I think Councilman Scavone was there, Councilman Bouvier was there, and myself regarding the governor's budget, not including the aid to municipalities. So we're, working with Senator Gorham and Assemblyman Thiel, who both chair respective local government committees in the Senate and the Assembly, to try to reinstate the money for Southampton. It was about $200,000.
We'll have them. We have them.
So Len, I'm just stalling here, making some announcements, so you're back. Just saying, this kind of affects you, that I attended with 2 other town board members a press conference calling for the reinstatement of the AIM funding, the aid to municipalities. So,
I thought that was being restored, isn't
We're working on it.
well,
it? Rumor has it.
And that was in most towns across the state. We just cut the AIM funding.
All of them. Yeah, well, you're right. There's a couple that.
Right, there were
Not all
like
of them.
6 that got.
any
Yeah.
year where.
Any town that had AIM funding under 2% of their total budget was cut. I mean, it really is, it's a large
I was gonna say, how
expenditure
do we get it?
statewide.
AIM is much less than 2% of our budget.
Yeah.
It's
Why do we-
200,000.
I
or
didn't-
$100
I think that was.
No,
fake.
those are the ones who got cut, anyone under 2%.
Oh.
So if you were more
Yeah,
reliant
more than
on it.
2%. If you were relying on it, you kept it.
Yeah.
That's not right. Whatever.
If
Yeah,
it
it
was going to
worked
have,
out to a
basically, if it was
small
going to have a
number.
less than 2% impact on your budget, you got cut.
Okay.
But we're hoping that it gets restored, and we have very, capable representatives that are going to be responding. There's always changes to the governor's budget every
Oh,
year.
absolutely.
And
Additions.
we are
Additions, subtractions.
hoping that the money gets, for us, it was 200,000.
Additions.
So we have, right now, have a $200,000 hole in the budget. Money, we passed the budget anticipating $200,000 in AIM funding, and it's not coming. We hope it will be coming.
Correct. But we're also working on other things to make that stuff up that won't impact services. I actually had a meeting yesterday with our investment advisor, and we have some opportunities coming up in the near future to refinance some of our outstanding debt, because the rates have dropped recently.
Yeah, we got that, I think we got an email or something that told us about the rates dropping.
Yeah, the rates did drop, so I met with him yesterday, we kind of went over some of the issues. It's a little bit too early to, they're not callable yet, they're callable in June, and the markets change obviously every day, every minute, so
And no more advanced refinancing. So
there's not advanced, this would be just a regular refinancing.
With the AIM stuff, when would we feel the impact of that if it were to go through? I mean,
We get the check in November, so it'll be in this year's budget, but it's late in the year that you get the money. I mean, we budgeted on an annual basis.
right.
It's based on population.
we'll know by April whether the money's been restored.
Yeah, by the time they adopt the budget, and then we'll have time to make adjustments. I mean, I would have liked to know ahead of time, because then you could have planned when we adopted our budget, but, we'll adopt. Right now, the mortgage tax is something that's much more valuable to us and variable, although I've actually saw some positive improvements in that, so I'm pretty cautiously happy with that, so that's good.
All right, so let's switch gears here. So Hampton Bays Water Authority, we've been having, Water District, I'm sorry, Hampton Bays Water District, we've been looking at different ways of addressing water quality issues there, including using Suffolk County Water Authority as our managing agent. And, we've all become aware of some of the infrastructure issues that Suffolk County Water Authority had intended to address in their proposal. And I've asked the controller and Frank to sort of look at different options if we were to try to do these things ourselves, modernize our system, try to match, rather than going with Suffolk County Water Authority, try to match those things, the additional testing and the infrastructure improvements, how that would affect ratepayers. So, Leonard, throw it to you.
Well, from the public sessions that we had, those were some of the comments that people would take away. I heard them saying, well, why couldn't we do that? Why couldn't you provide that to us? And the answer is yes, but you have to factor in economies and what it's going to cost. So I thought it would be important for us to kind of look at what we currently pay, what we could pay, and what the options are if we went to Suffolk County Water Authority, because it's not all, well, this or that. They all have financial implications. And perhaps there's a perception there now that if we go to Suffolk County Water Authority, our rates are going to go up. Our quality of water is going to be better, and our rates are going to go up. But I don't necessarily think that's the case if we look at all of the relevant items that go into what's to deliver quality water.
Len, is it fair to say that that will not be the case because we would be controlling the cost, the billing to the water district customers? And if we decided not to raise the water rates, we're not raising the water rates.
Correct, but ultimately.
Just the rates, though.
Yeah, that's the rates. It's more of a twofold agreement.
If we go to the water authority.
Yeah, I can get into that. Let me kind of go through this, and then we'll get at that towards the end. So, we broke it up into three options. Frank and I have been working on this for quite some time. And the first option is kind of just continuing what we've been doing. We have barely, we kind of keeping track of our infrastructure. We're not really doing major investments. We fix something when it breaks. We have consulting reports that sometimes we take their advice, sometimes we don't. There's some
Minimal compliance.
minimal compliance
That's
with
like a
standards.
no option, is what it sounds like.
It's continuing what we're doing. Right now, we didn't raise taxes in the district, we haven't raised the rates, the money's kind of coming in, it's going out, but that's kind of where we are. If a pipe breaks, we'll fix it, but we're not planning, we're not improving our infrastructure, we're not
It's sort of like your status quo.
status quo. But the status quo, as you know, this last year, we experienced a lot of trouble with the status quo. So I don't think that the quality of water delivery and the infrastructure needs, the status quo is an option that you now, as a board, should be considering. I think you really
No
think that
option. Wasn't kidding.
we need to up our game. I don't think that
Absolutely.
existing level of service by anybody's justification is satisfactory.
Well, it's also, you have things like the recoding of the tanks that you have to do. You can't not do those things.
Well, a lot of
We
times,
saw the pictures.
there's deferred maintenance that you can kind of put off, and you can put off, and
Right.
it doesn't show up right away. But then after a while, at
Right.
some point, all of that deferred maintenance comes home to roost, and you have a huge bill. So, that's,
operates as a baseline.
That's the
Right, so
baseline.
option one is, it's sort of a non-starter, but.
This
yeah.
is the point of departure, so you're going to present to us
Sure.
options.
So, option two, and so what we took away from some of those meetings were that some of the residents say, well, why don't you buy services? Why don't you hire a manager? Why don't you invest in the capital? Well, we'd like to do that ourselves, but this way you still keep control. Okay, that's certainly
Contract
doable.
with a chemist and a hydrologist.
Certainly doable. If you give me a checkbook, with an open checkbook, I could probably buy all the services that Suffolk County Water Authority provides.
Or a lot of them, maybe not all of them.
Well-
You're not building a testing laboratory, but you
No, we
might
would
be able
hire-
to
we would
pay
hire
to
somebody.
test for all those chemicals.
Yeah, we'd hire
But the
people.
largest investments in infrastructure improvements.
Yeah, so, part of what we'd have to do is invest in the capital infrastructure, and a part of what we would have to do is invest in our operating and continued operations. And the continued operations include various things like additional staff, water testing, and, other operating type things. But then there's also the capital component, which was identified with the County Water Authority as needing additional capital improvements within the next few years. 3 years, 5 years, however you want to look at it. You can't do it all at once, but you would phase it in relatively quickly. And then the third option is to transfer the management operations to the Suffolk County Water Authority, and then they would handle all of the capital improvements necessary, all of the operations, all of the testing, and,
Can I ask you a question?
sure,
On option number two, you said that the water rate increases,
yeah.
but I was looking with what I believe is the corresponding numbers table with that.
Right.
And that appears to be the same 277
Well,
across.
that would be up to you folks.
Right, so it
you-
doesn't
you-
necessarily increase.
What needs to come in, the money has to come in. How you
What-
raise it,
The rate, the water rate, the way this reads, the water and tax rate increases, may not, the water rate may or may not increase.
well, you can
The
choose
tax
to
rate
just
may or may
double the
not.
tax rate, but then that affects your
For
tax cap
infrastructure.
levy, and
Or you
I
could
don't want to go
increase the
there.
water
Right,
rate
no,
and
I
leave the
know, but I'm
tax.
just
That would
saying-
affect other
It's
parts
a-
of the town.
I'm just
It's a
saying, you have
$14
this
million
constant across.
Okay.
That's for comparison purposes, but I would recommend that we would do, if we were going to go with option two, I wouldn't just raise taxes, because that's going to impact all of the town because of the tax cap. So we would have to do a rate increase and a tax.
Or you could just do it all in the
Rate increase.
consumption, because then somebody who's
Then
not
it's
using
fair.
the
Opposite to the
water.
rate, but we've been saying that your rates are not going to go up, so we couldn't really do that.
Well, in option two, they would have to go up if you chose.
Right, that's what I'm saying.
Yes.
It's opposite of what we've been.
Well, no, we're
we've been saying that
with
if we
the
go
water
to-
If we
authority,
go to
it's not going
Suffolk
up.
Water Authority,
If you keep
Which
things.
is option 3.
that's
If
option
you keep
3.
things as they are, but modernize the
It's-
system, to forget about Suffolk County Water Authority, we do it ourselves, but we now add the added professional services and we fix the infrastructure up. And rather than using Suffolk County Water Authority's money, Hampton Bay's money,
Right.
that's going to affect the rates.
When you got these numbers for contracting services, where do those numbers come from?
Well, can we go
Well,
through?
let's go
I thought we were.
Yeah, let's go to the
Trying to
next
go
slide,
through it.
because we're gonna, that's all in there, I think.
Yeah, okay. All right, so that's the summary page. So now we look at option one. I'm just, the pros and cons, we just kind of talked about it. We continue our management structure. The cons are really all of the things we talked about. Not addressing the water quality, not addressing our capital improvement needs, and not addressing our contaminants. So we agree that option one is not something that we really want to look at. So then you talk about option two.
So let me characterize it. Doing nothing is not an option.
Okay.
I think that's fair to say.
So option two would be investing in our current infrastructure. Now, the investment in our current infrastructure, we did estimates on numbers. These numbers could be low, they could be high. They're numbers for us to discuss. We put out a capital project estimate of $14 million. Is that something you might want to do? You may choose to only do $7 million. You may choose to do $15 million, you may choose to do $5 million. That's obviously what we would discuss along the way. But it's a number so that we have a comparison to a
And that
fixed
comes from the
number.
14 million that the Suffolk County Water Authority
They gave us that
identified.
schedule. We didn't just pull that out of the hat.
They were giving us 6 million.
Right.
Well, in the
6 million
first 2 years.
first 2 years.
3 years.
Right.
First 3 years.
And then
And
they
then
were
they
coming,
committed to
they
the
came in
8.
with a $14 million plan over a period of time.
Well,
They committed to the other 8, you're
Yes.
saying, in the lease agreement.
Well, that's how they
Whatever
gave
that
us.
was.
That's how they gave us the schedule. They gave me that schedule.
And
I
if we do decide to go with option two, I would like to make sure, rate those infrastructure improvements, what's health and safety, what's just cosmetic, what maybe we don't need, so that number isn't so high.
Oh, sure. Well, we can get to that schedule.
For another
We can
day.
get to, and we
You
can get to
can
that
pick
schedule
and
here.
choose, though. Yeah, there's certain things I think you have to do.
yeah, you would have
And, one thing that's not on the list of Suffolk County Water Authority, there's no money scheduled for water mains. This is an issue Tommy John has raised.
Yeah, I
too,
think
that-
we should definitely have a contingency in there to make improvements in infrastructure on an annual basis, or at least money that gets encumbered to improve the infrastructure of the water district. Maybe it's $250,000 each year, and it builds up until we need it, or periodic replacement of water mains has to be part of the
Couldn't some of
equation.
these qualify under the water quality legislation for the CPF? That's exactly what.
Well,
I
yeah, I
brought
mean,
that-
that's,
You mean
Yeah,
it-
it can be.
You mean like
That's something to-
expanding
to
water
look-
mains?
And individual tie-ins and all that stuff is stuff.
but the
that
larger
arguably
picture
could be-
is,
Yeah, I don't think we're talking about
Yeah.
tie-ins here.
No,
right.
you are. They're in there. You got $500,000 for a tie-in, the iron.
No, no,
thing.
well,
No,
that's not an individual's time.
What is
That's
that?
the-
That's the
So that we
maintenance.
have a cross-link with the county water authority, so we can maintain
East
our
and
pressure in
west.
the summer.
There's about three other things on here that may qualify for
I
the
don't think
CPF
so.
purchase.
Remember, it has to be in.
CPF, sorry, investment.
It has to be in areas that have those emerging contaminants. those-
Yeah, I know that.
Right, so, the charcoal filtration that
What,
we
John?
put in might have qualified.
He's got an order here, I think he's going up to those issues, so if we could get
I
through
know, but
that,
it's
I
just in my
think
mind
we're-
it was relevant to
Because the
this
discussion of money is back
I-
here.
We can get to it, but I
Well,
don't think
I
there's anything
think
that
it's
would
relevant here
qualify
as
for
well.
water
On
quality.
CPF, I couldn't weigh in, I just, have to look at what this action.
All I did is raise the question that these charges that we're talking about, which says.
They're all, it's, what it is it's a placeholder. So you guys, so Tommy John is saying, what about water mains? Well, water mains might replace the computerized, you might say here, we have in this schedule, when we get to it, there's an upgrade of all the meters, $2.4 million. You may say, well, I don't mind having our guys walk around and continuing to read the meters. I'd rather save that $2.4 million. But now you might need that 2.4 for new water mains. So that kind of could
Right,
be
that's some decisions.
those things will come up, which we don't know. Part of the
There might be some
part of our
grant
problem.
monies out there for some of this.
Well, yes,
And
absolutely.
I think the CPF would also have.
Part of what our problem
disagree
is
with you,
I don't think that we've had a current system analysis or a system evaluation, like a survey. Like when you before you buy a house, you get a survey to see what's the damages, what can we be facing. I don't think we've had a comprehensive review, by like an independent engineer or something like that, to give us a report to say, here's your short-term, intermediate, and long-term needs that you have to address, and then you can assign a value to it. The closest we've come is the water authority walking around and giving us their opinion, and that's kind of where
So
we got it.
H2M didn't give us,
No,
hasn't given us.
well,
They've
anything.
done periodic reports, but
Individually, and I think we'll have them in here next week, but at this point, we don't have a comprehensive
Right.
proposal like we
Right.
had from the Water Authority.
No, we have a stack of things this high from their consultants for things that bear in mind that this system, I'm going to speak as the engineer on the board right now, it was built in the 30s, so we don't really know the extent of the maintenance that's taken place in that, and I think that's going to be more revealing. So whether it's 6, 8, 14, or more $1 million, we definitely have an infrastructure system that needs a thorough review, which has a cost, an understanding of it, because we don't see it. And the other one is any repairs or changes or modernization of that system that needs to
Yeah.
take place.
I mean, the largest component of our system is the water mains, and I have not seen a report yet that, looks at the condition of the water mains.
No, you actually
I think that we-
commission these, a camera, and it goes through the whole system. It's
Right.
kind of
Well, you
cool.
might have to take cross-sections of pipes, remove sections, and just examine them and see.
We wouldn't have known we had a problem with the
But-
pipe going
You
on
do
under
sound-
I will be
the
asking-
Quantuck Bridge until it broke.
I think, I'll be asking the
That's how
town
it's
board
been
to, ask H2M or other consultant to give us a overview of the condition of water mains. I think that's important.
So anyway, the option 2 contains a lot of pros. Obviously, the pros are we continue to maintain, manage the water district. We have our internal staff. You folks, continue in your role as overseers and prioritizing which projects need to take place. We will receive the level of testing that the Water Authority is, or will buy the level of testing that the Water Authority is doing. And we'll implement a bunch of these capital improvements. And the cons are, will it cost more? The current cost, which we'll get to, it's going to almost double on the annual basis what it would cost if we implement this type of a plan. So if you compare a doubling of the cost if we maintain local control, or maybe 3/4 of the cost versus some of the other options, then that's a conscious decision that you guys have to make when you decide which way you want to go. So then option 3 is the transfer of the management and operations of the Suffolk County Water Authority.
Can we stop? I just want to clarify what you just said, because that's an important point. So you're saying, depending on what we choose from this list that the Water Authority had put together, of course, we would get our own numbers and our own bids, but it's a guideline, that the cost to each individual customer of the Water Authority may go up by a third?
No, 3/4. 3/4,
70%.
70 to 80%, yeah.
But I think
Okay.
that's also important.
And that's based on the bond and the things, these improvements that we're indicating here, that to put into the water
If
district?
you were to implement the improvements that we talk about on these schedules, and the added operating and maintenance costs, which we added in on our projections, it would cost like 70, I think I have the percentages,
70% more.
70-something% more from their current rate levels.
Okay.
It's not only their rates, I'm sorry, it's a combined what an average homeowner would pay. Because the average homeowner, bear in mind, pays some in their rates and some in their taxes. So when you combine them together, it adds up to, say, $425.
So
Under this scenario, it's going to be over $600.
Got it.
But Len,
So let's
that may-
just be clear that this option you're talking about is the option where the the customer is bearing
Yes.
the bulk of the payment. It's coming out of the district alone, and it's coming
has
out
to.
of the consumer alone.
It has
And
to.
that's option 2.
Yeah, and I just also, and you may be right inevitably, but we don't really have the numbers in any type of, like, a quantifiable way that we can rest assured that we did our due diligence in terms of contracting out, and for the capital, because you can go through what your numbers are, but some of these may be allowed to be covered by the CPF. The contracted out services, we haven't looked at them individually. The cost of savings we could do if we restructure in some way. There might be a way to be able to bring together option 2 and option 3.
There might be
But
a
we
middle.
need real numbers in order to do that.
Well, this was our attempt. to
No, I
put
know that. I
together,
know that.
Estimates, and until you go
Your
out to
estimates.
bid, until you.
You based it on the
do more
list
due
of Suffolk
diligence.
County Water
This is a
Authority.
comparative.
This
Right,
is
but we need to
this
compare.
is to try to best match the proposal that Suffolk County Water Authority
And
offered.
they did address that in one of the evenings that we had in Hampton Bays, and the Suffolk County Water Authority said that this was their number that they get based on the numbers of recoding of tanks that they do. So they were confident, the Suffolk County Water Authority was confident that these numbers were actually very good and possibly lower than what an individual district might get
The
out
capital
on the
numbers
open.
you
Yeah,
mean.
yeah.
Capital
Yeah,
numbers?
because they put out
Capital numbers.
recoding of tanks, they put out
That's right.
20 of them, so they might get a better
We could
price.
tighten
I'm
those
not
numbers.
questioning those, because I would assume that they know what they're doing. I'm even taking those as they are. I'm saying some of those numbers may be able to be covered by CPF, and some of the other numbers that we have here, which are on page,
I so disagree with you
whatever.
about the
That's okay.
CPF.
So
I
what-
haven't said anything to
That-
disagree with. I said it may. And it's page
But you'd have
8.
to show me what you think might be coverable by
Okay.
CPF.
And
There
it's
might be
pa-
other grants available,
Okay,
but I
and it-
don't think CPF. It's very
Just
heavily
finish.
restricted, yeah.
And in page 8, when we come to water testing, technology costs, additional technicals, all of those numbers, 820,000, we really, I feel, need to get more into the nitty-gritty of what those actual costs would be. So to make a statement that 70% of the cost would go up without truly having delved in a little bit further, I'm just not comfortable saying at this point. You may be right,
No,
but
I've been doing this stuff for a long time. If I was going to put together a plan to do this, I think that's cheap side. I think 800,000 is
It may
on the
be,
cheap side.
but I think- I still
that's,
think
I think
we're
I
gonna
just threw
be-
numbers out there, you're right, so I put some numbers out there.
Yeah.
But when you start doing this stuff, you can't believe how much this stuff costs. Like,
But
I
we-
would just
but
sit
we have to
there, you
find
gotta be
out.
kidding me, that costs that much money.
but we have
dealing
to
with
find
water.
out.
I'd love to hear what
You
you
know, it
think.
just happens all the time. I've been doing municipal budgets and municipal government operations for a long time.
And the
So it's not a big
820,000
deal.
is less than 10% of the 14 million in infrastructure, so
Yeah.
it,
Well, you know, you might say, well,
May
I like,
offset- it may
I
offset
think we
a
have
little, but-
the existing, say, for staff-wise. We may be able to retweak what we have in existing staff and not look for somebody on the outside. Well, that's an option, and that saves a good amount of money right there.
Right.
So I just want to say two things.
There's different ways you
Again,
can combine.
Again, as the engineer here, I think your prices are low. And I think there's a lot of unknowns here when you start looking at what's actually going on with a system as old as this.
Sure.
And particularly with some of the, when you start to look on GIS, you start to see, 4-inch and 8-inch and 12-inch lines that sort of go and stop. There's a lot of infrastructure under the ground here through the years. I just don't know what the state of it is. I've got a big document that I need to go through to understand that over time. I don't see a maintenance schedule, which makes me really worry that that will drive costs up because I have no record of what's been maintained. The other thing about CPF, let's bear in mind, CPF Water Quality Fund, on a good day, is going to give us $8 to $10 million. And there's a lot of other projects that are earmarked for that fund. I'm not entirely sure, and I don't want to make a statement one way or the other, I'm not entirely sure the CPF qualifies for this, particularly on the basis of its stated goal is to remove pollutants, right?
For regulate, for, in
Yeah,
areas
so
where you
I
put the
don't, I think there's
contamination.
I think there's a lot of room here, but if we're talking about 70%, I think it's probably higher than that, even if we offset it with various funding sources.
It could be. My main point, though, is just that while this is appreciated on a macro level, we're making a decision that people feel very passionately about, and we need to get into the weeds, as painful as that can be, on some of these actual costs, because these people we're actually going out to a vote, which is going to cost them, could close to come $100,000, and we're asking them to make these decisions, but we need to do our due diligence and make sure that they're getting the information that they need so they can make this knowingly and intelligently, and then we can take it from there. But we need to have those numbers. I appreciate what you did, but I just feel like we need to use
No, you
this.
can tighten
Well,
the numbers.
I think that these numbers are probably a pretty good fidelity. It's like remodeling your home, I'm going to give you an estimate, and then it's going to be 3 times that. And the numbers never go down, they go up.
Well, it's an
based on-
allowance. You have an allowance here for operations.
It's
Whether or
an
not you spend it
estimate.
on testing or you spend it on additional staff, that would be up to you.
And you prioritize your
Capital
expenditures.
is an allowance too. Now, whether or not you need all of that money for capital or not, that would be
But this
subject
is
to
an
debate.
apples to apples type of comparison. You're basically saying if you wanted to get as close as possible to approximate what Suffolk County Water Authority is offering, these are the things that they're offering, so this is what it costs to do it ourselves. You don't have to match it.
No, we can
It
come in
doesn't have to be
somewhere in
apples to
between,
apples.
sure.
You say, okay, we're not going to match it, but we're going to keep it local, and
But even
we're
so-
limited in terms of how much we can spend and burden the local taxpayers.
wouldn't you
So
want actual-
this is some in-between
You're never
proposal.
going to get actual numbers, just like when we do a budget in the beginning of the
The
year.
one thing
We do a
I- you know,
budget for
I
next
just-
year. We get as close as we can.
What do you base those numbers on? What do you base those numbers
On
that you-
projections.
On projections, based on what? Your experience, and your budgeting and the prior year's budget and what you've seen over time,
No,
you've
listen.
done your due diligence. We need to do our due diligence in terms of contracting out these services, lab results, testing, some combination of both, maybe some combination of that, maybe with some combination of
Yeah.
different staffing structure, whatever it is. We just need
We
to
can
look at
tighten
it
up the
all.
Well,
budget.
that's what we're doing right
We
now.
Well, that's why, like
No,
I
we're
said,
not.
well, for instance.
Yeah, we
there's
are,
$300,000.
Christine,
No,
because
we're
we
not,
just
though.
started looking at
$300,000
these
for
numbers.
staff. I know if you add 2 staff members, 300,000 is a little, is probably a little on the low side.
What if you switched around staff or the way it was structured?
You mean not add staff?
Change, or not add
Staff
staff,
member-
not add
Any
staff.
decent not any decent, any level of a professional person is going to cost you 100,000 gross salary plus benefits, and it's 150,000. Is it 160 maybe? Is it 140 maybe?
Some people are retiring though too, right? So we have
No, I
things to talk about,
understand that. I
right?
understand that.
There
So
are
you,
things to
so,
talk
Also
about.
talking about adding not just replacement staff, you're
Right.
adding staff with different qualifications.
Correct.
So if you replace a laborer or an installer with a chemist or an engineer or a hydrologist,
Mm-hmm.
there's a benefit, but it's not a wash.
You still,
Right.
you
No,
still
I
might,
understand
you
that.
still might need to
And there might be some-
backfill that laborer position.
And there's
Somebody's
some-
got to fix the water main, it might not be the chemist.
What I'm saying
Right.
is that, what I'm attempting to describe here is the level of detail is obviously important. There's no question about that, but there's also a level of unknown that you're never going to get the I's dotted and T's crossed on every level. And I think it's fair, having spent a lot of time talking with the engineers at Suffolk County Water Authority to get these numbers, that however you feel about Suffolk County Water Authority, they have some expertise in this area. And when they give me a number, for example, I'm talking with them right now about the water main installations in the East Quad community. What would it cost to connect homes to street? They give me a number. And their experience,
They're going to do the work, right? Or
No.
not necessarily, but they know what it takes to get the work done, and they know the fair market value of those prices in order to get the work done. So I'm relying on that for our own RFP. That's a reliable source of information. There's sometime, not here in this discussion, but in other places, that when Suffolk County Water Authority makes an estimate of a cost, it's somehow jaundiced or inflated in some way that's to the advantage of the water authority and not the advantage of the town or the community. And I'm not passing judgment, but my experience has been just the opposite.
I'm not saying that. I'm
No,
not saying
I'm not suggesting that you are, but we prepared this document, of course, to share it with the town board, but it's to help begin to address questions that come from the community. So it has a level of generality and scope to it that is not enough to make a decision, but enough hopefully to get people who have questions to feel we're getting better informed. We're not completely
And we can
informed,
tighten the numbers.
we're
My
getting
fear is
better.
that the actual cost will be
That's the
higher.
objective.
And to know what we
And there's
don't
nothing
know.
here for water mains, which is, I'm concerned about too. But I did want to hear from Christine too, who, you said several times, you think that some of these
Yeah,
projects
iron
could
and
be
manganese.
CPF.
Yep, iron and manganese
Nope.
removal may,
No, it may not.
because you're saying that it's not
Iron-
now a listed contaminant?
That's right,
Right.
they're not on that list.
We've been hearing all about how the new levels are coming out, these new
Not
regulations.
for
and they're
iron and
seeking-
manganese. They
but
are
they're
not
seeking-
listed in those,
I understand
the
that they're
law is
not.
very specific to certain compounds.
I understand that. but
Iron
we're
and manganese
talking-
is not on the list.
Okay, understood.
so the recoding of the tanks, I mean, that's like an
Well,
operation.
let's just go there.
That's a
You
capital
can't do that with
project.
CPF.
That's a capital project.
The next one, recoding tank 3, it cannot be CPF. Replace water meters, not CPF. Suffolk County Water Authority tie-ins, not
I'm not
CPF.
sure. I'm not sure.
How could that
No,
possibly be
those are the
CPF?
tie-ins,
Those
so
are water
understand this,
main
please. Those are the
That's the
tie-ins from the
pressure.
east connecting to a non-service district and then going continuing west. Those are the tie-ins.
And the water main on Dune Road.
The CPF,
And that's a
right.
tie-in for the same
The
district.
CPF,
tie-in.
We had applied
CPF
for-
law, and we just went through
And
this.
we have
is-
grants also.
These aren't service lines.
Right,
These
these
are
are
big
all-
water mains.
The CPF law, when it comes to these water district type improvements, is so narrow. You can extend water mains to areas that have, served by private wells that have this contamination and do the connections.
I understand
You
that.
can't even just replace a water main in an area. It's a
Understood.
new water main.
I know what the law says.
Okay, so
Right.
then let's go
And all
through
I've been
this.
hearing from several on this board is that the new regulations are coming out, things that were not deemed regulated before, they're going to look to regulate them now, things that also have a HAL or whatever it is, that's going to get lower, it's going to become more stringent. So these things may may be coverable, and that's the point. And if
You
there's
say
things
that, but
I don't understand the
believe
purpose,
that.
because the percentage of
So
that coverage
that's why I
is
said,
pretty
want to go through it.
minuscule.
Building a building
Compared to
over the
$14
filters
million.
is
First
not
of all-
coverable.
Okay.
Adding a check valve to booster zone for backup, not coverable. New generator, not coverable. New generator, plant 3, not coverable. Reconditioning well number 1, you cannot use CPF. Install water main on Dune Road, you cannot use CPF. There's nothing on this list, and I think by saying you can use CPF for it, I think you're giving a false
I already
impression
said,
that somehow
do
the
not
residents
res-
might not have to pay for this.
Do not put words in my mouth. I very clearly said, it may. And it may, and I stand by that until I've done my research, and then if it's not, it's not. But the point is, we should be looking for that. We should also be looking for other grants, and the main point is that this $14 million price tag may come down, or may be able to come
There may
down
be other
based on those
grants.
things.
It may go up.
I'm
And it may go
confident
up
in saying that
significantly.
CPF cannot be used for anything on this list.
Okay.
And it may
You've
go
made
up
your point, as have
significantly.
I.
No, this is important, because if we're
I wasn't
talking to
looking
you. I
at
wasn't
this,
talking
You can
and
also
I am
choose
talking as a member of this board right now, and that number may go up.
Yep.
I mean, these are Suffolk County Water Authority numbers. They do 5 of these a year, so they get lower numbers. It's quantity of scale. So,
It's also
these are
prevailing wage.
generalized numbers that we need to make projections, to go to the Hampton Bays community and tell them that their water prices are definitely going to be going up if we keep this water district the way it is, and they should know that.
I agree
And
with
whether it's 3/4, I'm not trying to make you wrong or anything, but I think it's important, whether it's 3/4, it may go down to 2/3, it may go to half, but it's going to be a significant increase, and that's important. And we may be able to get some grants from the states, Community Preservation Fund,
No.
that would have to be voted on by this board.
Yes, it would. And I agree with you
We'll have to
that,
qualify first. and it won't
And it would have
qualify.
to go up.
I agree with you that getting the information to the public is paramount, and they should know if their bills are going to be going up
I
or
wouldn't want to give
down.
them false hope that CPF
Absolutely
is going
not.
to come in and...
Gonna say-
Which is why I said may. I think the public understands the use of that word. But they should also understand when I hear things like a 70% increase, and I said at the time also, it may be right. But the point is, I'm not sure. And for people in this district, they feel very passionately about the district, separate and apart from the fact that we all know that we have to do better in terms of water quality protocols, what we're testing for. Everybody wants to be better at that. But that means a lot to them. And there might be a threshold at which, you know what, I'm willing to pay a little bit more to keep it. No, I'm not really willing to pay that much more. And I think it's incumbent upon us to do our due diligence, and I'm happy that we're starting here, and these numbers are all great. I just want to be sure that I did my due diligence in getting all the particular numbers so we can give them as close an approximation as we can to what they're going to be making a decision on, because they're going to be living with it.
Well, don't
Yeah, we
imply that
understand that.
that the rest of the members of this board don't want to do the same thing, Christine. I mean, yeah,
Why are you
I
being
take a
defensive?
little offense at that, because
Why?
this is the process that we're going through right now. We asked our controller to come up with the numbers based on research that our deputy supervisor has done as a point of departure for us.
Right.
So that we can start looking exactly at that.
So then what's
Whether
the
it goes to 68% or 92%, we all agree we don't
Well,
know
what's
that.
the problem then?
Well, because you're making this statement as if somehow CPF is going to save everything.
That's not what I said.
And that you're the only one that's going to do
That's
due
not what I
diligence.
said.
Well, that's how I read it.
Well, that's
And
unfortunate
I
that you
find
read
it
it that way,
offensive.
but I think that the public understands the word may, and I think they're entitled to that information.
I just want
And
to
they
get
take it-
through
taking
this,
it
hear the
personally is a
numbers, and
little
get to
strange.
I
the
think
end and
that,
understand what it
I
is
think the
you're
word
presenting.
may presents a false hope. There is nothing on this list.
Okay.
And I say this with confidence that will qualify for CPF funding.
And you may be right. I want it looked into.
You know the law as well as I. It's for water main extensions into areas that have contamination as listed, under the state regulated substances, and in areas that don't have water mains, and for the hookups to the residents. That's it.
And when the
That's all you
regulations
can
come
do
out,
with
when
that
the
portion of it.
regulations come out that make manganese a regulated chemical or change the HAL or something like that, are you telling me that then it would qualify for contamination, but it would not be allowed to be
It
used?
may qualify for other
That-
things.
right,
You would have to
right. May,
change
it
the
may.
CPF
Oh,
program.
my God.
All right, well, I think we can go through these and just say that, as a minimum, this is kind of where we're starting off, as a capital. Again, when I started off by saying, would you spend 14.6? You may not. you may spend 10 million. You may spend 8 million, and you might put off some. I mean, that's how we do budgeting.
And that's
We
why we
don't-
have to
Right.
prioritize.
You don't
these
budget,
as well.
you don't budget, we have 50 million of needs. Do we
Right.
put-
And that's how
we
you
don't put that
project,
in a budget
that's how
every
you
year.
project
Correct.
engineering
But
projects.
we think we can afford.
Yes.
And we are
And we weigh
faced,
that versus our needs, and then you guys make a decision. And you'll have to make the decision throughout this budget process, too. This doesn't go away. You know, we would put these up every, this is like a 2 or 3 year plan that you would have to borrow money and go and invest money in this district. So you would have those options. So for me to like fine tune a number, whether or not $500,000 is the right number today, you might not be installing it for 3 years. I can give you a number today, it could be totally wrong.
I wasn't really talking about the capital costs. I was talking
Okay.
about maybe cutting some of the capital costs with potentially, or maybe, other funding sources.
If you had
that
other
put
funding
up.
sources, but
I
this
was
is what you
talking
need
about
to
the con-
spend.
right, I
How
was
the
talking-
money comes in to pay for it is another story.
I was talking about I was honing in on the contracted for services. Those are the kind
Okay,
of
but
things I was saying.
so let's
That's
get
what-
past the.
I think
Christine, that's my point. First, you have to define what it is. That's what we're sitting here for, and then we keep jumping ahead for looking at funding sources, but we have to define what the problem is. That's the first step.
So we kind of have
Due
this
diligence.
placeholder that we need. We need 14 million in investment in the district over the next few years. Whether or not it's 2 years, 3 years, 5 years, the next few years, you're going to need some
Can I
significant.
just say, because I think it's important to note that, Suffolk County Water Authority committed to this $14 million investment. And we asked the question, so what if you get grants? Are you going to then, give us less? And they said, no, that's the commitment. It's a dollar commitment. So they're going to commit to spending this much on the water district. Maybe more, because,
Well,
but this is the minimum.
commitment
That's
is
the
to
minimum
operate
commitment.
the system. Whether, if water mains break, they're going to come in and fix them.
Right.
That's just what they're.
Exactly.
That's the unknown that.
But this was a minimum
We're kind of the
commitment.
guarantor, whether or not we want to, give that risk to somebody else or keep it ourselves, that's our own issue.
So
So
in
in
other
terms
words,
of
if
the
some of the
operating
things
costs.
come in at a different cost, it still was a minimum commitment of $14 million. So they can use it for other things.
Well, that
So
was their
that's a-
schedule. Again, we didn't have an engineer come
just
in
trying to compare
and do our
proposals.
review, which I hope we will
Indeed.
commission and have a high level. It doesn't have to get into the exact methodology of the piping, but it can give us an overview of what we can expect to spend,
Good.
So I think that that's something we can decide, and if the engineers come in next week, we can have a conversation about it after that.
Our engineers could estimate, could look at all these numbers, and do their own estimations.
No, they might say, yeah, that looks pretty good, just from the,
Yeah, or not.
whatever. So on the operating cost, again, what we talked about is additional water testing. We did basic levels of water testing, and we weren't testing for emerging contaminants and a whole bunch of these new things. We would have to contract with a lab to do this, and I
Right.
don't even know who we would contract with, but, did we come up with a number? Yeah, we came up with $250,000. I don't know.
Is Suffolk County the only game in town that does this? We don't know, right?
Well, the state health department does these types of
Right.
testing, but, the turnaround time, the problem with this stuff is the turnaround time, right?
Right.
If I do a test today and I send it up to the state lab, I don't get it back for 3 to 4, 6 weeks, maybe, by that time, we're drinking water that's 6 weeks old, sometimes you need this stuff rather quickly.
Would we put proposals out for each of these things, or would you feel
Absolutely,
like-
you would not, we wouldn't
wouldn't
be,
know.
we would
Sure.
be putting RFPs on the street, we'd be putting bid documents out on the street,
You could pull some of this
Can we-
possibly off of the state contract. Right, because we know Pace
I don't
Analytical,
know.
we looked at Pace Analytical, they had a table in terms of if we
It
wanted
was
to get
expensive. When
them
we were gonna test some of these wells in,
for
West
PFAS.
Hampton, for people, they were like $600 a pop for each little individual well
That's
test,
a private well.
a private well. So now you start multiplying it by all of our wellheads all the time and testing it like once a week or every other week. Suffolk County Water does it every other week.
Well, I would think you would have an extended contract if, in the
So
aggregate.
probably
if
you'd
it was
have,
like-
you'd have some benefits
Yeah.
of scale, but
Right.
again, it's every other week and you're doing all our wellheads and we're testing numerous amounts. So 250,000 gets spent pretty quickly.
Right,
You-
so
you're
we could
talking
tighten
about a
that number
contract.
too, and actually get a price of matching.
That's all I'm
The
asking.
technology
That's
cost,
numbers.
when I throw out a number out there for technology cost, if we were to do the capital improvement plan, a lot of this stuff talks about modernizing the equipment with computerized operations. We don't have that technology now in place in the central office, and then you have ongoing maintenance of all of these systems, computer systems. So we know, as a general rule, that these maintenance cost between 10 and 20% of whatever the software technology costs are. So we just threw out a number, well, it's gonna be about $50,000. So that's not gonna be out of the realm, that's pretty close, if not low. when we talk about what the ongoing maintenance of the systems are going to cost. Okay, as far as the technical support, again, that's 2 full-time positions. Whether or not we want 2 additional positions or not, we can debate that. From our review, we thought that there was a need for an in-house engineer and some additional managerial type position. What that was, would be, we can discuss.
I mean, you
So
could
that's what that
contract-
is. That's the 2 higher level positions to cover that. And so 300 is actually on the low side, I feel, if they were truly a,
But you don't-
Standalone, yeah, but if you were
But
doing
you
other
don't
things, it
necessarily
may
have
not
to
be.
hire somebody, you could contract out
Contract.
professional
oh,
services.
sure, I guess you can hire somebody, but
You could have a chemist on retainer who can come in once a week and go over things and meet with the staff and make sure that.
that's going to be, usually that's $200, $300 an hour. I mean, you know,
Yeah,
that's
I'm
not.
not sure if
not-
it's, yeah.
that's
but-
not something that's going to be.
But then you don't have to carry the benefit costs.
So then we talked about other equipment modernization within the district on a regular, ongoing basis, like there's an annual thing. So there's like a capital component, and then there's, more of a regular recurring thing. So we put a $50,000 price tag on that, where again, there's not a lot of money given the size of the district. And then we
That
put in
could be for
$170,000 for administrative and legal support. We have not, when we've looked at our numbers, and I actually did a survey of a lot of the other towns, all of their districts and sub-districts, they allocate a percentage of their general administrative costs to the special districts. We don't do that. We haven't done that in the town.
Right.
So we were looking at it and we're saying, well, they're getting a lot of those services right now that should be borne by the district, but it's really being paid for by whole town. Everybody is.
Right.
Like the town board, the controller, the town attorney, all of those services.
IT,
And the debt
legal.
service.
And it's not being.
And also Suffolk County Water Authority proposal, they would be availing us of all those expenses, right?
Yeah,
They
well,
would take care of all the
Our
administrative.
general insurance, all of that stuff that's not being charged into the district per se, is not being charged to the district. So it's being borne by all of the residents of Southampton. So it's something that,
So that's a new charge you're thinking about, you're doing that across the board with
Well,
the
I
special
would-
districts?
it would only be the special districts that have staff, that have, because staff is really, you get into additional costs. I'm not thinking about special districts where it's just a one-time thing with an outside contractor, because they don't really draw resources from us.
No, but we use, your office.
Like, yeah, well, but it's a conversation, and it's something that we have to have during the budget time, because this is certainly a budget item.
But right now, it's not
It's a
operating,
number
but
that I'm
it's
just
okay.
throwing out
Okay.
there.
But
It's
this
not
is
in
to
there.
inform us, to make help us make an informed decision.
Correct.
That's the purpose of this.
So that's what that
And if you did go to,
170,000.
if the public, if there was a vote and they chose Suffolk County Water Authority, the town would have basically that savings, right? Because we wouldn't have the legal and the IT, we wouldn't have to provide that backbone.
No, we theoretically, everybody's workload would lighten up a little bit. For everything that we do for the water district, we would not have to do.
Because the water authority would be covering that cost that right now.
Our billing functions,
is
we wouldn't
being-
have to do. Our infrastructure with the files maintenance, in order to put the bills out every quarter, would not have to be done. We'd not have to put it on tax bills, all of that stuff would go away. It's hard to quantify, is that a full-time job here? It's not, because it's a little bit of somebody's job, a little bit of somebody's job. It's a little bit of everybody's job, and, but if you don't have to do it, then you have time to do something else.
Now, in fairness, there might be some things the water district is doing that if you went to Suffolk County Water Authority, we will have to start paying for.
Oh, yeah.
Like I think they're plowing the police station in a snowstorm, or something like that. There's some things that they're doing, so we'd have to
Yeah, we've
do an
invested,
adjustment there.
and we've invested in parks infrastructure to allow for them to pick up the slack on any town
Okay,
buildings.
but there's a cost associated with it.
Well, we didn't talk about all of that as well,
Right.
because there's infrastructure within the existing system that would not necessarily be distributed to if we went to the water authority as well. There's trucks, well, no, I'm trying to say, here, if we were to go to the water authority, right now, we have a whole bunch of stuff. We have a barn, we got trucks, we got equipment, we got, all of that stuff, they're not gonna take it. So they would probably take our parts, like the raw materials, the valves and stuff like that. But the trucks and stuff that's fungible, we would move them into parks, we'd move them into highway, we'd move them wherever they would be
But they're
necessary.
owned by the water district, so we'd have to do a
We'd have to do a
chargeback.
chargeback, yeah, absolutely.
We would purchase those, and
Yeah, well, we would move the equipment around
the
at their
money would go
depreciated
into the
values.
Hampton Bays Water District.
At whatever their depreciated values are, we wouldn't, we're not gonna pay.
That could help lower taxes in the water
Right.
district.
We're not going to pay full value for a truck if it's 10 years old, so we would calculate the values, and then that's what we.
Can we get like an inventory of what those
Yeah, we
would be
have
and
it.
what we
Yeah,
would
well,
offset?
We
We have that, yeah, that's, we have a detailed.
You
list.
So we
provided
can
that
see
to
what
us.
we
Also
cost.
depends
I
on
want to know what it would
that the
offset.
Again, this exercise,
assets will defray costs associated with other assets that are in need
Right.
of redevelopment and replacement. The highway barn, the parks maintenance building, the justice court. Not that the water district could be used for that, but because it's in relatively good condition and a reasonably useful asset, it not only will save water district customers funding, but it will defray the costs associated with other capital improvements which are staring the town in the face almost
so
immediately.
again, option 2 is basically saying, if we were trying to replicate what Suffolk County Water Authority is offering in their proposal, as close as possible, what would it cost? I'm not saying we have to do that. We can come close to it or come halfway there.
Yeah, so I'm on the last page.
So, but that's what this is, and just to try to be as fair with the numbers as possible. We just want to be fair with the numbers. And if the
So,
numbers
yeah.
are off, we can tighten them.
So I think that what, the amount of increase on option 2, in terms of if we do the upgrades and we do the capital improvements, maybe not all, maybe it's not a 72% increase, and like Tommy John said, maybe it's 60%, maybe it's 50%, but it's more than it is today.
Or
We
maybe
all can
it's-
agree on that.
Or maybe it's 78%.
Or maybe it's all 100%. We don't know. You're right, but it's more than it is today. So what this tries to do is say, well, if you took the bill of goods that we gave you here, and we accepted that as is, it would cost $706 for the average customer, a 72% increase in their annual bill versus option 1 or option 3, which option 3 is going to the Water Authority. It may be 50%. So if it's 50%, the average bill may be $600 instead of $706, okay? So, yeah, I mean, and obviously, as us operating government, if we went down option 2, that's part of my job and everybody's job is to minimize costs. That's what we're going to do. If you say we're going to option 2, I'm not just going to take these numbers for granted. We're going to go out and bid, and we're going to negotiate, and we're going to bargain, and we're going to do everything we do all day, every day.
Maybe there's a hybrid even between option 2 and option 3. I mean,
There
I
could be.
think we should be exploring all that.
Maybe we hire the Water Authority to do our testing in option 2. They might be the testing source, if they can contract with us, and they might be our lab. And I don't know what they would charge for that, but maybe they're less than 250, maybe they're 200,000,
Or
100.
maybe we don't
But option 1,
modernize everything.
option 1 over time ends up costing us a lot more in reality.
And I don't think you can do option
No,
1.
no.
So I'm saying I don't think option 1 is an option.
Right, no. Nobody wants brown water,
Right.
nobody that's.
I guess what
That's
some
what I'm
people are
saying, so
suggesting that there might be something in between option 2 and 3, where we don't necessarily match everything that the Water Authority is providing. We match some things, maybe we don't modernize, maybe we don't put electronic meters, or, you know.
Wireless meters.
We don't borrow quite as much, and not raise the price as much either. So that's a possibility. What your exercise was to try to match, right? To not develop a two-way.
Well, because if I was a resident and I was going to vote, if I was going to make a decision in myself, well, I need to know what are my choices. Well, my choices right now are, I can't just stay where I am. What my bill is today is not an option. That's what we're saying, that's not an option. So my bill is today is, well, am I willing to pay $200 or $300 extra a year for us to maintain local control of the water district? Or if I go to Suffolk County Water Authority, my bill roughly will be about the same? And that's really what it comes down to. And why does it cost us so much more? Well, we don't have the economies of scale that the Water Authority have. We don't have the ability to spread our capital infrastructure over a lot of ratepayers. We don't have an existing lab, we don't have the ability to redirect staff in an emergency, so we have to have our own staff in that emergency, right? So you don't have, so yeah, the Water Authority does have a huge amount of staff, but the amount dedicated out here are maybe not as much, but they can redirect staff from other areas of the island in a moment's notice to address any issue that has to take place.
And
That's what happens when you have a
They
big
already have
system.
the chemists and the hydrologists on staff, they don't have to add
They
something.
don't have to have it. So those are where you see a lot of the savings. But again,
Did you,
that's what.
the one slide you sort of skipped was option 3, pros and cons.
Oh, okay, so let's go back.
So this would be with the Suffolk County Water Authority.
Okay. Well, yeah, so, again, I thought I kind of just
You
said
did,
that.
you did.
But the rates and the tax is basically going to remain stable because you folks set the rates, and you folks, we have a current rate. So the current revenue stream that we get in from both our current billing level and our tax revenue is enough to pay Suffolk County Water Authority their bill. So that would be sufficient enough to do that. We gain the in-house technical and professional staff. Obviously, that's everything that they talked about. They brought together the whole gamut of people to the table, professional staff. We don't have that. They will implement their infrastructure, and they'll provide for all the management of that. You know, what I didn't talk about, I might want to say that, you know, if we entertain this kind of capital investment, Christine Fenton can't, like, supervise all of these jobs. That's a huge thing to do that kind of capital work. You need monitors, you need professional staff. You need, like, you know, whenever we do a capital project of like over 500,000, we usually hire an engineer to be the construction manager to
Didn't
watch
we have
it.
a clerk of the works or something in this new budget that you was
In the
just
general
announcing?
fund, but
Right.
that's handling all the general fund projects. There wasn't anticipating another 14 million.
This is a huge project.
So if you were to implement these things, you need construction management to do all of those things. We didn't price that in here. That's not part of this. Somebody,
This would require a team of engineers, not just.
yeah, I mean, you just don't,
coordinators.
right, you're not just gonna have a vendor reline a tank. You're gonna inspect to make sure he's doing it right.
You
And
also
you're-
hope that that's what the water district employee does, at least one of them.
I don't think that they would have the expertise to
Right,
do
and
that.
if you.
If we
brought in-
hired somebody,
Yes.
That's what
yes.
H2M is supposed to do for us,
Right.
aren't they? They're
They're-
consultants.
Well, we would
and
have to
somebody
hire
gets
them for
hired.
construction management.
That
This-
would
they
be the
would-
combination.
This is different,
we would need to bring them in
That's
to
not even
monitor these
factored in.
construction. That's another cost that's not on these schedules.
because one of the
factored
biggest
in advance.
efficiencies in a
Now, can you-
project like this, one of the biggest efficiencies is knowing when to do things in the proper order and proper sequence. And you can really spend a lot of money making those kinds of mistakes. And you need somebody who knows what they're doing to do that. And that requires an analysis of the system, so you know how to proceed from that point to save a lot of money. And that involves tearing up a street at the wrong time, or having, you know, there's just a whole bunch of moving parts there. It's scheduled over a period of years. Me, in my head, I see this as 3 to 5 years.
Councilman Bouvier, you said saving a lot of money. I look at it as staying within the budget that we allot. If we make the mistakes, or if the
I
mistake,
agree
if
with
it's not done properly, then these budgets are higher.
Yep,
So.
I agree.
So, but there are obviously a lot of questions that need more precise answers to them, there's no question about that. But one point that wasn't emphasized, it's in the slide here, is that if the board decides at some point, in whatever mechanism they choose to enter into an agreement with Suffolk County Water Authority, it's not an agreement forever. You enter into a 2-year contract or a 3-year contract, and if they're not delivering what you expect them to deliver at the cost you expect it to be delivered, you have the option in that proposed contract to withdraw from that arrangement. So you're not selling your soul to the devil, so to speak, in that regard. There is a fail-safe built into the mechanism. That doesn't diminish the value of doing the level of due diligence that the board is
Right.
asking for, but it's
If we
not,
exit, we
you don't
have-
close the door behind you that you cannot reopen again.
reopen.
That's
But
important to
there's a
remember.
cost to that as well as reopening.
No question
You have to
about
pay
it,
the bill.
but any insurance policy comes with a cost. And you may never use that insurance policy, but you make a decision that it's worth the
You know,
cost.
if in year one they invest $5 million in our system, and then we tell them to go buy, they want their $5 million back. They're not just gonna take,
Yeah.
you know,
Right,
it's just
but
not
then
gonna
you're,
happen.
so then option 3 becomes option 2, as if we had invested it in ourselves,
Yeah,
Yeah.
modernizing the system.
So, and the debt service on this is somewhere upwards of $6 million over, at least that's what I'm
That's
reading out,
first three.
right? That's for the.
yeah, these are long-term bonds, because
Yeah.
they're.
But that's only
That's-
based on what the number is that we have now.
20-year bonds on these things.
So
I don't-
in the interest of doing the due
Debt
diligence,
service?
this number is going to change and go,
That's a 2019.
yeah.
2,000, that's.
Oh, if we go to the total amount on the
Right.
last column, 14.6, at the end, after debt, after the total bonds are paid off, it would cost 19,696. I mean, that's 20 years into
Oh,
the
so
future.
yeah, so it's like there's a $5 million interest.
Interest cost.
Yeah, that's-
Over
yeah.
20
Interest
years.
cost, not debt service.
Oh, I'm sorry, but I said, I apologize.
The total
The
amount of
total
interest
interest,
cost
right.
over the life, but you would have that. I mean, that's part of.
It's a low interest.
Part of what we
So the purpose.
And that's assuming that this all stays copacetic rate-wise.
Whether we borrow it or
We
Suffolk County
assume,
Water
we made
Authority
assumptions
borrows
on
it.
the current
Yeah,
rate.
so I'm just,
Yeah.
we're trying to talk so the public can
No, we
understand.
made some assumptions on the current bond rates. If they go down, it's less. If they go up, it's more.
And if Suffolk County Water Authority borrows the money to do the infrastructure, they're gonna have to pay the interest.
Yeah, but their amortization's over 1.2 million people.
But it also works in the reverse. If they do a job in Babylon or somewhere else, it's going to get spread out over everybody too.
Yeah, which most ratepayers in the town of Southampton already.
Right,
I'm not arguing, I'm
Their
just,
rate is.
No, I'm not arguing either,
factors-
I'm just trying to state
factors that.
facts, Christine.
But
So-
there is a concern that
Or-
new regulations are coming down on some of, that may require more filtration, more costs, and
Part of what
significantly more.
Part of what we're trying to do is, you folks have a decision to make, right? Do we put this thing out to vote? Do we not put it out to vote? What are we putting out to vote? So in order to vote, people have to know, what are they voting on? If I go to this, I think it's pretty clear the Suffolk County Water Authority contract, right? That's going to be,
it's the other.
that's the black and white
Right,
contract. We're
right.
going to have a contract, it's going to
There
have
it is.
terms, conditions, it's
Right.
pretty kind of a clear
Yep,
document.
Yep.
It's this, and whether or not it's some variation of this or not, I feel pretty comfortable. These are the gross numbers, whether or not we want to move around some of the pieces. I think overall, this allows us to upgrade in a way that we'll be able to run the district. And,
Well, and match their level of service.
yeah. And whether or not we spend 250,000 on testing or 100,000 on testing, that leaves me 150 in the bank. Bear in mind that that money, if it goes into the bank, will ultimately just goes back to these residents. I mean, it doesn't, like, you don't borrow it if we don't need it. We don't spend it if we don't need it. They are the beneficiaries of it. So, but are we talking about a magnitude error of 100%? No. Maybe 10%? Sure. That's what I'm thinking, 10% plus or minus. But that, and that's on our best day if we can get it down by 10%. It's very easily to go over by a lot, too. So,
So the question is, the purpose of this was to begin to bring some level of detail to the principal questions that are asked by the community. Where would you like this information to go next? The usual protocol that the board feels when we do a presentation like this, we'll put it on the town's website and make it available to people. And then any subsequent presentations, the data becomes part of that. We haven't done that yet. The board's just seeing it for the first time today. So how would you like to see the information disseminated after today's conversation? Would you like it to be on the website and made available to people to review? Or
I think if
Something
if it's as a report from the controller's office, I think that's fine to put on the website as that.
yeah, that's what it is.
Okay.
It's
And
our
I-
estimate.
And not to debate, Councilwoman Scalera, and I'm debating with you, not arguing. I'm going to support your point to look at the details of this and money-wise. So I'd like just a little opportunity to just go through the lines that you have there and just validate them for my purposes and see if I can break that down a little better so I have a greater sense of confidence that the numbers are real.
All right, we're really focusing on the operating. We kind of taking the water authority's analysis as a good starting point, and we really want to talk about what's our ongoing operating. What would we need for additional operating?
how do you suggest we proceed with discussions about perhaps a combination of things, just so we can go through, operating structure, potential partial contracting out for things, like how should we go through that process? Because I think that's important.
That interim proposal, I mean, the intermediary, if the.
We would, I guess, we'd have to check with the water, like, say if we wanted the water authority to do testing, water testing. We'd have to see if they were able to do that for us. I don't know if they can do that within their charter, if they can be a
Or if somebody
private.
else will do it, like how do we find out if they're the only game in town, if there's somebody else, or if we can go off the state contract?
Well, we
and
can,
they speed service
we
up.
can start to do some research in my office.
I think that we would have to
Christine, there may be-
say,
There may be an intermediate step to, if I understood your question, that you need to first look at this list of proposed capital improvements and have a conversation, I would suggest, both with the Suffolk County Water Authority and maybe H2M or someone else of the board's choosing, and decide what comes to your mind as this is a priority over that. The board needs to be comfortable, maybe everything needs to be done, but board members have different degrees of expertise. Julie asked the question earlier, what are our priorities? Before you can say, I want this contracted or I want this done by Suffolk, you don't know what this is. So I would say the conversation to establish among the proposed $14 million worth of capital improvements, what do we think is the priority among those? And then look at comparative costs for those priorities.
Is it unrealistic to, I mean, in my view, and maybe I'm wrong, and you tell me, I'm looking at that 14 million as, those are the things that need to get done. Whether you prioritize it this year, next year, these things are gonna need to get done during the life expectancy of whatever district or whoever's handling it. This is at the minimum. This is what needs to get done. So I think we do have to prioritize in terms of that, but I'm just saying in terms of the overall costs of knowing what it's gonna be, I'm more thinking, I'm taking those almost like as a given, as a baseline and a continuum. And the other stuff where we manipulate through, structure, contracting out, consulting, whatever else we do.
We'll try to get some better estimates on the testing. I mean, that's really the only thing that's a variable in that operating. You have to, that's my thing. I'm telling you, you need 2 staff. You can tell, we have this every year when we do a budget. How much staff does the town attorney's office need? How much staff does the engineering? We have that conversation all the time. I'm saying, in this area, you're gonna need 2 staff members. That's open to debate, but I don't think that it's high and I don't think it's low.
But we also have people leaving, so there are
But I
things
think you need
that-
them to be backfilled. I think all of that needs
Maybe,
to
maybe
take
not,
place.
maybe different. Like, you don't know. That's
I
the discussion
think
we need to have.
And your point's valid.
I'm asking a
but-
question, though.
But, and I don't think he can answer it. I think that's part of, that's not an answerable question at this point.
We're budgeting
Asking what we
300,
should-
we're right.
Asking what the next step is to do this. How do we?
Well,
find out
I
this
think what we
information?
said before is, next week we're having the consulting engineer come in. So we're gonna let him give them their analysis of where they see the system. And I think at that time, they should be prepared to look
Tell
at
us what
this
it's gonna cost.
list and say, do you agree with this list? Right? So we can kind of confirm this list from a from a firm that we've been hiring for the last 20 years.
To include the cost estimate.
Yeah.
Yeah.
Can you confirm, so that we're talking in the same pew, that what they're throwing out there are kind of things that we have to do? And if they agree, I think then that's a closed book. Now we say, that's what we need, now we just have to, now that becomes the number, and now we just want to talk about the operations, and that's a little bit more,
Was the bulk of the increased cost the capital, or?
well, at least half.
Yeah, no, the capital's
Well,
a huge amount of
Yeah,
it.
yeah.
I mean, it's
And then,
like,
we agree that the operating cost then, so once you take half of the increase for the capital off, now you have another half. And of that half, is it a quarter? If we really nitpick, yeah, maybe. So now we're only talking about, again, a 50% increase in the rate, not a 70% increase in the rate.
Right.
That's
Which
what-
to
But
some
we
may
have to
make a
convey
difference.
that
I
to
don't know
the-
that, but it may make a
Well, yeah,
At
difference.
some point, we have to convey that to the public. So if, let's say there is a vote, and yes, if we were going to try to match Suffolk County Water Authority, it would be significant, 700, but we're not going to do that. We know we're not going to double everybody's rates. What is our tolerance? What can the people of Hampton Bays sustain in terms of a rate increase? That's, I think, is the question.
That's
So
what
we
I'm trying to
say-
get to.
Health and
so if
safety
we-
versus-
So if we don't go to Suffolk County Water Authority, what is likely to happen in the water district? What are we likely to do, and how much is that going to cost everybody?
You're saying the same thing in a different way in my mind, Jay, as what I meant by prioritizing. What of those things are absolutely essential to do? And because if the town is going to accept the responsibility of running this district, the town, as you just said, is not going to impose a double-digit increase on the tax rate for the individual. We're going to try to find some logical way to progress towards assuring quality water. And what is that logical progression, and what does each step in that progression entail?
Right.
In terms of capital
Exactly.
infrastructure?
and the danger of that is kicking the can down the road.
Well,
and
the
deferring
court's already
maintenance.
pretty much
Right.
said unanimously
Yeah.
that that's not what you want to do.
No, absolutely
There's
not.
There's
Good.
no option to kick the can down the
Good,
road.
because we currently, I believe, are in a position where maintenance has been deferred, and it is now here. And I'm looking at it.
So I can label this as prepared by the Office of the Town Comptroller, so that that's clearly identified here. And we can put that on the website with no advance publicity. Just put it out there, and we'll let people know that it is available for them to look at. I did have one other question. The online survey is still online. It's receiving little or no attention at this point. We got up to around 500 numbers. I don't think it's serving a useful purpose any longer. We can keep it there if you choose, but I'd like to put this in place of that on the website, because the two things might be confusing to people who go to the website and not know what they're looking for. But if the board wants both on the website, that's fine too.
Good with me.
I don't know, are you still getting online
I
survey?
don't think on the online survey, we've received a response in over 2 weeks, John.
Okay, so that kind of tells me that, yeah.
But Whenever,
Seems like
whenever
that.
you do a poll, it's a snapshot in time. And my concern is if we leave it up, we're taking a snapshot over a long period of time where information is changing out in the public. For instance, on that online poll, most, I think 2/3 or 3/4 of the respondents believe that Suffolk County rates would be higher, right? It would be higher to have Suffolk County Water Authority than Hampton Bays Water District. Your presentation indicates that that's not true, that it might actually be higher to have, the water district with those infrastructure improvements. So when that becomes understood, now you're going to have new people doing the poll with a different understanding of the facts. So Mike's sense is take it down, because
Yeah, I
you're
think
taking a snapshot over too long of a period of time.
I don't disagree,
Yeah,
but I didn't
maybe
want to just
later we'll do a new
willy-nilly do
poll.
that with and then some community member would call one of you folks and say that survey you keep talking about is not online anymore. So I wanted you to know that I'd prefer to. I'd rather take it down, I'd rather ask you first, and I'd rather do it on camera so that we all
When
agree
more of the
that
facts
we're
are
replacing
understood, if we
with
feel
this.
like we need to do a new online
do it.
survey, we could always do that.
And because a lot of the questions we ask are no longer pertinent to the new information that's out in the public. That's
Right, so
exactly
I
right.
would say take it down.
Okay.
All righty, we're good.
Okay.
Thank you.
Thanks.
Thank you.
Okay. All right, so let's go back to updates. I had already made a couple announcements. Again, the police awards tonight. The press conference is tomorrow, 10 a.m. for the commuter train. Couple other quick things. We had Suffolk County Water Authority did come to the Hampton Bay Civic on Monday night and presented. Lynn Arthur also presented the CCA legislation to the Hampton Bay Civic. I think she's been presenting to a bunch of groups. There were questions about Bel Air and the urban renewal, so I answered the best I could those questions. Also, there's a opioid PSAs that will be up on the government channel across the 5 East End towns and possibly News 12. They were filmed recently with Drew Scott and the 5 East End police chiefs, and they may premiere next week at a Suffolk County conference on opioid misuse and abuse, and they were produced pro bono by American Portfolios in Holbrook, and we want to thank them for that. That conference, actually, a Suffolk County conference, is at the Greek Orthodox Church here in Southampton. And I know they've been active on this issue of opioid addiction. So that's all I have at the moment. Any other announcements or updates? Tommy John? You're good, John?
I'm good, thank you.
Christine? Good. Julie? Okay, so we do have some executive session items. Who's got the agenda? So we have acquisitions and personnel matters. And that's it. So I'll make a motion to end our work session, go into executive session on those two matters.
Second.
Second by Council Bouvier, all in favor?
Aye.
Aye.